Good morning. At this time, we would kindly ask that you please take your seats and silence all devices as our program is about to begin. Thank you.
I'm good. We good? Yeah? Yeah? Okay, good morning. My name is Grace O'Hanlon. I'm a program attorney with the Practicing Law Institute. It's my pleasure to welcome you to the SEC Speaks in 2026. We are honored to be able to once again offer this annual program in cooperation with the Securities and Exchange Commission. PLI is a nonprofit learning organization dedicated to keeping attorneys and other professionals at the forefront of knowledge and expertise. Last year, we presented over 500 programs to over 300,000 attendees on a wide variety of legal topics, including approximately 100,000 individuals who attended pro bono programs through our scholarship program and our pro bono membership program for public interest organizations across the country. None of this would be possible without the assistance of our faculty who contribute to and participate on our programs. without compensation or reimbursement. I would like to take a moment now to thank them for their time and efforts, and I would like to give a special thank you to the staff members who assisted in coordination on behalf of their divisions and offices. Tom Carr, Karen Schimp, Tracy Harden, Jeff Berger, Roxanne Romnath, Matthew Jones, Jill Henderson, Melissa Astra, Adam Wendell, Julie Davis, Shanna Wolfson, Michaela De Dernay, John Kavanagh, Anne-Marie Ettinger, Adam Anasich, Elizabeth Nishala, Anna Abramson, Jessica Ansart, Sonia Tarico, Morgan Taylor, Thomas Starr, and Shirley Sorn. Their assistance in coordinating this program has been invaluable, so we thank them. Before we begin, a few administrative details. Those of you joining us via the webcast or watching the program on demand later may notice that our media player has been redesigned with updates to improve your learning experience. You can always access help and FAQs by clicking the support option on the right-hand side of the player, and we welcome your feedback. We would ask that those folks in the room please take a moment right now to check that your phones are turned off or placed in silent mode. Also, if you'd like to have a conversation with other attendees, please make sure to go outside of the room. Conversations conducted in the room are heard in the conference and are disruptive to your fellow attendees. For those attending in person and seeking CLE, please be sure to swipe in and out each day. All certificates will be emailed to you within 1 month of the program date, generally sooner. If you have any questions, please see a PLI representative. Now it's my pleasure to introduce you to the chair of today's program, the Honorable Laura S. Unger. Laura is a former 78th Commissioner of the U.S. Securities and Exchange Commission, where she also served as acting chair during her 4-year tenure. At the SEC, she played a pivotal role focusing on the influence of technology within capital markets and authored the influential 1999 report, Keeping a Pace of Cyberspace. Following her government service, Laura has built an accomplished career as a public company board director. She has served as an independent director and committee chair for organizations including eToro Group, Barracuda RE, MBNA, Merrill Lynch IQ Funds, Ambec Financial Group, CA Technologies, CIT Group, Navient Corporation, and various Nomura Group companies, leading key committees such as nominating and governance, risk, and audit. She has also worked extensively with Children's Hospital over the last 2 decades, including as board member and nominating governance chair. Her most recent awards include the Sandra Day O'Connor Board Excellence Award and Directorship 100. She is a member of the Economic Club of New York. It's my pleasure to turn the program over to Laura at this time.
So good morning, everyone. It's after several years of not being at SEC Speaks, this is a great opportunity to spend the next couple of days with you. So I look forward to that, and thank you for your introduction, Grace. So I have a couple of things I have to say. One is to the members of the press, if you have any questions regarding anything said by SEC staff, please reach out to the Office of Public Affairs, and they will address your questions and get you whatever information you need. The second is a disclaimer, which I haven't given for a number of years, but I'm going to give one now, which none of the comments here are anything other than the opinion or ideas of our own, the people making them, and not any of the other commissioners or staff. I think I mangled that. I guess it has been a while. But in any event, you get the idea. The disclaimer holds. So over the next couple of days, we will have a number of panels from the SEC divisions and offices to talk about various rulemakings, cases, and trends, and hopefully get some incredible insight from the commission and the staff and the commentators. We'll hear from the chairman, Paul Atkins, first, the commissioners, Hester Pierce and Mark Ueida, and then, as I said, the division heads. So it is my honor, distinct honor, to introduce the chair of the SEC, Paul Atkins, who is the first speaker. Paul is a friend and a colleague, despite the fact that I was walking out the door when he was coming in in 2002. So he was sworn in as the 34th chairman of the SEC on April 21st of last year, after being nominated by the president, Donald Trump, and confirmed by the Senate. Before he came back to the SEC, most of you probably know Paul from Potomac Global Partners, which is a firm he founded in 2009 and grew to be a rather large and global firm of experts. He, in the past, and continues to lead the efforts to develop best practices for the digital asset sector. He was an independent director and non-executive chairman of the board of BATS Global Markets. And from 2012 to 2015, Chairman Atkins was an SEC commissioner. Wait, no, he was on the board. I need practice. 2012 to 2015, and he was a commissioner, as I was saying before, when I walked out in 2002 to 2008. Sorry about that. And then in 2009 to 2010, he was appointed as a congressional member of the TARP panel, the Troubled Asset Relief Program. And before that, he was a consultant on securities and investment management matters. And before that, he served on the staff of two chairmen, Richard Breeden and Arthur Levitt. So as you can see, Paul has had his hands in many issues over the years and has served in many different roles at the SEC. We are so happy to have him as the chairman, and he has already done an incredible job in less than 1 year. And he will now come up to the podium to talk about his agenda, what he's done, what he's going to do. And let's welcome Chairman Atkins.
Well, thank you very much, Laura, for that very nice introduction, and it's great to see you all again. It's hard, I have to pinch myself, it's hard to believe that almost a year ago, not quite, I was here at the same podium here talking to SEC Speak. So I'm closing in on my anniversary on 21 April. So anyway, so still lots to do. But so I really thank Laura for taking on this task of spearheading this year's program alongside our hosts at the Practicing Law Institute. I should also like to acknowledge our many participants for being here today, including those who are tuning in virtually. And of course, I must not neglect to thank my fellow speakers from across the Commission for contributing their time and expertise and in order to discuss these issues with you all. The strength of the SEC as an institution has always rested on the dedication of its public servants. And this annual opportunity for SEC staff to speak publicly about their work is an occasion for all of us to recognize the rigor and high purpose that animates it. Finally, before I share a few reflections, let me go ahead and give the normal disclaimer, and this pertains to everybody who will follow me up here on the podium from the SEC, that the views I and the rest of us express here today are our own, and in my case as chairman, and do not necessarily reflect those of the SEC as an institution or of the other commissioners. Now, despite some fits and starts in recent years, SEC Speaks has long occupied a unique place on the Commission's calendar. Over my 3 tours at the SEC, first working for 2 chairmen and then as commissioner in the aughts, I noticed that this audience tends to hang on a speaker's every word. but I would do well to remember the counsel of Bill Casey, who at the very first SEC Speaks program some 54 years ago encouraged future chairmen to realize that the crowd is here to pay tribute not to you nor to your colleagues, and this is a quote, nor to the SEC in general, but as he put it, to the SEC in particular. And so it is today. Over the course of this program, Commission staff will explain in considerable detail the direction of our policy initiatives across every division and several offices. My aim this morning is a bit different. In lieu of previewing each of those efforts individually, I'd like to step back and then offer a framework of how they all fit together as a cohesive whole, so that as you hear from our speakers, you understand not only the substance of the SEC's priorities, but also the shared principles behind them. Now, with a robust pipeline of rulemaking set for the year ahead, I think it's instructive first to contextualize them in the years that they follow. A period in which our regulatory framework too often struggled to keep up with a market that it oversees. As just one example of the gulf between regulation and reality, our rules still default to paper delivery for shareholder communications. In an age of algorithmic trading and artificial intelligence, I believe that requirement ought to be a relic and not a standard. In fact, not long after the first SEC Speaks in the 70s, the late SEC Commissioner Roberta Carmel observed that, and I quote her here, "Data analyzing technology has progressed to a point of magnitude superior to that available just a few brief years ago." Commissioner Carmel added, around the advent of the word processor, mind you, that, quote again, "Although these developments have augmented the complexity and efficiency of the private financial sector, the SEC has not enjoyed all the benefits of this improved technology," unquote. Her words were at once a warning and an enduring appeal for financial regulators to do a better job at keeping pace. We are resolved to answer that call by refusing to remain tethered to the tools or temperament of a bygone era. Second, and on that note, a refusal to update the SEC's rules paired with a misguided regulation by enforcement campaign has killed many would-be products or driven them offshore. When innovators cannot discern fit-for-purpose rules, or when they face the prospect of a subpoena as the response to good faith efforts to comply, the rational response is to build elsewhere. And they did. An entire generation of digital asset innovation developed outside the United States, not because American entrepreneurs lacked the ambition or American investors lacked the appetite, but because American regulators lacked the will. Third, decades of accretive rulemaking have compounded into a compliance labyrinth so elaborate that it sustains entire industries whose sole function is to help public companies to navigate the SEC's complex regulatory framework. When the cost of accessing America's capital markets includes retaining specialists to decode the SEC's regulatory regime to produce disclosure that only an academic would appreciate, then something is very clearly and deeply amiss. Our goal should be to increase the cost of fraud and manipulation, not the cost of compliance itself. So against that backdrop, every initiative towards which the SEC is working and every rule that we propose, every interpretation that we release, and every institutional reform that we undertake largely falls into one of three categories. Those that advance our rules to align with how markets operate today. Those that clarify our regulatory regime to streamline oversight and unlock innovation. And those that transform our requirements by eliminating both the burdensome and the impractical. So together, these three pillars of advance, or A, clarify, or C, and transform, or T, form one integrated policy agenda that I'm calling our ACT, A-C-T, strategy. So let me begin with the first, advance. To advance our regulatory posture is to bring it into honest alignment with the world as it is, rather than as it was when many of our rules were first written. It is to recognize that a rule book crafted for one era does not automatically serve investors well in another, and that the costs of pretending otherwise are borne not by the agency, but by our markets and the investors who participate in them. Of course, advancing new regulatory frameworks does not mean deviating from the SEC's core mission. On the contrary, it means fulfilling it with tools that are equal to the task. Indeed, the application of our enduring principles must reflect how markets function today and how we anticipate that they will function in the future. Perhaps nowhere has the cost of failing to do so been more apparent than in our treatment of crypto assets. For years, the SEC dealt with these markets not through the issuance of rules, but through the might of our enforcement apparatus. Instead of articulating workable pathways for compliance, our message to the marketplace often amounted to a directive to adapt to us or else. We bothered not to adopt inapposite forms and adapt inapposite forms and disclosure requirements to innovative products, but demanded that the innovators adapt their products to our antiquated approach, or else face the consequences. The problem, of course, is that innovation rarely pauses for regulation. It will either occur within a regulatory framework or around it. And in the case of digital assets, the SEC's regulation by enforcement campaign precipitated the migration of an entire class towards offshore jurisdictions. Only compounding the Commission's subversion of American entrepreneurs, that posture completely failed in its effectiveness. Advancing new regulatory frameworks means choosing a different approach. It means crafting rules that are clear enough to guide markets, flexible enough to accommodate innovation, and firm enough to protect investors. It's long past time that we do so. So, of course, as we modernize legacy rules for the 21st century, we must recognize that markets also depend on clear and coherent regulatory scoping. This brings me to the second pillar of our ACT strategy, which is to clarify. Having been around the SEC and the CFTC now for 3 decades, I've seen firsthand how jurisdictional ambiguity can stifle innovation just as surely as ill-devised regulation. Quite often, the relationship between these two agencies has resembled two fortresses facing each other across a regulatory no-man's land, and in that space lay the wreckage of would-be financial products. Entrepreneurs approached new frontiers with ambition, only to retreat when the answer to a fairly basic question remained elusive: whose rules apply? Duly registered firms have long been forced to navigate 2 agencies, 2 regulatory regimes, 2 or more examination cycles, 2 reporting pipelines, and often 2 supervisory structures, even where the underlying risks are substantially similar. Of course, for registered firms owned by banks, then we have to recognize that other regulators also play a role. By acknowledging this crazy quilt of supervisory authorities, we should recognize that the principle that ought to guide us instead is straightforward. Where one agency's framework achieves comparable regulatory outcomes, then the regulator should accept the overlapping requirements of the other. Closely collaborating regulators ought to be cognizant of these issues and work them out collaboratively. In short, our goal is to draw clear and abiding regulatory guidelines, lines that give innovators the confidence to build without fear of being caught in a crossfire of their government's own making, and therefore lay a foundation for super app trading net. As one example, earlier this month, the SEC and the CFTC entered into a memorandum of understanding under which both agencies will usher in a new level of harmonization. By aligning regulatory definitions, coordinating oversight, and facilitating seamless, secure data sharing between agencies, we will ensure that our rules and regulations deliver the clarity that market participants deserve. Among the first outputs of this new era of harmonization focused on clarifying rules and regulatory jurisdiction is the token taxonomy and crypto interpretative guidance that the SEC recently published, and the CFTC, I'm happy to say, joined with us. And as I said earlier this week, while the interpretation provides long-needed clarity, I should like to assure this audience that it amounts to a beginning and not to an end. So finally, the third pillar of my program for this year and next is to transform our rule book by trimming immaterial requirements that burden the market without a corresponding benefit to investors. Many SEC disclosure requirements that began as a framework to inform have steadily become instruments to obscure, to insulate, and to sustain a highly specialized cottage industry of advisors and consultants. Along the way, we've drifted from the immutable objective standard of immateriality, as enunciated by no less than the Supreme Court back in 1976, which is what a reasonable investor would consider important in deciding whether to buy, sell, or hold a security. Unfortunately, this standard seems to have devolved in the past few years into the notion of a subjective standard of what any particular investor may be curious to know. One can also see this drift manifest as a dragnet in places like Rule 17a-4, particularly in the so-called off-channel communications matters, through which the Commission allowed the extension of regulatory requirements for broker-dealers to a point that strains any common-sense understanding of the vague, quote-unquote, business as such standard. Similarly, the Commission has permitted the same result in a crazy quilt of similar but differing standards for document retention with respect to other registered entities. So we very, very clearly need a spring cleaning to enable reasonable investors to separate the wheat from the chaff when reviewing offering documents, periodic reports, and proxy statements. The attic, the basement, and the garage have all accumulated their share of clutter, and they make it difficult to find the load-bearing beams. Accordingly, our Division of Corporation Finance is actively engaged in a first principles review of our disclosure requirements with materiality as its North Star. But corporate disclosure is scarcely the only area where the Commission's focus has drifted from Congress's intent. The Division of Enforcement is also undergoing a course correction by prioritizing cases that provide meaningful investor protection and strengthen market integrity rather than technical rule violations in situations where investors have not been harmed. To those ends, we have directed the division staff to investigate the types of misconduct that inflict the greatest harm, such as fraud, market manipulation, and abuses of trust, and away from approaches that measure success by volume over real investor protection. And lastly, following a court's remand of 2 rulemakings related to securities lending and short sales, we have an opportunity to holistically reevaluate these rules, and I've directed the staff to make recommendations regarding a reporting regime that balances the policy goals with the burdens of reporting. This ruling also serves as a useful reminder that cost-benefit analyses are essential in assuring that our policies are sound and able to withstand the test of time. So you all have been very patient and attentive, so let me close perhaps where I began, with a reflection, in fact a request, from Chairman Bill Casey in his remarks at that inaugural SEC Speaks program. As Chairman Casey concluded that day, and I quote him here, "In these and in other endeavors, the Commission needs your ideas. Do not be passive receptacles for the views of us who will be addressing you at SEC Speaks. Challenge us. Make us do some hard thinking. It will be good for us, good for you, and good for the Commission, and good for the law." The strategy unquote there, the strategy that I have described today, advancing, clarifying, and transforming our rulebook and regulatory frameworks, is not work that this agency can accomplish alone, nor is it work that we should seek to accomplish alone. Our success depends on the ideas that you all offer and the scrutiny that you all apply. Indeed, as aficionados of the SEC, and I'll refrain from saying groupies, you all have a role in helping us to oversee our initiatives and holding us accountable for them. Few understand this institution as well as you do, from its history to its habits. You can see our warts, our successes, and more clearly than most, those aspects. That perspective is indispensable to us. So I hope that you will take Chairman Casey's counsel to heart and challenge us, push us, make us think more critically about the rules that we write and the decisions that we make. America's investors, innovators, and entrepreneurs are counting on us to get this right. I look forward to working with you all to ensure that we do. So again, thank you for your time, and please enjoy the remainder of the conference today and tomorrow. Thanks.
So thank you, Chairman Atkins. I think what's really interesting about what you just said is that the body of the federal securities laws remains intact and very relevant, and we just kind of need to revisit how it's applied, especially given the increasing complexity of today's markets. And you're just the person to do that, so good luck. So our first panel is led by Jim Maloney, who's the director of the Division of Corporation Finance. Jim became the director in October of 2025. He began his career, I believe, at the SEC for 6 years and then joined Gibson, Dunn, and Crutcher, where he worked for 25 years, ascending from corporate associate to equity partner. While there, he served as a longstanding co-chair of the firm's securities regulation and corporate governance practice. Joining as commentators of this increasingly growing panel is Kathy Casey. Kathy is currently an advisor with Potomac Global Partners. She had more than 2 decades of experience in senior government, regulatory, legal, and policy roles. She finished her term as SEC Commissioner in 2011, and during that time, during her tenure, she was the principal representative in various international fora. She was the international commissioner, really. And before that, she worked in the US Senate, and in fact, Kathy and I became sort of the charge that led from the US Senate Banking Committee to the SEC as commissioners, which you'll see over the next few days. There have been several people on that same path. She currently serves as non-executive director of HSBC and is a member of the Board of Trustees of Penn State and chairman of the board of Penn State Health. She's also a member of various advisory and other boards, including the Public Company Accounting Oversight Board Advisory Council. The other commenting commissioner is Elad Reisman, who's a partner at Cravath, Swaine & Moore in the corporate department and a former commissioner and acting chair. While at the SEC, Elad led a process to improve the proxy voting process, which, thank you very much. That is a very intense and heart-wrenching task, which he did a very good job of. He played an instrumental role in modernizing the regulation of the U.S. equity markets as well as the Treasury markets. He joined the SEC after serving as chief counsel for the Senate Banking Committee. And before that, he served as counsel to Commissioner Dan Gallagher. He was chief counsel of NYSE Euronext and a corporate lawyer in private practice. So my other required comment is that you consider the comment of these panelists. And I say this every time so that you will get CLE credit for listening to the comments and everything else. So I welcome the Corpin panel. Thank you very much.
Thank you, Commissioner Unger. It's great to be back. My name is Jim Maloney, Corpin Division Director. I think many of you know me, or maybe you read something about me in the press. Been with the back with the division for about 5-6 months now, and it's been going very well. We have a lot of rulemakings underway, but before we start, I just want to give the disclaimer for everybody, so we don't have to have everybody give a disclaimer. As I give my disclaimers, I say it's just Jim, just what I think. It's not what the commission thinks, or any particular commissioner, any staff member, any division. It's just Jim. And when you meet all my fellow colleagues up here, that stands for them too. It is just Christina, Thomas, Duck Dang, Sebastian Gomez, Luna Blum, the rest of the folks out there, Ted Yu. We keep going. We got Commissioner Casey, and all the way out of the back, Eli Reisman. All my good friends, I speak for them when I say they are speaking for themselves. So where are we today? As you heard from the chairman, ACT, advance, clarify, and transform. We're going to do a little drinking game here. It's early in the morning. So whenever anyone says advance, clarify, and transform, you are to take a sip from your coffee. This will energize you. This will get you focused on what we're all talking about here today. This is important stuff because we're about to embark upon, I think, a number of rulemakings, which will advance I don't see people drinking, advance the Commission's mission to modernize the rules and clarify them. Still not seeing people. Okay, a few over here are drinking. They're catching on to this game. And what we will be doing is we will be transforming. Any of you who read the Commission's interpretive release yesterday, you no doubt picked up on the theme of transforming, that things can transform. They can be a token, they can be a security, and they can transform into something that's not a security. So these are exciting times. I'm not sure how many of you know that today is the day in 1792 for the first Wall Street crash. That's right. We've had many crashes in the past. That was the first. I think the 6% Treasury bonds dropped by 10%, issued by the Bank of the United States. Some trivia for you. Well, we can't stop the market from fluctuating, but what we can do is we can advance the rules. Things that were written in 1933 and 1934, which was handed to us by Congress. It's our job, not just as the Commission, but also as the division and the other divisions, to transform and to clarify how those rules written close to 100 years ago apply to the technologies today. So I'm going to shut up now because I am going to sit down and let this brilliant team of specialists who are working with me in the Division of Corporation Finance and our two former commissioners at the end kind of weigh in with their thoughts about this exciting mission that you're about to see unfold in the next year or two. Thank you very much.
All right, thank you, Jim. Good morning, everyone. I'm excited to be here today. I'm even more excited to be back at the SEC, acting as your deputy during this transformative time at the SEC. I think anyone in the audience who advises public companies is well aware of the division's efforts to clarify the rules that we have on the books. In the last year, you've seen a lot of publication of new and amended CFIs, no action letters, and other guidance. As the chairman has said, it's a new day at the SEC, and I hope you've noticed that the door is very much open, and we've really been happy to have a lot of meetings and discussions about what we can do to help provide clarity to the market. So we're working hard also to advance not only a large number of rules, but a large number of what Jim refers to as blockbusters. And I'm really excited for those to start coming out in the near future. My colleagues are going to cover many of the rulemaking efforts underway, but I wanted to highlight two that are particularly near and dear to me, Rule 14A8 and Regulation SK. On Rule 14A8, we are taking a close look at the SEC's involvement in this space, including whether it's appropriate, whether we ever even had the authority to create this regulatory regime over shareholder voting, which is typically the jurisdiction of the states. On modernizing Regulation SK, another major area of focus right now, we have an open comment file. In case anyone wasn't aware of that, it closes next month. We've been really encouraging members of the public to write in with data and concrete suggestions for revisions to Regulation SK, and I wanted to take a moment to note that internally, work is well underway. We have a team of lawyers and accountants in Corpin, led by Robert Arrett, Jennifer Lopez Molina, and Seth Mann, who have been doing an incredible job taking a close look at the rules on the books, making recommendations, and digging into the history of the requirements. Michael Arnold just joined the SEC from private practice, and he's going to take a leading role in transforming Regulation SK. And we're in the process of hiring additional people to work on these efforts as well. So please stay tuned. It's really exciting. Again, these are just two examples of the blockbuster rules that we're working on. So I'm going to turn it over now to my colleagues to give you more of a sense of what we've been acting on and what you can expect from the division in the coming months and years.
Hi, everyone. Thank you. So I feel like I should have actually sat at the end, since I will not be talking about any rulemaking or cool policy initiatives. But since I'm here, I'll go ahead and start. What I wanted to do was actually just give 3 updates on the disclosure review program. One is going to be an update on our transactional review program. The second is our annual review program. And the third is something related to our comment letter dissemination. So first, I think most people are aware, there was a long, not the second short mini government shutdown, but there was a long government shutdown in October that then bled into about half of November. And as I was sitting there, you can imagine, it's a pens down situation where basically staff couldn't review anything that was already in process prior to the shutdown. And me, Sebastian, and a handful of folks every day were looking at spreadsheets showing the inflow of filings coming in every day that we could not review. And that list grew over time, got to a point where it was it was over 1,000 filings. And of course, when we reopened, filings just keep coming in. And so while we wanted to continue focusing on the important mission of investor protection, we didn't lose sight of capital formation. And so when we reopened, there was a very concerted effort to try to limit the impact of the shutdown on capital formation. And so just to give you a sort of a data point, when we first reopened, there were a lot of instances where what we call the time to first comment, that's when the first comment letter goes out or the first round of review is done on an initial registration. We were in the 70-day ranges for that when we first reopened. I'm delighted to say that at this point now, we're now at an average of around 30, which means there's a decent number of reviews that we are actually completing the first round even under 30 days. And that really is just a testament to the hard work and dedication of the staff, because it takes a lot of additional effort to be able to deal with a backlog that's significant. And to give you a sense of the lift that the staff had to undertake, focus on the initial registration statements, because those are critical to capital formation. So if I look at the date when the government reopened on November 13th up till today, the staff has processed the initial round of comments on over 600 filings. If you look at that same period last year, so the same number of days, the staff actually, based on like a normal flow, processed just a bit over 300 filings. And so in terms of the transactional initial registration statements, the staff was able to process more than double the amount with, you take into account the number of staff reductions we've had and departures. I'm always impressed about when I look at, as we were just whittling down that time to first comment, I'm just proud to see the efforts that the staff put in to get to the point now where we can actually share that good news. But I would remind you that as we're sort of at that point now, if you have sort of specific to your transaction, please still feel free to reach out to the staff, and we'll consider any type of time and considerations that are unique and where we can help to, smooth out the process. Let's see. Now, as you can imagine, one was actually working probably on some level more hours than normal to get to that point, but another was actually providing flexibility to the staff, because the transactional review program is a sort of a selective review program. So where we were able to make adjustments, we did. But the second thing is we also have an annual review program. That's where we're we always comply with our SOX mandate. And it's in section 408 of SOX. So as you can imagine, when we reopened, we had to make a decision to basically halt the annual review program to focus on the transactional filings. But I'm happy to say we have now kickstarted and restarted the annual review program. And it actually works out because we're sort of in that 10K cycle now. Most companies have filed their 10Ks, and so the staff is actually in full swing performing annual report reviews. And I have zero concern that we will comply with our SOX mandate. So, of course, the number of reviews will probably be less than prior years, but in terms of complying with our SOX mandate, there's no risk there that I'm aware of. The third update I wanted to give is related to the comment letter dissemination process. And I know it's sort of a cottage industry out there for people to aggregate all of our comment letters and provide insights on the type of comments we provide. So due to several factors, including staff departures, the shutdown, I am sad to share that we're probably 5 months or so behind on disseminating our comment letters. So I would caution folks from actually going out there and, whether you're using IntelliGuise or whatever, to try to track trends and then have a takeaway or have some type of commentary about, oh, the volume of comments are down. It's a function of that is going to be because there is a delay in the dissemination of the comment letters. But we are actively working to address this. And we're looking at several solutions, including sort of transforming the process. So I did take a chance to sort of see how that process works. To this day, it's still a pretty manual process. And so we're looking for ways to, if we can automate it, to be able to speed it up and get it back to what people are used to. Because recognizing that, that our transparency on our part is important as well. And one tip for folks, one of the things that sort of slows down the comment letter dissemination process is that we make an effort to not disseminate PII, because people will submit correspondence that includes PII, and we work to prevent that from happening. So if on the front end, if you could be more mindful when you're submitting correspondence, you just double check that there is no PII. And some examples are sometimes people will include some exhibits with their correspondence or other ancillary supplemental documents. And we've seen instances where bank account numbers are included, addresses are included, tax ID numbers. So if you could just sort of clean that on the front end, it actually would help us on the back end as well. And so that's...
And before we move on, I just want to say, Duck and Sebastian and I guess we had Cicely Lamoth at the time and Michael Seaman, who's not here. During that 43-day shutdown, that government shutdown that was outside our control, you guys did an amazing job at triaging the filings that were coming in and getting us dug out from that backlog. And, having been in private practice for 26 years, and then everybody out there in this audience mostly sending in registration statements and filings and correspondence and requests, from somebody coming from the outside in and seeing how 5 or 6 people continued the division running for a month and a half, it was amazing. Thank you, guys.
Oh, thanks, Jim. Appreciate that. Now, pass it on to Sebastian.
Thank you, Doug. Good morning, everyone. Let me tell you that the best part of being up here is looking at the audience and seeing so many familiar faces, current SEC staffers, former SEC staffers. Really appreciate all the support. We're very thankful for the staff at the SEC and everything they do, so thank you to them. But we're also very supportive of those alumni of the SEC who continue to support the work we do every day in your careers. So big thanks from us. I wanted to expand today a little bit on what the chairman talked about and give you a little more about how we are advancing clarity with respect to crypto assets, and give you just a little more of a description of what we did in the interpretive release that the commission just put out this week. It's only 68 pages, but we did cover a lot of ground in those 68 pages. And I like to think of it as 3 different buckets. So let me just go through the 3 different buckets and give you my take of what the commission did to continue to provide clarity with respect to the federal securities laws and their application to crypto assets. So the first category is that the commission in the interpretation provided a crypto taxonomy. So we're the SEC, so in plain English, what does that mean? That means that the SEC went ahead and created different buckets of categories of crypto assets, and then went on to provide an interpretive analysis of whether those buckets of crypto assets constitute securities or are not securities. The interpretation is grounded on a very familiar case, Howey from 1946. And as we think about it, what is novel here is the fact that crypto asset is something where the commission had not provided a clear interpretation as to how that case applies to these categories. So what are the categories? First of all, digital commodities. Digital commodities are what most people think about crypto assets today. So blockchain, Bitcoin, Ethereum, XRP, Solana. These are what people mostly think are crypto assets, and the commission determines that they are not securities. Second, digital collectibles. Digital collectibles are what most people think as meme coins. So these are digital representations of arts. These are the tokens that you will use as part of a video game. These are things that people will collect. Again, the commission applied the Howey test to those and determined that they are not securities. Third, the commission looked at digital tools. Digital tools are probably the one that most of us are least familiar with, and these are types of crypto assets that perform or function. So for example, there will be a token that will represent your ability to access a concert, or your ability to show that you have a membership in a certain group. Again, the commission applied Howey to digital tools and determined that they are not securities. Finally, the commission applied the Howey test to stablecoins. But in this case, it was much easier because as part of the Genius Act, Congress determined that stablecoins as defined in the Genius Act are not securities. So the commission noted that in its interpretation. With respect to digital commodities, digital collectible, digital tools, all these categories of digital assets that are not securities, the key outcome, the key takeaway of this is as you apply the Howey test and you look at the prong of, is the investor expecting profits as a result of the essential managerial efforts of others? Does that apply to these situations? And as what the commission concluded is, in all of the situations, the value that investors get is not as a result of the essential managerial efforts of the innovators of these assets. So therefore, they're not securities. So that leaves us with the 5th category, digital securities. And this is the one that most of you will care about. This is the ones that are squarely within the framework of the federal securities laws. And what constitutes a digital security is any of the items that otherwise fall within the definition of security, think of share of common stock, that has been represented on the blockchain. In other words, has been tokenized. So with respect to those, the fact that something has been tokenized does not make it not a security, but because the underlying instrument is a security, the digital securities will be securities. The second bucket of what the Commission covered in this interpretation is the fact that even though some assets may not be securities, they may be part of an investment contract. So what the Commission did is went through an analysis of when is it that a crypto asset that is not a security becomes part of an investment contract, and even more importantly, when is it that such assets that became part of an investment contract ceases to be part of an investment contract. The first part of that test, we're all very familiar with. It's no secret here that over time, the Supreme Court, other courts, the SEC have interpreted when is it that something becomes an investment contract. The Commission noted in its interpretation that someone, innovator, is developing a project in which the underlying asset itself is not a security. They may make representations or promises in order to induce investors to invest capital in that project. Those representations are the ones that become the essential managerial efforts of those innovators, and therefore the purchaser is expecting profits because of those essential managerial efforts that are represented by those promises that are made to them. At that point, even though the underlying asset, the crypto asset, is not itself a security, it has become part and the subject of an investment contract that is created because of those promises and representations. This part, this is something that I think we all have heard about it, and it's how the Orange Grove, Jim, the Orange Grove became actually part of an investment contract. Now, the next part, the one that I find more interesting is when is it that that investment contract ceases to exist? Often we stopped our analysis at the fact that an investment contract was created, federal securities laws apply, and for most situations, we don't care anymore about it. That just ends the question. But with respect to crypto assets, what matters here is that as that project develops, it gets to a point in which there is no longer an expectation of profit because of those essential managerial efforts. The reality is those promises, those representations that the innovators gave that was inducing others to invest, those promises and representations are fulfilled. And therefore, those investors who are looking at that project are no longer relying on those efforts in order to expect profits. The reality is they have moved on, and the expectations is that the project now is living on in itself. So let me take that back to the Orange Grove. Say, for example, hypothetically, that at some point, an investor that initially was living in New York and had no ability to actually tend to the orange trees, pick the oranges, and turn them into orange juice, decided that New York was too cold and wanted to move down to Florida. And at that point, they said, Mr. Howie, I actually don't want anymore for you to actually do the work for me. I don't want to be part of the service contract. I am going to take that back, and I'm going to become self-sufficient. At that point, you are no longer relying on the efforts that Mr. Howie was doing, and therefore, you are now actively working within that Orange Grove. At that point, none of us would expect that that investment contract exists today. So this is not that novel. What's novel here is that the Commission is actually providing clarity in this space and allowing us to have a better set of framework as to how we think about how innovators progress from having an investment contract and then how that investment contract ceases to be part of it. Finally, the third bucket, the interpretation provides clarity on a number of transactions that are related to crypto assets. Airdrops, protocol mining, protocol staking, and wrapping. Some of this, the staff had already provided guidance as to whether they constitute the offer and sale of a security in the form of staff guidance. The Commission adopted some of that guidance and made it its own. With respect to some of the other ones, is new topics. I know that there's less of a focus on this part of the interpretation, but it's key in order for the crypto infrastructure, the crypto market to continue to function and to provide the clarity in this space. As the chairman mentioned, the key here is that we also did this jointly with the CFTC. The CFTC joined in the interpretation to provide guidance that they will interpret their laws in accordance with the interpretation that the commission provided here. So it shows the two agencies working together in this space. There's a lot of resources about this. We put out not only the interpretation, but a fact sheet. I know that this is the time of the year when many of you get called to go to school to your kids and tell them about what you do at work. For us lawyers, that is very hard because it's really hard to explain to someone in elementary school what we do. If you are in that situation, I encourage you to take a look at Jim's statement with respect to this interpretation. It's the little golden book story of Howie and how the investment contract was formed and how the investment contract ceased to exist. I'm not going to suggest that you actually read it to your kids at night, although that may be very helpful. But if you're thinking of ideas as to how you can turn this into that successful presentation for career day at your kids' elementary school, it's a great way to start there.
You know, I just want to thank Sebastian. You know, he is the guy who runs the railroads on the rulemakings. And you probably saw the RegFlex agenda has like 22 rulemakings. So in his free time, he becomes a crypto specialist along with Andy Scheffler. But I think you can see, you guys are the experts in the room. You can see why this is such an exciting moment in time. This is earth-shattering, and I know it's hard to wrap your head around, but I also want to get commentary from our Commissioner Casey and Roisman at the end as we go along. I don't want them to run out of time down there. So if they have thoughts on the things that we're talking about, I invite them to chime in.
So thanks so much. Actually, Sebastian, just want to follow up. You highlighted the most recent interpretive release and the work with the CFTC on this, and obviously the chairman highlighted in his remarks the landmark MOU. Just curious on a more operational level, can you talk about what that means for the division going forward in terms of working really closely with the CFTC?
Sure. I think sometimes we enter into MOUs and you're waiting to see what is it that means in practice. And I think you couldn't see a better example of what that means in practice when we follow the MOU shortly after by putting pen to paper and an interpretive release showing that we're working together. But I think it's bigger than that in the crypto space. The chairman mentioned the importance of the clarity that only Congress can provide on a permanent basis in this space, and how important it is the efforts that Congress is doing with respect to advancing the Clarity Act. Once Congress completes the Clarity Act, it's going to be very important for the two agencies to work closely together. And as the chairman mentioned in remarks earlier this week, him and Chairman Seelig at the CFTC are very much looking forward to show how this MOU in practice is going to work as we continue to further clarity in this space. Did you see I used the word clarity one more time there? So thank you for the question to give me that chance. The last thing I'll say about the MOU is it's much broader than just crypto assets. Take a look at it, but this shows how across the SEC, all different agencies are going to be working on a number of work streams with the CFTC, and I think it's the best we can do in Washington. I mean, we have two sister agencies, and I think it's great that we're going to be able to collaborate together.
So I've been drinking. I think it's incredible. You said it's 68 pages, but it is really sort of the landmark piece that the commission has never done. And I know in Jim's statement, it's the final chapter in the book of Howie. And I really did like the golden story. I almost envisioned someone in an old Ford driving down the roads to these orange groves. Like all good books, people want more, right? So sometimes the characters appear in other books. Do you think that this is sort of the the final thing, or do you think there's going to be more coming? And the last point is I hope people in Congress are listening because the SEC and CFTC are doing great work, so hopefully they'll be able to continue to do that even after clarity.
So Jim called his statement the last chapter in the book of Howey. Keep in mind that he said the last chapter in the book of Howey. He didn't say the last chapter in the book of crypto assets. And for those of you who are interested in what's coming next, if you go to the page where we put SEC statements, the chairman gave a speech at the DC blockchain earlier this week, and he forecasted what he would like to see in this space as next steps. Rather than taking his thunder, I encourage you to take a look at that. But he is describing how we can move forward, and the next step would be to actually provide additional clarity for those who are looking to raise capital and come up with exemptions that are bespoke to the needs of crypto assets in order to facilitate capital formation with respect to those. So take a look at that statement, because I think the chairman does a great job of showcasing what it is that he would like to see in the months to come. So a short answer is lots more coming.
So one other question, and again, maybe for Sebastian or others, did note the chairman's speech and anticipation of potentially formal rulemaking coming. Just how do you all think about, in terms of whether it's guidance, whether it's formal rulemaking, as you're looking to provide greater clarity, particularly in the digital asset space? Just curious about making those judgments about where an interpretive release might make sense and where formal rulemaking might make sense, particularly with an eye to longer-term sustainability and confidence in the rule books going forward. Thanks.
Yeah, I'm happy to take that. As you all know, I mean, interpretations are not something that creates new rules. Interpretations is just the commission providing its views on how the law applies in their views. Keep in mind that when we are interpreting case law, a court might decide to look at it and interpret it differently. We can't control the courts. We're hoping that the courts will look at this interpretation as they are thinking about cases in this space, but we can't bind the courts on this. Only rules can bind the courts, and even within the SEC, sometimes when we think about the 33 Act and the 34 Act and how those worked, and they were not crafted with the idea of crypto assets back then, only Congress can actually change statutes in order to provide certainty in this space. So I think the congressional action here is extremely important to provide something that is very definitive. In the meantime, as the chairman mentioned, it's key for us to provide the clarity that the market deserves within the parameters of the rules we have. So the interpretive release is doing that. Notice and comment rulemaking is where we actually will do new rulemaking. And again, within the exemptive authority, we have the ability to create new exemptions, all within the parameters of what's given to us by Congress. So to the extent that we move forward and the Clarity Act is still working on, I hope that we can go ahead and provide additional clarity in the form of new potential rulemaking in that space. But at the end of the day, if we want this to be permanent, I think that's when Congress comes in.
Yeah, and I would just add, if you saw my first statement, it talked about movies, and each rulemaking is sort of a separate movie, and there will be sequels. And so the interpretive release is sort of the tip to foreshadow what's to come, laying the groundwork, if you will, for the Clarity Act when that comes. But the commission's not sitting on its hands waiting for that to happen. We are moving with full speed on all cylinders. So I'm very excited to be back and have all my team here working on these different rulemakings. So there's a lot more to come.
Well, I think I'll take that excellent segue. Thanks, Jim. But we're going to take a hard pivot away from crypto assets. But before I dig into the meat of my comments today, which you may have guessed are largely going to focus on our rulemaking pipeline, in particular, what I'll call more our bread and butter rulemakings, I do want to jump in on, I'm sure folks have seen the recent Interp bandwagon. I just want to give a shout out to Jeb Byrne and his team, the Office of Small Business Policy, for their tremendous effort updating a number of our interpretations in several areas, including Reg A, Reg Crowdfunding, Form D, Rule 701. And Jeb will be talking about some of those interps more this afternoon, so I hope folks will stay tuned for that. So on to rulemaking. I know that everyone is very interested in having a better sense of the timing of things, and I know y'all know I can't tell you very much. I'll also just acknowledge that our Reg Flex agenda has been coming out with about a half a year delay, so right on time, I would expect that our fall 25 agenda will be published in the very near future. But I do think at this point, folks have largely digested the last Reg Flex, so I'm just going to go into a few of those blockbusters that we keep talking about. And the first ones I'll talk about, I'm very excited about, and these are really transformative rulemakings focusing on the sort of 33 and 34 Act, framework. So the first one I'll mention is the enhancement of emerging growth company accommodations and simplification of filer status for reporting companies. So for those that were in tune for this panel last year, one of the things I talked about was just how complicated the current filer status regime has become between the accelerated filer statuses plus smaller reporting companies, emerging growth companies, never mind FPIs and asset-backed securities issuers. So these all have different thresholds and tests for whether you are in one status or another, and as a result, it can be sometimes very hard to know where the accommodation lines are, or if those lines even make sense anymore. So we are looking to rationalize that system and leverage the success of the EGC accommodations as we think about how to encourage companies to go public and stay public, and I would say especially when we're thinking about that small to mid-cap area. So on the 33 Act side, we have shelf registration modernization, as it's called in our Reg Flex, but as we're really calling it now, registered offering reform. So consistent with filer status, this rulemaking's goal is to encourage more companies, especially small and mid-cap companies, to go public and stay public. And really what this effort is doing is considering ways to build on the success of the shelf registration system that the Commission introduced 20 years ago in securities offering reform, which was a very innovative and transformative paradigm at the time it was adopted. So building on those successes, I think you'll see some very interesting things on the 33 Act side in addition to the filer status rulemaking on the 34 Act side. So from here, we can then move to disclosures, right? We have our 33 and 34 Act frameworks, and now we have to think about what are companies actually having to disclose, and is there room to rationalize that? So on our Reg Flex agenda, I know folks have seen the rationalization of disclosure practices item, which is admittedly very broad, and that's on purpose. I won't repeat some of what Christina's already mentioned about efforts underway on a real rigorous review of Reg SK, but I will just mention the other topic that this Reg Flex item is meant to encompass, and that's executive compensation disclosures. So folks know we had a roundtable last summer. That was a really exciting event. We got amazing input there, and there was a corresponding comment file. We received over 60 comment letters with really great insights into executive compensation practices, how that disclosure regime is working or doesn't work, and we're taking into consideration all of those comments as we move forward. I'll talk about a couple of major themes in how we've heard from the comment file that disclosure is useful to investors. The executive compensation disclosure regime, we understand from commenters, allows an assessment of the compensation committee's effectiveness, provides a basis for say-on-pay decisions, enhances company decision-making on compensation in a light of access to peer info, can show the economic cost of named executive officers to the company. It can help identify retention risk, and it can help investors assess the alignment of pay, whether that's realized or realizable, and performance. So I think these are some of the major kind of benefits that we are hearing from the comment file and want to ensure that a future disclosure regime will continue to address. Commenters who are critical of the current regime, by contrast, noted that the remuneration structures and related disclosure requirements have become really increasingly complex, and it can often be difficult for the disclosure to fully illustrate the connection between pay and performance, at least the way that the comp committee and the board really think about it. There can be a lack of comparability. The disclosure can be difficult to digest and does not reflect the actual nuances of an issuer's business. the compensation practices may inadvertently create misimpressions that can be counterproductive to effective disclosure. So again, this is just giving to you sort of objectively what we heard from the comment file as some of the concerns around, the current disclosure regime and whether the prescriptiveness of it really aligns with how companies think about compensation today. So of course, the staff is working away, taking on this excellent feedback from the comment file and developing recommendations for proposed rules that the commission can consider. So stay tuned for that. I'll circle back on one thing that is not on our last Reg Flex agenda, which again is about a year old now technically, and that's semi-annual reporting. I think everyone is well aware that this is clearly in the pipeline based on comments from the president, the chairman, and our director. And as the chairman has said, quarterly reporting has not always been required. And so his goal is to have the commission take its thumb off of the scale on whether quarterly reporting should be mandatory for all public companies or whether instead the market can dictate the best reporting frequency based on investors' needs and the particulars of a company's business. So I'll turn now to this last Reg Flex item that I want to note, which is updating the exempt offerings pathways. So with this initial lineup that I've talked about, I think it's clear that we're making it a priority to consider regulatory changes that will hopefully reduce costs while still protecting investors in an effort to make our public markets more attractive so that there are more public companies. But we recognize this is really only one half of the picture. Every public company starts its life as a private company, and so part of our goal has to be ensuring that capital formation is reasonably available at every life cycle stage while still considering the protection of investors. So by making sure that companies have access to capital before they go public, we're helping to ensure that there is a robust pipeline of enterprises that are growing ripe for the public markets. So accordingly, we're taking a close look at the exempt offering framework with these objectives in mind. Before I turn to my final topic, which is really more rulemaking adjacent, I just want to take a moment to give a shout out to the Corpin rulemaking teams that are just grinding away at getting proposals ready for the Commission's consideration. We're obviously really excited about the agenda and for things to be out for comment so the public can kick the tires on all of these new ideas and approaches that we hope the Commission will approve. It really is an exciting time. Our rulemaking teams, of course, include all of the staff in the Office of Rulemaking under the exceptional leadership of Valian Afshar as the chief of that office. But in addition, subject matter experts and staff from across the division are jumping in to help with this tremendous agenda. This includes staff from the Office of the Chief Counsel, Office of Mergers and Acquisition, Office of Structured Finance, the Office of International Corporate Finance, the Office of Small Business Policy, our Chief Accountant's Office, and with help and expertise from staff in the Disclosure Review Program, including the Crypto Assets Office and the Disclosure Management Office. So it is a tremendous effort. In addition, when we have to take so many folks on to help with such a big agenda, it takes away other resources and folks have to pick up the slack. And that's, of course, on top of a backlog and a shutdown and everything else. So I can't really thank the staff enough for all the support for these efforts. And the folks on the rulemaking teams are just doing a tremendous job, and we're so grateful and proud of the work they're putting in.
Needless to say, that's a lot of rulemaking, okay? A lot. And many of you know and remember Betsy Murphy. I could not think of a better person to pick up the torch and run the Office of Rulemaking than Luna, a fellow New Yorker who you can tell with her energy and zest and fast talking. She is a fellow New Yorker, and she will get it done with her team. Thank you, Luna.
Thanks so much. And of course, I can't help talking with my hands too, so that's also.
That's the Italian in you.
If I can just not hit the microphone, it's a success. So with that, I'll turn to my final topic today, which again is sort of rulemaking adjacent. This is the accreditor investor definition. So as I'm sure folks are aware, there's been different pieces of proposed legislation that have touched on the accredited investor definition. Some of them, like the INVEST Act, which passed the House with bipartisan support in December, and the Empowering Main Street in America Act would require a new accredited investor examination to be created by either the commission or a self-regulatory organization.
Our chairman has also talked about the possibility of an accredited investor examination and made the point that individuals with significant investment experience and knowledge shouldn't be excluded from the private markets in favor of individuals who have inherited wealth. So such examinations would certainly modernize the accredited investor definition and recognize that financial sophistication cannot be measured by income or net worth alone. So in an effort to increase investor access to private markets while ensuring adequate investor protections, the chairman has directed staff in the Division of Corporation Finance to begin conversations with FINRA about the possibility of creating an examination, and those discussions are underway. If FINRA determines to move forward with creating an exam, or if Congress mandates it, there will be an opportunity for subject matter experts to be involved in developing the substance of that exam. There will be more on that in due course. We're still in early days in these discussions, but folks are welcome to reach out to the Office of Small Business Policy in the meantime, and we'll be happy to facilitate the connection with FINRA when the time is right. And I do just want to also shout out our colleagues in FINRA who have just been tremendously helpful and eager to engage in this process. We're really excited about the possibility. And I don't want to get in front of the commission. Obviously, all of those efforts are going to take some time, and ultimately the commission would have to recognize that exam as an appropriate means of establishing accredited investor status. So this is a journey that we will go on. We'll go on it together, but we're really excited that it's kicked off.
Well, just before I move on to my topic, just want to see if the commentators have any thoughts on.
It's all great stuff. I don't want to interrupt because I'm just waiting to hear what's next.
Okay. Well, thank you. So I'll sort of bring the end of this panel to a conclusion here with some updates on some rulemakings on the Holding Foreign Insiders Accountable Act. I had to practice that a couple of times. Which came as a bit of a surprise, sort of an unexpected Christmas gift from Congress to the SEC. It was enacted on December 18th, and it had a short deadline of March 18th. So very short sort of rulemaking time. The staff immediately acted quickly because when Congress gives us a mandate, we have to comply with it, and we have to meet the deadlines. So the first thing we embarked on was a rulemaking. Pretty straightforward, but not much time to work on it, to be honest. We got it done 2.5 weeks before the deadline. It's a fairly short release, but it has some pretty good footnotes. So for those who are really into Section 16, read the footnotes. That's really where the good stuff is. There will be a couple of things I'll highlight. One, the commission made it very clear that this mandate that for foreign private issuers to file Section 16 reports, it does not apply to 10% holders, unlike for domestic issuers. There was some bit of commentary about whether that was the true intent to exclude 10% holders, and the commission thankfully took the effort to clarify very clearly that it does not apply. The second thing that we did get some questions from, and just since we're all securities law groupies here, I want to make it clear, the commission did not include a Item 405 delinquent filer requirement to 20F. So I think for those who are advising their clients and 20F season's coming up, please keep that in mind. The next step really was the exemptive order process. Congress gave the commission the power to exempt officers and directors of foreign private issuers incorporated in jurisdictions that have substantially similar requirements as Section 16A. The commission did use that authority about a week after the rulemaking came out and exempted jurisdictions, FPIs in jurisdictions such as the EU, Norway, Canada, the UK, Switzerland, Chile, and South Korea. Our estimate is that that exempts about 22% of the reporting FPIs and the officers and directors of those FPIs. And I think it's pretty clear why those jurisdictions were considered, because their laws very much mirror Section 16 in some ways, almost identically. So we have been getting questions as to whether or not that's the final exemptive order, and I will make it clear that we do have pending requests currently. The commission will obviously make the final decision, but the staff is working with folks to sort of get that process done. Smooth implementation also requires answers to technical questions for those who are advising their company, the FPIs. And so we issued 2 rounds of FAQs, which helped answer some of the fairly technical questions, which I will spare you right now. Michael Coco will cover those in the workshop. But one thing I will make clear is for those who were worried that EDGAR access wouldn't be available by March 18th, the FAQ does provide no action relief up until April 1. So for those who are still sort of trying to get those filings into the system, you have a bit of time. And then the last thing that we did was issue a no action letter for those, for Israel and other foreign jurisdictions that are directly affected by the current conflict. We heard some concerns about, understandably, the ability to build a compliance system under fairly difficult conditions. So there is a 30-day period for those who are in these jurisdictions to get their Form 3s and 4s and 5s on, I'm sorry, probably just Form 3s on file by April 20th. Yesterday was day one of this transformed landscape for foreign private issuers. And I'm happy to report things worked out fairly well from our perspective. We received about 4,100 Form 3s yesterday. And just by comparison, our EDGAR office has informed us typically we get about 30 to 80 per day. So I'm glad that many are filing, but I'm also glad that the system and the process that we set up worked out well. I have not heard of any massive problems getting those filings into the system. And so it's good news from our perspective. Smooth implementation is so important for those who are trying to get their clients in full compliance. I will say that this was a agency-wide effort, and it was really wonderful. It was a collaborative effort. I want to take this moment to thank not only our Corpin colleagues, but our colleagues in the Office of International Affairs, our economists in DERA, our general counsel's colleagues, as well as our EDGAR business office folks. It was a team effort. It's really rare that we can sort of work so well in such tight timeframes and get everything done without major problems. So, so that's our effort on that. I'm going to move on to guidance. Our Office of Mergers and Acquisition has been very active in providing guidance. Guidance in this space is always fun, and since Jim is here, it provides us with an opportunity to push out a lot of guidance that we wanted to, since he was very supportive in this space. So we saw Jim arrive, and we said, let's get those things out. We put out a fair amount of guidance. Perry Hinden will sort of go into sort of the more technical ones later in the afternoon session, but I do want to highlight a couple of things that I think really are remarkable, one of which is the ExxonMobil voting platform no action letter that we issued in September. That one, for me, was a really fun one, because the question of how to get retail investors to vote in a system that is frankly a little bit obsolete and difficult to get into is something that the commission and the staff have thought about for years and years. And lo and behold, a company wanted to take the first step in establishing a retail voting platform with standing voting instructions. We worked with that company, and we made sure that it had all the investor protection guardrails that we want. It's complete opt-in, no one's forced to do it, and even if you participate, you get all your regulatory disclosure documents. Nothing's changed. And so we were happy to see it launch. We were happy to see or hear from the company that the participation rates among retail investors was very high. We were very happy to hear that other companies were looking to create such platforms. Our Office of Mergers and Acquisition is very open to engagement on that space. Please do reach out if you have clients who want to build similar platforms. We think this is a good move toward sort of empowering the true holders of a company, the retail investors, to make the decision. And if there's any sort of guidance that we need to provide, please reach out. It's wonderful to see some movement in this space. A couple other things that I just want to highlight. Notice of exempt solicitation. We put out a CFI this past January, essentially allowing folks, preventing folks to file these things voluntarily. These are typically filed in recent years by folks who own less than $5 million in securities. It actually is not something that they're supposed to be doing or required to do, but they have been using it sort of for a purpose that the commission did not intend. We've been tracking this for years and years, and the rate at which these forms are being used by folks who aren't supposed to use it really got to a level we were not comfortable anymore. And so we put out guidance in January indicating that we do object if folks who do not own $5 million in securities file these. And I think the word has gone out. Our Office of Mergers and Acquisition has been closely following the filings on this front. Every one of them gets looked at by the office. We have reached out at least twice to filers who we wonder as to whether or not they actually own $5 million in securities. Generally speaking, I would say folks just didn't know. Folks who file these don't follow CFI, CDIs, staff guidance as closely as people in this room, and they stop. We will exercise our ability to use Rule 15 of Regulation ST to remove these filings if there are truly egregious situations. That's a power that the commission has. It's been delegated down to the staff level, and we have processes established so that if you do have a situation where a notice is filed, please do reach out. We will consider it. Doesn't mean that we'll always use it, but certainly the tool is there, so please do reach out. And the last thing I'll just end on, and I want to make sure the commenters have a chance to sort of weigh in on this, is we're working on the potential shortening of the 20 business day tender offer rule. It's something that we've always wanted to do, and again, since Jim's here, we're going to really try to push it through. When Jim got here, we were all like, oh my goodness, like Jim's here, so we can now do some of this stuff. M&A stuff doesn't always get the top billing at the commission, but he's here. So we've engaged with many firms and investor groups and whatnot. We're looking to shorten that, both in equity tender offers as well as debt tender offers. It's something that the staff has done for years. We did the last one in 2015 with the abbreviated tender offer, debt tender offer letter. But if you can go back to the letters, the staff have been shortening these periods going back to the 80s. So I think it's just, again, time to build on the success.
Well, Ted, great work. You, Tiffany Posel, Jeb Byrne, Michael Coco. I mean, you got a lot on your plate. I really appreciate it. I know we got some questions that came in, but we do want to cede it to the commissioners because I know they're chomping at the bit to ask us something.
Well, again, thank you very much. I'll say, like, the rulemaking sounds amazing. I don't want to sort of gloss over what Christina said about sort of these blockbusters, and especially what you said about 14.8. I think that's exceptional, sort of going back to the roots of whether, the grounding of it. And then Luna, amazing on all that, and including on, super excited about accredited investor. I think, that was sort of the contemplation in 20 when, people should come and talk about what is sort of a good way to think about, being able to invest in these, and money's not a good proxy. And then Ted, I just want to say, even the way you talk about the proxy plumbing and frankly about the retail voting program, and the point which is like they're getting the same rights and opportunities they always had, and it's a true evolution in this. I think it is a really exciting time for this. I have a question I'd like to ask about sort of the great work on SK and SX that you've talked about, and then quickly on 14.8, the season. I know the comment period for SK is coming up in April. Some of the things that, folks have been wondering is this supposed to be more of a nibble on the edges sort of approach, or are you looking for more wholesale suggestions, to the point of even striking certain things?
Yeah, I'll just say everything's on the table right now. Like I said, we're taking a look, even just internally now, as we're waiting for comments to come in, and looking at, okay, are certain provisions statutorily required, right? I mean, it's really just back to basics, and we're starting with what the rule on the books is, but I think it's definitely a review in terms of, okay, is this disclosure necessary? Is it providing material information to investors? Is the burden of producing the information greater than the benefit of providing the information? So definitely not looking to nibble around the edges. I feel we'd be misleading, maybe even materially misleading, if we were calling the rule proposals blockbusters, and that's all we were looking to do.
I want to let Commissioner Casey go.
No, you want to start with 14.8?
Sure. I mean, it's been a very fascinating 14.8 season, to say the least, I think. What are sort of anything that the staff has observed from this season that you may have not expected, or is this sort of how you envisioned it, given 14M and all of that?
So I think this is an unusual season for 14A8. The division director put out a statement in November due to circumstances beyond the division's control. We had to focus on transactional filings, which meant not pulling together the task force of 14A8 reviewers this season and just kind of let private ordering take its turn here. We did have the 14A8J requirement, 14A8 Jim letters, as we're calling them. You write in and you have to provide notice to the commission that you're excluding and on what basis. So I'll say we had about 180 of those notices submitted. I think we're probably at the tail end of that. They're not coming in like they were. And given timing of the usual annual meeting season for calendar year and companies, we'd expect that those are pretty much dried up by now. I think it's too soon to really draw conclusions based on that number because we haven't seen all of the proposals that have been presented to shareholders at meetings. We don't know how many were withdrawn, but that's the latest stat that we have available. And I think that likely as we get through April and May, maybe not from us, but others will certainly be able to draw some conclusions based on meeting results and proposals that go up for a vote. So a couple of just like anecdotal observations in addition to that. I think, we obviously there was a lot of surprise, I think, both from issuers and from proponents when that notice came out. Again, nobody really knew what to expect. I think the lawsuits were inevitable. That's always been a right of proponents and companies to get a binding determination on a 14E8 interpretation. But we did hear from some that there was sort of increased engagement and maybe willingness to negotiate because the SEC wasn't refereeing this season.
I'll add that we have taken so many meetings, CII, Business Roundtable, Society of Corporate Governance. We've also listened to the proponents. We've listened to the activists. They've all come in. We've taken multiple meetings, ISS, Glass Lewis. So this is an open door division and commission. We are listening. We're not just doing things without taking into account what folks have to say. So we're trying to make informed decisions based on, real-time data.
Yeah, just so appreciate that very much, and maybe just kind of put a finer point on it, which you've kind of highlighted already, Christina, is given the unique nature of 26, right, and how that impacted the ability of the division to provide opinions in the 26 proxy season, how should issuers and shareholders be thinking about the role of the division in the future?
I think that we're going to, at the end of this proxy season, look at the data, and Michael Seaman leads this, and he's keeping close track of it with his team, Matt McNair, Emma O'Hagan, Anna Abramson, Jenny Choi. They're still monitoring it when they give these letters out, and I think we're going to see what the data shows us. But if I were a betting person, and maybe this was a Polymarket or a Kalshi type of thing, I would say that the stats are going to look pretty much similar to last year, the prior season. There was a lot of fear-mongering that everybody's going to include their proposal or no one's going to include the proposal. And so despite all the pundits' prognostication, I think that at the end of this season, we're going to see numbers that are very similar to last year. Well, I know they wanted us to keep it tight, 10:35. Is the time, and we want to end it and thank my fellow panelists. And for those who we didn't get to your questions on the little iPad here, we'll be in the room and we'll be putting out CFIs, Corpin Interps, so stay tuned. Thank you, everyone.
Okay, I'm going to go ahead and introduce the next speaker as this wonderful panel disembarks from the runway. I will say if the accredited investor exam does become the rule of law, that we maybe have the possibility of a whole set of golden books for the people who will be taking those exams. So stay tuned. And now I am very excited to announce our next speaker, or introduce our next speaker and announce Hester Pierce. She is on year 8 of being an SEC commissioner. She was designated a little over a year ago to be the crypto task force head, and she has been traveling the states to include every voice possible as she assesses and recommends to the commission actions on this crypto task force. Prior to coming to the SEC, she conducted research on regulation of the financial markets at the Mercatus Center at George Mason University. She also was a counsel to the Senate Banking Committee, and she was counsel to Chairman, then Commissioner Paul Atkins, and was a staff attorney at the Division of Investment Management. Hester is a very accomplished and energetic commissioner. I think she also maybe is a very long-tenured commissioner, which is amazing, and that continuity has been great. She is known as the crypto mommy, probably no surprise to anybody in this room, and I would like to welcome her to the stage. Hester.
Well, it was an honor to be introduced by Laura Unger. Thank you, Laura. I do not feel energetic this morning, so take that for what it's worth. But anyway, thank you all for being here, and I have to give you my disclaimer, which is that my views are my own views as a commissioner, not necessarily those of the SEC or my fellow commissioners, and you all can be happy, and I can be happy that that is the last time I'm going to have to make this disclaimer at SEC Speaks. Since we met at this event a year ago, the Commission has been very hard at work. I think you heard about some of that just now from Corpin. We've been taking actions large and small to fulfill our mission. Among other things, we've been focused on providing crypto clarity and facilitating capital formation, 2 areas that I think were in need of Commission attention. But today I want to discuss a different topic, and that is the limits of our disclosure rulemaking authority. Authority should be front of mind for regulatory agencies in Washington, particularly in light of Supreme Court cases like Loper-Bright and Corner Post. The SEC, though, should pay particular attention to the topic of statutory authority, because we have a graveyard of rules that has been vacated or remanded by courts, and that graveyard is filling up fast. Understanding and remaining within our statutory boundaries is an essential element of good regulatory work and part of our constitutional duty. Before turning to the limits of our authority, however, I want to ask you to humor me by considering a question. If you had to describe the Mona Lisa to someone who'd never seen it, what would you say? A half-length portrait of a woman? Wouldn't you need to add that her smile is slight and her eyes seem to follow you wherever you go? But that description really isn't sufficient to convey what Mona Lisa is. What else do you need to say? You might want to reveal the artist's name, Leonardo da Vinci. Perhaps you'd explain that the subject's gaze is off-center and that she stands in a 3/4 profile with her right hand resting on top of her left. You may also need to note her resemblance to contemporary depictions of the Virgin Mary. What about the background, a debatably imaginary landscape that was anomalous for portraits at the time? And perhaps you'd mention the modest dimensions of the portrait, which seems to shock visitors to the Louvre when they look at it. You might also want to reveal that the subject of the painting is probably Lisa del Giocondo, a Florentine woman of the 15th and early 16th centuries. I could keep going, but I think you get the point. Describing a work of art requires choosing among different things to convey to people, and knowing when you've adequately described something is difficult, and maybe the person you've described it to won't even think that you've described it adequately once you're done. At the SEC, we don't deal with paintings, we deal with public companies, and we don't deal with brush strokes, but with financial statements. Nevertheless, we encounter the same problem. We tell public companies to describe themselves. One could say a lot of things about a company to describe it, but what type of description accurately captures a public company's essence? More precisely, what should the Commission, as a regulator, mandate that companies disclose about themselves? In assigning you the task of describing the Mona Lisa, I left out an important guidepost for you. I didn't tell you who your audience would be, other than saying that it was someone who hadn't seen the painting before. So you probably assumed that you're describing the painting to an average person with an ordinary interest in art. But your description might have changed if you were speaking instead to an art historian working on a book about cultural context, or craquelure, which is a new word I learned, an archivist for whom special elements in need of preservation would have been most interesting, a reader of the Da Vinci Code who's looking more for what's hidden than what's revealed, or a climate protester who needs to figure out how to aim her pot of pumpkin soup. If you're going to succeed at the mission of describing the Mona Lisa, you need to know to whom you will be describing the painting. Similarly, if public companies are making disclosures, they need to know who the intended audience is, and the SEC, as crafter of those disclosure mandates, also needs to know. Only then will the disclosures meet the audience need. And Congress actually did a much better job than I did when I assigned to you the Mona Lisa exercise. Congress told us to whom securities disclosures should be aimed, and that is investors. But not only did Congress identify investors as the intended audience for public company disclosures, but Congress also gave us examples of the type of disclosures this economic, return-loving, and risk-sensitive audience would need. I reiterate that Congress focused its statutory assignment to the SEC better than I did to you. For example, disclosure required by Securities Act Section 7A is enumerated in Schedule A, which contains 32 unique items that constitute the information a registration statement should contain. Schedule A focuses on providing investors with the essential facts of the counterparty, management of the issuer, and the price of securities being sold. Similarly, Section 12 of the Exchange Act requires disclosure by companies that, among other things, register securities on a national securities exchange. Those disclosure requirements cover topics such as the fundamental nature of the business, its financial condition, and its securities. Congress sometimes permitted the Commission to add to the statutorily mandated disclosures, but the authority always had strict limits, and any disclosure under the securities laws should serve a fundamentally economic purpose. Andrew Vollmer explained that the statutes, quote, limit the SEC's power to issue disclosure rules to specific types of information closely related to the disclosing company's values and prospects for financial success. The statute's emphasis on financial matters focuses the Commission's efforts in a way that is consistent with the needs of its investor audience. But what is an investor? The dictionary tells us that an investor is one that seeks to commit funds for long-term profit with a minimum of risk. An investor, then, whether an institutional investor or a member of one of the nearly 60% of American households who invest in our markets, is someone who cares about economic returns and risk. The pursuit of risk-adjusted economic returns is the common thread running through an otherwise diversely motivated population. Knowing that investors, despite the many other things that matter to them, all share an interest in risk-adjusted economic returns guides our disclosure mandates. The Commission's disclosure work should focus on, as Professor Sean Griffith puts it, investors qua investors. As Griffith explains, quote, understanding financial return as the core concern of investors clarifies the limits of the SEC's authority to regulate for the purpose of investor protection. The reasonable investor who shows up in the classic materiality cases from the Supreme Court has her eyes trained in an unwavering Mona Lisa-like stare on risk-based financial returns. Commissioner Roisman put it this way, quote, while any given shareholder may have bought securities for reasons other than or in addition to making money, it seems clear that a reasonable investor is someone whose interest is in a financial return on an investment. While it's not unreasonable to consider non-economic factors when investing, a person is an investor because she does consider economic returns. She may be thinking about other things too, but the common element of investor status derives from her consideration of economic returns. Fulfilling our foremost policy objective of protecting investors requires us to ensure that investors have access to material financial information. Companies, of course, are free to disclose information to satisfy the non-economic interests of investors and non-investors, but the Commission is not free to mandate such disclosures unless, of course, Congress explicitly tells us to do so. Congress generally keeps the Commission focused on serving investors qua investors, and that limited mandate focuses our discretionary disclosure efforts solely on material information. Just as some in-person Mona Lisa viewers are shocked by the diminutive size of the portrait, there's some folks who are shocked by the diminutive size of our statutory authority. Advocates of broad disclosure authority point to references in Section 7A of the Securities Act and Section 12B of the Exchange Act to necessary or appropriate in the public interest or for the protection of investors. This broad language, they contend, reflects a congressional delegation of, quote, the difficult task of keeping up with the rapid evolution of financial markets and of regulating those markets to a specialized agency, the Commission. Congress cannot delegate, of course, without bounds, and the Supreme Court has made clear that public interest has to be read in the context of our mission. Public interest and investor protection have specific meanings derived from the statutory context of the Securities Act and the Exchange Act. Divorced from their context and from the textually based purpose of the securities laws, those words would empower the SEC to be the only regulator in town. We could use disclosure mandates to shape corporate behavior in areas like employee and customer rights and environmental and social practices. Hence, no matter how broad the language, it never extends beyond our mandate. The Commission stated as much in 2016 when it said that, quote, disclosure relating to environmental and other matters of social concern should not be required of all registrants unless appropriate to further a specific congressional mandate or unless, under the particular facts and circumstances, such matters are material. In doing so, it echoed the Commission's 1975 view that the discretion vested in the Commission under the Securities Act and the Securities Exchange Act to require disclosure which is necessary or to consider appropriate in the public interest does not generally permit the Commission to require disclosure for the sole purpose of promoting social goals unrelated to those underlying these acts. Bernard Scharfman described the phrase "in the public interest" as, quote, an empty shell of a policy objective, a non-ascertainable standard when standing alone that does not provide an agency with guidance on its mission or a reviewing court the boundaries of delegated authority that it can use in its review. The ascertainable standards with which the shell must be filled, argues Scharfman, are two policy objectives, investor protection and promoting efficiency, competition, and capital formation, and one, what he describes as a soft policy constraint, materiality. Whether one thinks of them as policy objectives or directives, investor protection and promoting efficiency, competition, and capital formation may be in tension at times, but also can work in tandem. The second directive derives from NISMIA, which directed the Commission when making a public interest determination to consider, in addition to the protection of investors, whether the action will promote efficiency, competition, and capital formation. Professor J.W. Verrett makes the point that an immaterial disclosure requirement would have trouble, quote, surviving the kind of cost-benefit analysis contemplated by NISMIA. NISMIA makes clear that costs matter, but mandatory cost consideration is baked into the Commissioner's investor protection objective or directive. Disclosure demanded by a subset of investors hits the pocketbooks of all investors in the company. Costs include not only the time of lawyers and accountants to prepare those disclosures, but also the time and attention of company personnel devoted to tracking, verifying, and reporting information, and then, of course, the potential litigation costs and competitive costs of making disclosures. Forced disclosures can substantively change how companies behave. They can also empower people who seek to harm a corporation. The Commission needs to be aware that demanders of disclosure may not be acting in the best interests of the reasonable investor. As Professor Griffith notes, quote, protecting investors qua investors means protecting them from the concerned citizens and from groups of investors, even majority groups, with opposing interests. So even if information is material, mandating disclosure of it may not be consistent with our statutory obligations if the direct and indirect costs, which are borne by investors, of producing it outweigh the benefits to investors of consuming it. If we're taking our statutory obligations seriously, why would the SEC, of its own volition, mandate disclosure of information that is not material? By definition, immaterial information costs more to produce than it is worth to the investors for whom it's being produced. If information is not material to the reasonable investor, is the resultant investor protection benefit is de minimis. For materiality to be an effective check on impermissible disclosure mandates, we have to treat it with respect. What does that mean? First, materiality determinations require judgment by a company, its lawyers, and its auditors. Investors, regulators, and courts will continue to scrutinize those determinations and at times take issue with them. Regulators should not, however, substitute their judgment for companies making materiality judgments in good faith. We cannot short-circuit that company-specific judgment with one-size-fits-all prescriptions on all manner of topics. Second, materiality modifiers do not cure prescriptive rules. In fact, materiality qualifiers and rules are often definitionally discordant with our statutory understanding of materiality, as we saw in the climate rule. Third, we should guard against what Meredith Cross calls fuzzing up materiality. Materiality is used for reporting in other contexts, but it does not necessarily mean the same thing that it does in those contexts as it does under our securities laws. That definitional slippage complicates materiality analyses under securities law. Fourth, straining or ignoring materiality could turn us from a disclosure regulator to a substantive regulator. Commissioner A.A. Summer explained 50 years ago when the Commission was under a lot of pressure from various directions to expand its disclosure mandates. And he said this: "The value of the concept of materiality derives from its very breadth, imprecision, and defiance of exact definition. It reflects the complexity of human affairs, the multitude of situations in which human beings find themselves involved, and the multiplicity of relationships that they create." But he also cautioned and said this: "It's extremely important to keep in perspective what the disclosure documents filed with the Commission and circulated to investors are supposed to be. If the enforcement of the disclosure laws becomes in effect a substitute for the enforcement of other substantive laws, then I would suggest that the Commission has been diverted from its true mission, which is to provide information to investors about matters that are likely to impact the future prospects of the corporation, as well as historical information. A deeper commitment to disclosure rules that enable reasonable investors to obtain the material information they need in pursuit of economic returns will help us stay within the lane that Congress set for us. Limits to authority may seem unwelcome for a regulator, but I actually find them quite useful. They help us to shepherd our resources well. The most valuable of those resources is, of course, our brilliant and talented staff. If the Commission directs the staff to work on things outside of the SEC's authority, the staff have less time to work on the important mission that Congress entrusted to us. Moreover, a successful legal challenge would eliminate the fruits of any of that work. Empowering our staff to write and enforce sensible rules within our authority is the best way to steward their time and to protect investors. So now let me end where I started, with a disclaimer. And that disclaimer is that while I certainly did not address all the arguments in this debate, I hope that you, the reasonable audience, are satisfied that I hit a few of the material points. Thank you, and enjoy the rest of your day.
We are on a break until 11:15, when we'll resume with Commissioner Ueida's remarks.
Good morning. At this time, we would kindly ask that you please take your seats and silence all devices as our program is about to begin. Thank you.
Ready? Okay, welcome back. Hopefully everybody refueled or refilled their coffee cups so that they can keep cadence with the ACT count. And I have been told there's another beverage later in the day that will be counted towards the ACT mentions. So look forward to that and stay tuned. Right now, I have the distinct pleasure of introducing a friend and colleague, Mark Ueida. Mark was sworn in as a commissioner in June of 2022. He looks so young. He was acting chairman of the agency from January through April of 2025. Prior to that, Mark has been all over the capital markets, regulations, and the government. He spent 2 decades at the SEC. He was also a detailee to the legislative and executive branches, a policy advisor to senior leadership at the Department of Treasury, the Department of Labor, and a senior advisor to Chairman Jay Clayton, counsel to Commissioners Piwawar and Paul Atkins, and assistant director and special counsel of the Division of Investment Management. Before all of that, which is a lot, Commissioner Ueida served as chief advisor to the California Corporations Commissioner, where he was appointed by Arnold Schwarzenegger in 2004. I feel like I should make a comment, but I'm not going to. Please join me in welcoming Mark Ueida.
Well, good morning, and thank you so much for that, Laura. Well, it's great to see so many of you. Now, this is SEC Speaks. If you're looking for the Fire Engineering Conference, that is the floor above. But it would have been appropriate, I think, for me to speak at that conference because at least a year ago, when the new administration took office, there were so many dumpster fires at the agency. I mean, so many to have to put out. Somebody who's been at the agency for 20 years, I mean, I thought I'd seen kind of where things might land, between two possible ranges, and it was a lot of them are well beyond that. So anyway, the good news is now under the leadership of our chairman, Paul Atkins, and I think we are back to how the commission has traditionally thought about the securities laws. And we still have some hot spots we need to put out, but most of the dumpster fires have been extinguished. So now we can move on to something that is much more forward-looking, such as this year, where America will celebrate the 250th anniversary of the Declaration of Independence. a document that came into existence during a period of transformational thinking about the relationship between the people and how they are governed. In an era of European monarchies and the divine right of kings, the idea that those in government derive their power from the consent of the governed was a stark departure from the status quo. The Declaration, as penned by Thomas Jefferson, declared to the world that certain truths were self-evident. People are endowed with certain unalienable rights. Among these unalienable rights are life, liberty, and the pursuit of happiness. Jefferson adapted this important phrase from John Locke's Two Treatises of Government, in which Locke identified life, liberty, and property as foundational natural rights. Scholars have long hypothesized on why Jefferson replaced property with the pursuit of happiness. Today, though, I want to reflect on what this small but meaningful adaptation means for us today, and specifically what that means for the Commission. The pursuit of happiness. It is a more elastic and somewhat more amorphous concept than property, but perhaps the most distinctly American idea in a document full of them. It is not a guarantee of happiness. It is not the government's obligation to deliver happiness. It is the right to pursue happiness, to start a business, to choose your occupation, to risk your capital, and to reap the rewards or absorb the losses of your own decisions. Although the SEC did not exist during the earlier parts of American history, the ideals that underpinned America's foundation should continue to guide how we think about opportunity, accountability, and the proper limits of government action. The Declaration reflects a broader American belief that Americans as individuals are not bound to the circumstances of their birth or class in society. It is forward-looking and not wedded to the past. The pursuit of happiness, one's chosen vocation, ambition, or enterprise, is not predetermined by lineage. It embodies the notion that each generation can forge its own path through self-determination and agency. Free enterprise, innovation, and entrepreneurship are not afterthoughts to the American experiment. They are woven into America's DNA from the very beginning. 250 years later, the freedom to choose your own direction remains one of America's most powerful promises. What transformed the pursuit of happiness from an aspiration into actuality was the development of America's capital markets. During the 18th century, the Dutch operated some of the most advanced capital markets for their time. Perhaps it is not surprising, in a city founded as New Amsterdam, that less than a decade after the end of the American Revolution, 24 stockbrokers would sign the historic Buttonwood Agreement that would give rise to the New York Stock Exchange. The ability to raise capital played a pivotal role in facilitating America's evolution from an agrarian society to the world's leading economic power. But capital comes at a cost, and effective regulation can lower the cost of capital. Investors may be willing to take certain risks with a potential investment, particularly if it's part of a diversified portfolio. But investors do not want their money stolen or to be misled about the risks, return, financial condition, or prospects of an investment. If the capital markets are rife with bad actors, investors will either not invest at all or demand higher returns to compensate for the added risk of fraud. Either way, even legitimate and honest companies will face a higher cost of capital because of the presence of bad actors. Over time, Congress recognized that regulation and oversight of the capital markets could benefit economic growth and enacted the federal securities laws. However, rather than having government bureaucrats engage in merit review of securities offerings, similar to how various state securities laws then operated, Congress created a statutory framework with the Commission serving as a disclosure-oriented regulator. Hence, it is not the SEC's role to decide which ideas are worthy of capital, which business models are viable, or which entrepreneurs deserve a chance. That is the market's job. Our responsibility is to ensure that investors have accurate, honest, and financially material information to make those judgments for themselves. As a result, a company with unproven technology and a long road to profitability, can still access America's public markets so long as it tells investors exactly what it is and what are the risks. Some will be successful in executing their business plans, while many others will fail. The risk of failure, however, is an important, integral, and expected part of the process. Markets reward enterprises that create value and take away resources from those that do not, in ways that no regulator or central planner could ever replicate. Capital allocation in the free markets, despite periodic booms and busts, often channels resources to new ventures that can challenge incumbents. Opportunity is available, albeit at times imperfectly and unevenly, to those with the ideas and determination to pursue them. And the results speak for themselves. America's capital markets have powered every chapter of this country's economic ascent from westward expansion to the modern technological era. The Commission has a responsibility to preserve and strengthen that tradition, and we are working on meaningful steps intended to revitalize the public markets. Post-Enron reforms, although well-intentioned, have had the effect of making initial public offerings less of an avenue where companies can raise capital and broaden ownership among the public, and more of a liquidity event for insiders and early-stage investors. As we seek to incentivize more businesses to IPO and increase the pool of public companies, it is worth assessing whether the current SEC regulatory regime is conducive to going and staying public. In this spirit, we are working to modernize the shelf registration process to reduce compliance burdens and further facilitate access to capital. Shelf registration provides significant advantages and flexibility for eligible companies to manage capital and liquidity needs. By using shelf registration, companies can offer securities to investors when market conditions become favorable. On the flip side, companies will also have the ability to quickly secure funds in stressed market conditions, essential for maintaining operations or servicing debt. The staff has also been instructed to engage in a comprehensive review of Regulation SK to assess the effectiveness of current disclosure requirements and to consider permitting companies to change their periodic reporting cycle from quarterly to semi-annually. There are a few other examples where we may be able to improve disclosure requirements so that they are relevant and efficient. For example, we should revisit the thresholds for being an emerging growth company and smaller reporting company. For too long, the disclosure framework for public companies was built around a one-size-fits-all model that imposed the same disclosure burdens on smaller companies as on a large, seasoned conglomerate. Recalibrating the EGC and SRC thresholds is not a matter of lowering standards. It is a matter of ensuring that regulatory burdens correspond to the size, sophistication, and regulatory risk profile of each company, and that smaller issuers are not driven out of the public markets before they've even had an opportunity to grow into them. Taken together, these reforms reflect a simple conviction that vibrant public markets require on-ramps, not obstacle courses. But public markets do not thrive in isolation. The public and private markets coexist in a symbiotic relationship. Private markets have always been the seedbed where ideas become businesses from which the public markets draw their most dynamic companies. For much of modern history, private markets have incubated companies that were not yet ready for the public markets, which at some point in the future, when they were at a more mature stage, then went public. The question is not how to choose between them. It is how to allow everyday Americans to have exposure to the opportunities that exist in both markets. Until now, the benefits of private market investing have been reserved for institutional investors, the pension funds, endowments, family offices, and sovereign wealth funds, while retail investors saving for retirement have been effectively excluded. The disparity is difficult to ignore. The teacher or firefighter whose retirement is managed by a public pension fund has benefited from meaningful private market exposure for years, if not decades. The private sector worker saving through mutual funds in a 401k plan has not. In an environment where public market securities are becoming increasingly correlated and concentrated, exclusive reliance on such securities may no longer provide the diversification that retirement savers need and deserve. Private assets such as private equity, private credit, venture capital, infrastructure, and real estate can enhance overall performance returns and reduce volatility when included as part of a diversified portfolio. The argument against allowing retail access is familiar. Private investments are illiquid, complex, and sometimes unsuitable for retail investors. But this framing gets the analysis backwards. Retirement savers are often long-term investors, and private investments can offer a premium for that illiquidity. For long-term investors saving for retirement, this trade-off can not only be acceptable, but desirable. The notion that a zero allocation to private assets is somehow inherently safer or more desirable than a diversified allocation is not investor protection. It is not the government's role to impose its judgment as to what opportunities investors may pursue, particularly when those choices are often being made by a fiduciary. The Commission is working to change that. We have already taken steps in that direction, including lifting the 15% cap on investments in private funds for closed-end funds. We are also actively engaged on how to expand retail investor exposure to private markets. We are working to ensure that the SEC and the Department of Labor are aligned in providing fiduciaries the regulatory clarity and safe harbors they need to prudently include private assets in defined contribution plans, because access alone is not enough if plan sponsors are deterred by litigation that second-guesses good faith decisions with the benefit of hindsight. Now, the Declaration of Independence also stated that the unalienable rights of life, liberty, and pursuit of happiness must be secured. So how should that apply in the context of the SEC and the capital markets? It means that our role is not to stand between Americans and their economic aspirations in the name of protecting them from themselves. Instead, it means that our job is to build and maintain the infrastructure that makes free markets possible. Clear rules, honest disclosure, and timely accountability for fraud and manipulation. It means that when we adopt rules, we should ask not only whether they prevent harm, but whether they preserve freedom for investors. Capital markets are not perfect, and the cost of capital can increase dramatically in markets that lack rules and safeguards. A free market without proper oversight lacks the tools to prevent and address fraud, insider trading, market manipulation, and market failures such as monopolies that stifle competition. Capital markets will fall far short of their potential if there is a significant lack of transparency and information asymmetry. Investors, those persons who put their capital at risk, will simply withdraw. However, investor protection does not mean that government ought to engage in paternalistic control. Innovation cannot wait indefinitely for regulators, and we cannot suffocate innovation under the guise of investor protection. When the Commission fails to provide workable regulations, markets do not stand still. They'll move elsewhere. And when they move elsewhere, investors lose, competition suffers, and the Commission's credibility as a forward-looking regulator is diminished. Nowhere is the Commission's stifling of innovation more apparent than in its recent treatment of crypto assets. The United States had the opportunity to lead the world in building a regulated, transparent, and competitive crypto asset market. However, rather than engaging seriously with the question of how existing securities laws apply to these novel asset classes, the Commission chose enforcement as its primary regulatory tool. Exchanges that sought to register were turned away or left in regulatory limbo. Token issuers who asked for guidance received subpoenas instead. Lenders and custodians who tried to engage with the Commission in good faith were met with litigation. The message was unambiguous. Don't bother trying to comply with the SEC rulebook. American investors were left with fewer regulated options, not more, and they did not stop participating in crypto asset markets. They simply did so on platforms and in venues abroad and outside the reach of the U.S. securities laws. Regulation should not predetermine outcomes or restrict participation under the assumption that individuals are incapable of making informed choices. Instead, the role of the regulator should be to create conditions in which investors can make informed decisions, entrepreneurs can raise capital honestly, and markets can allocate resources efficiently. Innovation in financial markets has always required regulatory clarity. The development of money market funds, exchange-traded funds, and electronic trading all required the Commission to grapple with novel structures for their time and to adapt our rules accordingly. In each case, the Commission's willingness to engage led to markets that were broader, more liquid, and more accessible to a wider investor base. The proof of these principles is visible in the work that the Commission has completed during the past year and in the work that lies ahead. We've granted exemptive relief to asset managers to offer mutual funds and ETFs, to offer share classes in a single fund. We granted exemptive relief that would allow 24/7 trading and instant settlement for tokenized shares of a money market fund, all within the regulatory perimeter of the Investment Company Act. We have also proposed amendments to the rules that define which funds and advisors qualify as small entities for purposes of the Regulatory Flexibility Act, in an effort to reduce the regulatory burden on smaller market participants. We have forthcoming rulemakings that will be consequential. We are actively exploring how to expand retail investor access to private markets. We are developing an innovation exemption that would facilitate limited trading of certain tokenized securities. And after years in which the Commission's misguided posture towards crypto assets was defined by regulation by enforcement, we are now building a proper regulatory framework for them. We are also thinking about potential changes to the custody rule to accommodate the advent of new asset classes and different types of custodians. Moreover, the staff is conducting an ongoing evaluation of whether legacy rules continue to reflect market realities or simply persist by inertia. 250 years ago, America embarked on an experiment in democracy. The founders had seen what happens when the state appoints itself as the arbiter of which enterprises are worthy, which ideas deserve capital, and which individuals may pursue their ambitions. The founders built something different, based on the principle that government exists to secure the conditions for human flourishing, not to determine its content. It is this liberty that has allowed the United States to move ahead of global competitors and achieve economic prosperity and innovation. The United States remains the land of opportunity, not as a slogan, but as a lived reality for millions who have pursued careers, businesses, and ideas far different from the generations before them. The Commission's tripartite mission is to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. Each part of that mission matters. Protecting investors means requiring honest disclosure and accountability for fraud. Maintaining fair markets means setting clear, consistent, and predictable rules. Facilitating capital formation means keeping the pathways to capital open for both established companies and the untested startup alike. When we allow any one of them to crowd out the others, we lose the balance the founders understood intuitively, that freedom and protection go hand in hand. Today, the Commission is working to restore that balance and rejuvenate the spirit of the Declaration of Independence in our markets. Every entrepreneur who raises capital is exercising the freedom America's founders envisioned. Every investor who risks his or her hard-earned dollars on a new company is affirming the principle of self-determination. Every market transaction freely entered into is a small act of independence. What is at stake is larger than any individual rulemaking. The United States has led the world in innovation and capital formation, but that edge is not guaranteed. America's next 250 years will be shaped by ideas we have not yet heard of, building things we cannot yet imagine, and in markets that do not yet exist. The Commission's job is to make sure that an honest, efficient, and open infrastructure is there when they arrive, to ensure that the pursuit of happiness remains exactly what the founders intended it to be, a right that belongs to everyone willing to pursue it. So thank you very much for the opportunity to speak with you this morning. I'd also like to thank the Commission staff who have put an enormous amount into organizing this event and preparing the presentations for this program. Their dedication to the Commission's mission helps maintain the robust capital markets that afford opportunities for everyone. And don't forget to check your smoke detectors. Thank you.
So I'm not sure if Mark actually said this, but I think he's mentioned the pursuit of happiness and the capital markets, and therefore the happiness is money or earnings or profitability, and I would agree with that. So that was a deft tie-in. Right now, I am pleased to introduce the next panel, which is the Division of Economic and Risk Analysis. When I did work on the Senate Banking Committee, as most of us have, Senator Phil Gramm was very apoplectic about the fact that there were no economists at the SEC, and therefore there was no real risk-benefit analysis of rulemakings. So beginning way back and continuing until today, I think the significance and importance of that division has built up, along with the number of economists that are now involved not only in cost-benefit analysis, but also risk analysis. So this is a wonderful development. And I would like to welcome Dr. Joshua White, who became the chief economist and director of DERA just a couple of short months ago. Welcome. But like all of us, he was at the SEC before, between 2012 and 2018, conducting cost-benefit analysis of the rulemakings while in different DERA roles. Prior to that role, becoming the SEC chief economist, Dr. White also served in the Office of Economic and Risk Analysis at the PCAOB, where he was a senior advisor until he became acting chief economist in April of 2025. Joining the panel as a commentator is former Commissioner Cynthia Glassman. She did not come from the Senate Banking Committee, but that's good for diversity of thinking. She and I kind of went through the revolving door. I left, she came, and she served from 2002 to 2006, and as acting chairman during the summer of 2005. As the only commissioner with a doctorate in economics at the time, Commissioner Glassman offered a unique perspective that was extremely helpful in her demand for rigor in the regulatory process. She then served as Undersecretary for Economic Affairs at the Department of Commerce from 2006 to 2009. In that role, she served as the Principal Economic Advisor to the Secretary of Commerce. Dr. Glassman is a member of the board of Discover Financial Services, where she chairs the audit committee, and is, I think, recently a member of the Dow Jones 5-person special committee, which is an independent body charged with safeguarding the editorial independence of the Wall Street Journal and Dow Jones. So,
is this on? No.
You have a correction?
Okay. Oh, now it's on. I retired from the board of Discover a couple of years ago, and now Discover has been bought by Capital One. So I'm not on the board of Discover.
You're not there. Okay, so I thought that. I checked with ChatGPT, and I'm going to tell you I got bad information. I know. How else am I going to know? 2024 was the last proxy you were in, but it was inconclusive. So here you go, a real-life example of not relying on ChatGPT for your information. So in any event, I still welcome former Commissioner Glassman and the panel. Thank you very much.
Make sure this is on. Okay. Good morning, and thank you for the kind introduction. It is a pleasure to be here today. Before I begin, let me give the standard disclaimer on behalf of all the DERA speakers. Today's remarks are provided in the speaker's official capacities as members of the Commission's Division of Economic and Risk Analysis, but they do not necessarily reflect those of the Commission, the commissioners, or other members of the staff. Okay, so the SEC is a market regulator, and economics studies how markets function. Thus, DARA is involved in all aspects of the SEC's mission. You can sort of think of it as the SEC in a microcosm. So DARA has a four-part mission. We support economic policy. We support examinations and enforcement and analysis. We do data management and analysis, and we do risk analysis. DARA is made up of approximately 170 individuals consisting of economists, data scientists, statisticians, lawyers, and other professionals. Most of DARA are economists, and the majority of whom hold PhDs. And this kind of expertise allows us to provide high-quality economic analysis on issues related to all parts of the SEC's mission. So in order to provide that economic analysis, the division relies upon data. It is very important to us, and you'll hear quite a bit about it from the other panelists. We encourage market participants in your comments on our upcoming rule proposals to also provide data. There are times when commenters possess unique data. They can be metrics, they can be surveys that can inform uniquely our rulemaking proposals. This type of evidence from industry participants can reveal information that our public filings do not. It can show us where our rules work, where our rules fall short, or where they may need to be modernized. So we encourage commenters who possess this type of information to submit it to the comment file. Comments supported by evidence help us ensure that our rules are informed by the facts on the ground. So as we look ahead to these proposals in this robust rulemaking agenda that we have, we encourage you to also provide rigor in the comment process. That means if you share data on both costs and benefits when you have it. You clearly state any assumptions that go into the generation of that data, and that you proactively share survey evidence that can uniquely quantify things that other data cannot. It also means separating one-time implementation costs from ongoing expenses and explaining how a rule may impact or that data can shed light on unique firms that operate based on size, based on the industry, their business model, or their investor base. Now, to the extent you have proprietary concerns, you can aggregate and anonymize data, and that can still provide us with substantial insight without revealing competitively sensitive details. Now, some may ask whether data and evidence truly matters to the rulemaking process, and I'm here to say that it does. Economic analysis informs staff recommendations and helps the Commission determine whether adjustments need to be made between the proposed rule and a final rule. And so to us, the comment letter is not a formality. It is central to the rulemaking process, and it is paramount to have evidence-based policymaking. In our view, better information from commenters leads to better analysis, and better analysis leads to better rules, and better rules promote and enhance the continued strength of the U.S. capital markets. Okay, so in a few minutes, you're going to hear from my colleagues about some interesting work that DARA is conducting. So first, Enrique Lopez is going to give an overview of U.S. capital markets. Next, we will have Wei Lu, who will give a demonstration of our new statistics and data visualization page. Following Wei, Vlad Ivanov is going to go over some IPO and exempt offering trends. Julie Marlowe is going to discuss how to get good information out of AI by using structured data. And then finally, Bill Young will talk about the economics of insider trading. So thank you again, and let me turn it over to our first speaker, Enrique Lopez from the DARA's Office of Risk Analysis.
Thank you, Josh. That was a very nice introduction, and I hope that we can kind of break up some of the more verbose presentations here with a little bit of data for you guys to look at. So as he mentioned, my name is Enrique Lopez from DARA, the Division of Economic and Risk Analysis. Today I'd like to talk a little bit about capital markets and non-bank financial intermediation and how those two are sort of support each other and intertwined. So at the Commission, capital markets, as we see them, include any marketplace where participants can buy and sell financial assets such as stocks, bonds, or other securities. Capital markets facilitate the transfer of capital from those who seek a return on their assets to those who need capital in order to grow their enterprises. Capital markets, put simply, are the way we connect providers of capital, investors, with those who seek capital, companies, or governments. If we look a little bit at the data here, you can see that the U.S., the data sort of underscores a dominance that the U.S. has within global finance. Looking at fixed income securities, you can see that the U.S. represents just over 40% of total global fixed income securities outstanding. With respect to the global equity market cap, you can see the U.S. is just about 49.1% of that global number at $62.2 trillion US dollars. And just lastly, the GDP, looking at GDP, U.S. makes up almost close to 26% of global GDP. So as you can see, the U.S. is large, but not only is it large, it is also robust. The U.S. has markets that are both deep and highly liquid. And I'd like to talk a little bit today about some of the reasons why we think that is very important. The first is risk transfer. Markets allow participants to manage and transfer risks through instruments like insurance policies and derivatives. Capital allocation and growth. Markets provide platforms to efficiently raise capital, supporting business expansion, infrastructure, and innovation. Some good examples of those would be AI or data centers. Financial stability. A stable, transparent, and liquid market structure absorbs economic shocks rather than amplifying them, crucial for preventing or limiting the impact of financial crisis. Diverse financing options. In the U.S., 75% of debt financing for non-financial corporations comes from capital markets, rather than banks, providing competition, efficiency, and flexibility in pricing risk. Liquidity. Liquidity is necessary and critical to capital markets as it ensures quick asset transactions in high volume with minimal price impact to investors. And lastly, asset valuation. U.S. markets provide necessary liquidity and assist in determining accurate asset prices with very high precision. So now I'd like to think about, as we think about capital markets, I'd like to think about what role does NBFI play within capital markets. And just a simple definition for everybody here, non-bank financial intermediation, as defined by the Financial Stability Board, can be thought of as a broad measure of all non-bank financial entities, composed of all financial institutions that are not central banks, or public financial institutions. So what role do they play? First, NBFI plays a critical role in capital market formation by connecting investors, savers, borrowers, and issuers. NBFIs, such as investment funds, insurance companies, hedge funds, and pension funds, play a critical role in market intermediation by providing alternative financing, enhancing market liquidity, and enabling risk transfer. Second, NBFI provides an important alternative and competition to the banking sector. This competition benefits not only investors, savers, borrowers, and issuers, but it benefits banks themselves as well. And lastly, third, when it comes to risk and fragility in finance, it's important to think of NBFI as a diverse set of entities. Not every risk is the same. In fact, we view the financial sector as allocating and pricing risk, not necessarily eliminating it. We also take into consideration the interconnectedness between NBFI entities and the larger financial ecosystem. So I'd like to talk a little bit about how large NBFI is. I think this is maybe a common misconception. So the Financial Stability Board produces a global monitoring report, which has been a yearly report published usually in December. This data here that you see is from the December 2025 report, which publishes year-end 2024 data. The SEC, and myself in particular, participates in this effort, led by the FSB, which is a comprehensive monitoring of global trends, vulnerabilities, and innovations of the NBFI sector, and an important part of both the FSB and SEC efforts to enhance financial system resilience. At the end of 2024, U.S. non-bank financial intermediary assets were $94.5 trillion US dollars, 65% of U.S. total financial assets, and 3 times the size of banking assets. Banks made up only 22.6% of U.S. total financial assets, and central banks only made up 4% of U.S. total financial assets. Now, NBFI provides many benefits, but I think it's also important that we talk a little bit about vulnerabilities. So the FSB, in this FSB report, there is what they call the narrow measure, and it is composed of NBFI entities that authorities have assessed as being involved in bank-like activities and pose particular financial stability risks. Once that cohort is defined, there is then a series of risks that we look at to assess all of these entities. Three of these risks are here up on the screen that I would like to talk about today. The first, credit intermediation. The credit activities of the NBFI sector are of particular importance to financial stability. NBFI entities can be an important source of credit, competition, and innovation within financial systems. On the other hand, NBFI entities that are not sufficiently resilient to shocks could slow the flow of credit to the wider economy, especially during downturns. Financial leverage, if not properly managed, creates a vulnerability that can propagate strains through the financial system, amplify stress, and lead to systemic disruption. Leverage is a characteristic feature of modern economies and financial markets. It can be used to increase exposure and boost returns. However, if not properly managed, the buildup of leverage can lead to systemic disruption via multiple channels. Some channels include the position liquidation channel and the counterparty channel. And lastly, interconnectedness. Financial interconnectedness may help share risk across financial sectors, but may also serve as a channel for risk transmission. Banks and NBFI entities are directly connected with funding channels operating in both directions. For instance, banks often extend credit to or invest in pension funds, OFIs, or insurance corporations, while these entities provide funding back to banks or deposit the non-invested part of customer assets with custodian banks. Understanding these linkages is essential for identifying vulnerabilities and assessing emerging risks to financial stability. And I would like to leave you guys just with 3 quick thoughts from everything I just said. The first is U.S. capital markets are large and hold a dominance on global finance, providing many benefits to investors. Second, NBFI plays a crucial role in capital markets, and in fact, its size is 3 times that of the traditional banking assets, really highlighting its importance. And third, NBFI participation in capital markets provides efficiency, diversification, and credit provision to global financial markets. Thank you. I will go ahead and pass along.
Hi, can I just interrupt and comment? One of my questions is for you or for anybody on the panel. Given all of the changes in capital markets and the related markets, how much does DERA get involved with other divisions in developing new rules or looking at old rules that may be or are irrelevant and ineffective? What is your role in all of those things?
Yeah, so I can take that question. It's a great one. You know, I think you're referring to sort of retrospective analyses, and a core part of any kind of evidence-based policymaking is recognizing that some of the effects of a rule can't be sort of quantified at the time the rulemaking is taking place. And so the economic analysis that we do in support of policy, we think of that as prospective analysis. We're trying to predict the economic effects, the costs, the benefits, you know, potential unintended consequences, and trying to think, is there a market failure, and how we can compare that to any kind of baseline data we have. Once a rule is in place, sort of looking back with data allows us to say, well, what outcomes did we predict? What can now be quantified that maybe could not be quantified at the time the rule was being adopted? And where did behavior sort of deviate from expectations? And so a lot of that is informed internally, and so we're consistently engaged in evidence-based retrospective review. And so we look back at those rules where data allows us to measure those types of effects that weren't measurable, or to use new methodologies or fresh data, more refined models to quantify it. But I do want to emphasize that sort of our first priority is always ensuring that the economic analyses accompanying new rules are sound and rigorous, even-handed, independent, and grounded in economic theory and evidence. And so it's one reason I was encouraging commenters to send in data that allows us to sort of get it as right as we can the first time. And there have been instances in the past where the rules did not withstand judicial scrutiny. And so that highlights why analysis is really not procedural. It's essential to producing rules that last. And so our view is that if the rules at the beginning are sort of grounded in economic theory and evidence, and we make sure we identify true market failures, and they become harder to unwind. And so if a future effort tries to repeal a rule, they need to show a change in the underlying economics or the market failure, which is one of the things we look at in retrospectives. But we view the economic analysis as a stabilizing force, and so we're focused on that now for prospective. But in terms of retrospective, there are instances where that analysis was limited by data. And so when new data sets become available, or when commenters share concerns with us, or we see academic studies or our own internal studies, then we can revisit those and shed light on those effects and see if the rules need to be tweaked or adjusted.
That is very good to hear. Thanks. We didn't have the benefit of ADIRA as it now exists when I was here. And so I'm really pleased to see that you're doing all those things. Thanks.
Great, thank you.
Okay. Good afternoon, everyone. I'm Wei Liu, Assistant Director in the Office of Economic Statistics. It's my pleasure to present to you Statistics and Data Visualizations white page today. Okay, so first of all, I want to take this opportunity to thank our colleagues in the Division of Corporation Finance, Trading and Markets, Investment Management, Exams, Office of Municipal Securities, Office of Credit Ratings, Office of Advocate for Small Business, as well as our colleagues in the Office of Public Affairs. We really appreciate their energetic engagement and fantastic collaboration through this initiative. As you all can see, this is a big team effort in SEC. Our goal is to provide greater transparency to serve the public more effectively. As our Chairman Atkins highlighted in the press release when we launched this white page last August, this white page transforms SEC's public reporting of fundamental statistics to the public and to put vital information into the hands of investors, market participants, and the public. We wanted to make our work, especially how we produce statistics, how we conduct our data analysis, more accessible to the public. So this web page provides a centralized location, access to all statistics. We cover broadly 4 major categories: capital formation, market participants, market activity, and investors. And from the landing page, you can browse all the statistics at the same page. At the same time, we provide comprehensive coverage of the market, of the capital markets. As you can see, as an example, under capital formation, we offer registered offerings, exempt offerings, as well as asset-backed securities issuances and the commercial mortgage-backed securities issuances. After me, my colleague Vlad will also dive into more details on the IPOs and exempt offerings, a lot of interesting statistics to share with you. So we provide regular updates. Most of the statistics we offer quarterly updates. At the same time, we also provide historical statistics. So this page offers the ability to look at the market information over time so you can see what's happening in the markets. On each page, we follow this standard structure for easy navigation. It has 5 sections: data visualizations, statistic guide, statistic table, statistic guide, statistic download, and the related materials. On the top of the page, follow each link, and then you will go to each section on the same page. This is the, I think, more exciting part, the interactive data visuals. Okay, and then we provide interactive data visuals for each statistic page. As you can see here, those are 6 data visuals highlighted what we, among many data visuals we provided also through data visualization gallery. For example, for the initial public offerings, and you can actually select any time periods you are interested in, and then just dive into the specific time period. And on the pie chart, you can actually, you have the flexibility to select the groups you are interested in, and then pie chart can be automatically updated. And on the map shows the geographic distribution of offerings of market participants, and you can zoom in, zoom out, and to look for specific interesting information. And all the data visuals can be downloaded and in various formats. In addition to that, you can also download the underlying statistics so that you can create your own data visuals. Okay, so on the statistic page, you will see statistic table, which provides you the most recent annual and quarterly statistics. And in addition to that, we also have statistics download, which covers all historical statistics for you to download to use as well. So this is what we want to achieve, greater transparency. It's all about how we do our work. In the statistic guide, we provide detailed information on description of each metric, calculation method, as well as data source. And this will help the analysts and to even replicate the numbers using the same data sources we used. Okay, so last, I wanted to thank market participants, analysts from various research groups and organizations, agencies, as well as professors and graduate students who have already sent us suggestions, ideas, and which is making our webpage better. We really also appreciate their very kind, very encouraging words about our webpage. We truly value your feedback. So the webpage currently have over 40,000 views by over 28,000 users since it was launched last August. We also offer the briefings on this page. When you have a moment, go visit this webpage. Take a tour in the data visualization gallery. Just explore all the market information there, past and present, at your fingertips. Thanks.
That was great. I think this website is terrific. Wish we'd had it before. I have one quick question. How do you make sure that the data are accurate and current?
That's a great question. So we, in my office, also in the entire DRA, we do have a standard procedure to ensure the data quality before we even jump to analyze data. So this is often, I would think like analysis part is important, but pre-analysis assessment of the data quality is extremely critical. And in DRA, we have a standard practice in place. And then we also use other data sources as a cross-reference check and to ensure the data we are using are of high quality.
Great, thank you.
Hello, everyone. My name is Vlad Ivanov. I'm a principal economist in the Office of Corporate Finance in DIRA, and I'm going to talk about some recent trends in IPOs and exempt markets. I'll start with the IPO market. This chart shows the number of IPOs and the amounts raised from 2000 through 2025. As you can see, the last few years, the IPO market has been down. Number of IPOs and especially amounts raised have been well below historical averages, although it appears that the market is on an upturn. Last year was actually a very good year for IPOs. There were 374 IPOs that raised about $70 billion. Compare that to the year before. So in 2024, there were only 246 IPOs that raised about $39 billion. So in 2025, we've seen an increase in the number of IPOs by more than 50% compared to previous year, and increase in the amounts raised more than 70% compared to the previous year. Obviously, nothing in the last 4 years approaches even remotely the record IPO market that we had in 2021, right? That year, 2021, would be one of the top IPO years, even if you look at the last 50 years of IPO data, right? As you know, it was a very special, IPO market. In 2021, out of these almost 1,100 IPOs that were performed, and also more than $300 billion raised, right? More than 60% of those IPOs were SPAC IPOs, so a very unique IPO year. I also want to mention a couple of other interesting trends in the IPO market. So we observe a rebound in the number of SPAC IPOs. For example, last year there were 90 SPAC IPOs compared to 58 in 2024 and only 31 in 2023. So it seems like SPAC IPOs are on an upward trend again. Also, last year was a record year for direct listings. 9 direct listings compared to only 3 in 2024. So again, given that the issue of how do companies go public, how do we encourage companies to go public, can companies use alternative and cheaper ways to go public, is very important from policy perspective, research-wise and otherwise. As you can see, both SPACs and direct listing public offerings are up. Still, the numbers are small, especially direct listing numbers, compared to the number of private companies that prefer to go public via the traditional IPO way, using underwriters, doing roadshows, and things like that. Next, I'm going to switch to the exempt offering market. I'll start with probably the most frequently used offering exemption, Regulation D. So the chart here shows the number of Reg D offerings and the amounts raised from 2009 through 2025. You can see a clear upward trend, kind of stepwise, with a slight downward trend in 24 and again rebound last year. So the Reg D market is very large. For example, the last 5 years, capital raised under Reg D was more than 2 trillion per year, right? As you might know, most of this is capital raised by funds. So hedge funds, private equity funds, venture capital funds account for probably more than 75% of this amount. Operating companies raise on average about 200 billion years annually using Reg D. Also, as you know, Reg D has 3 rules. Rule 504, which allows an issuer to raise up to $10 million. Rule 506B, which allows an issuer to raise unlimited amount of capital, but does not allow solicitation and advertisement. And Rule 506C, which allows for unlimited amount of capital to be raised and also allows for general solicitation and advertising. So which one of these rules do issuers prefer? As the graph shows, overwhelmingly 506B, despite the fact that 506C allows general solicitation and advertising, right? The amount of capital raised under Rule 506C is about 5% of the amount of capital raised under Rule 506B, right? So for whatever reason, various factors make issuers rely mostly on 506B. Right? Next, I'm going to switch to crowdfunding. The chart on the top left shows you the the amount of capital raised by crowdfunding issuers since 2016, when the rule was adopted. As you can see, a clear upward trend, peaking in 2022, kind of a downtrend after that, and a slight rebound last year. So at that peak year, 2022, the amount of capital raised under crowdfunding was about $345 million, right? Orders of magnitude less than Reg D. Right? What other exempt offerings do crowdfunding issuers use to raise capital? The table on the top right provides some statistics on that. So crowdfunding issuers, about 25% of them use also Reg D to raise capital. About 4% of them use Reg A. And very small fraction of them, about 1%, do registered offerings. And lastly, what happens with crowdfunding issuers? Very important question regarding outcomes in this market, again, which is open for retail investors as well, right? So what happens with those companies? Well, the table at the bottom kind of shows us some statistics on that. So a small portion of crowdfunding issuers end up being public. Only 0.25% do an IPO, which is, again, not surprising given that these are small and early stage companies. About 2% of them get acquired, and about 3.5% get venture backing. Right? And the last offering market exempt offering market I'm going to talk about is Reg A. Again, the chart on the top left shows the capital raised under Reg A offerings from 2015, when Reg A was amended, through 2025. We see a similar trend like with crowdfunding, an upward trend peaking in year 2022, and then kind of a downtrend with a slight rebound last year. At the peak, year 2022, issuers relying on Reg A raised about $1.8 billion, right? Orders of magnitude smaller than Reg D. What other exempt offerings do Reg A issuers use to raise capital? That's what the table on the top right shows. So like crowdfunding issuers, about 32% of Reg A issuers rely on Reg D, 6% of them use crowdfunding to raise capital, and about 20%-ish rely on registered offerings. Now, Reg A, as you know, is probably the only offering exemption that allows for the issuance of freely tradable shares. So another interesting question is, so what happens with those shares? Do Reg A issuers list their shares on any trading venue? So that's what the table at the bottom shows us. So about 4%, that's the last column, 4% of Reg A issuers end up getting listed on national exchanges, NASDAQ or NYSE. About 25% have their shares listed on the OTC market, and you can see the distribution across various informational tiers. And then still bulk of the Reg A issuers, about 70%, do not have any markets for their shares, right? So to recap the evidence on exempt offerings, large market, that's Reg D, right? Trillions of dollars raised every year, much larger than the amount of capital raised via registered offerings, right? And again, when you talk about Reg D, it's 506B, that's it. Everything else very tiny. Interesting facts about crowdfunding and Reg A. Issuers utilizing those two exemptions don't seem to fully utilize the offering limits that these two exemptions offer. For example, the average size of a crowdfunding offering is only $350,000, given the offering limit of $5 million, right? The average amount raised in Reg D offerings is about $11.5 million, given the $75 million limit in Tier 2 of Reg A and the $20 million limit in Tier 1 of Reg A, right? So for whatever reason, issuers rely on crowdfunding and Reg A do not seem to fully utilize these offering limits. And lastly, a very robust fact, issuers, when they look for raising capital via private offerings, tend to favor Reg D compared to Reg A and crowdfunding. So if an issuer wants to raise $1 million, they can do it with Reg A, Reg D, Reg crowdfunding. They overwhelmingly prefer, I'm talking 90% of the time, would go with Reg A. Again, 506B, right? With that, if there are questions, then I'll turn it over to my colleague, Julie Marlowe.
To what extent do you use the findings from this and all of the other data that you have to prioritize your next steps, the next project the next question that you want to answer?
Yes, so we use this, as Josh mentioned, when we first do our analysis for rulemakings and also when we review retrospectively rules. So, for example, why, again, if I go back to Reg D, why isn't 506C, which allows general solicitation, why isn't it used more frequently compared to Reg D? Well, we look for what are the factors that drive issuers to go towards Reg B, right? What could be, is it because it's costly to verify accredited investor status? Is it because issuers prefer Reg D for various reasons? So we do analyze, given the patterns that we see, we do analyze the reasons for the factors that drive those patterns.
Great, thanks.
And if I can, I'll add on to that. So thank you, Vlad, for that presentation and for the question. And so really, both the information that Wei shared and that Vlad shared, you can think of that as informing the baseline for potential regulation, because we always want to establish what the status quo is. And if we see a particular rule or a particular area of the market that's not, the capital raising is not happening at the activity or level that we expect, then we look for a potential market failure. And so that type of analysis that we shared, and really we're excited about the data we're sharing on this website, because it's essentially a real-time baseline rather than waiting for an actual rulemaking to take place where we can share that analysis. So we're sharing baselines sort of in real time and can also get feedback from market participants on maybe why we're not seeing levels of activity that we might not have expected. So it's a great question. Thank you.
Good afternoon. Thank you again for the opportunity to share a few thoughts today. My name is Julie Marlowe, and I'm the Assistant Director for the Office of Structured Disclosure. Today, I'd like to discuss a little bit about what our office does. We're unique in a way that our office doesn't have economists, but we do have accountants, attorneys, data analysts, data scientists who work on various projects with the economists and policy divisions and others at the Commission. We'll also get into how the machine-readable data enables AI, and also discuss staff observations and guidance that our office issues once we had a chance to look at the data quality of the filings we receive. And I'll end the presentation with free data sets that we publish on our website. In summary, our Office of Structured Disclosure, supports the Commission's efforts in making data accessible and easy to use. We aim to conform to current market standards, meaning what is the industry already using for certain disclosures and how are they extracting the data. We design SEC-wide analytical applications for our staff's use to conduct analysis, for rulemaking and other purposes, to ensure they're using the machine-readable data. And once we collect enough data, we publish them on our site so the public can use them for free. And we design taxonomies. In case you're unaware what a taxonomy is, it's a list of tags that filers use to make their disclosures machine-readable. You can think of it as a dictionary. And we also work on validation rules with different divisions and offices so that when the filers give us the data, at the intake of their process, we can check the quality of the data. And as we're doing now, we conduct market engagement. We're one of the few offices with a public-facing inbox. So we get questions from investors, filers, tagging vendors, and all types of users who have questions on our data or the taxonomies we publish, and we meet with them to address their concerns or get feedback on the data. We also work with FASB and ISB on their respective standard taxonomies. And we have met with other federal agencies that use our data because the entities that report to them also report to us. So let's talk about machine-readable data and AI. But before we get into the details of that, let's step back and talk about AI. What is AI? What does it do? So AI models are driven by math and statistics and subject to probabilities. And the outcomes are only as good as what the data is trained on. So if you think about what are you feeding your AI tool, the quality of that data matters. I started my career in a Big Four accounting firm, and one of the common phrases was garbage in, garbage out. And the same concept applies here. Is the data complete? The chairman, Commissioner Glassman raised earlier about how do you ensure data is complete and accurate. That's exactly the point. And the quality of the data matters. And the AI is better if you give the context, meaning what is the data related to? Machine-readable data provides that context. It tells the AI what it's looking at. If you go to a standard taxonomy, like the GAAP taxonomy, based on accounting standards, or one of our rulemaking taxonomies, each tag comes with a codification, accounting standard, or a rule requirement. So the filers and data users know exactly what that tag to use for common disclosure. So let's say a company has research and development expense. If you go to the GAAP taxonomy, and if you type in research and development expense, you're going to get the tag name. It comes with the definition of the tag, and then it shows you what codification is it related to. So the filers can assess, is this the right tag for my disclosure? On the flip side, data users and investors can also go to that taxonomy, because it's public and it's free to everyone, and you can look at it and go, I want R&D expense across filers for this particular period or across industries. And they know exactly what tag to use. The filers get to define the data with the standard taxonomy and machine-readable data. So downstream users don't have to guess. We don't know what this data means because the filer already used it based on the common standard taxonomy. There are already a lot of AI chatbots that's using machine-readable data. One of them particularly pings to the Edgar API data that's on the Commission's website. And we're not the only one that's working on AI and machine-readable data. Department of Commerce has issued a guidance on AI and machine-readable data. And they actually said AI-ready data is not just machine-readable, but it's machine-understandable data that is enriched with contextual data, metadata. So let's talk about how different stakeholders are using machine-readable data in AI. Tagging vendor. We're aware of a tagging vendor that is using structured data in their AI model to do benchmark, to do peer review, draft narratives from tabular data, and do a historical roll forward of financial reports. These tools have been very useful when I was working long hours at an audit firm, and that have been very useful with that. Speaking of audit firm, there's an audit firm that's using machine-readable data to identify anomalies as part of their audit cycle. Data aggregator that's integrated AI into reporting by using structured data as part of their financial and analytical services. And a filer, an executive at a large filer, recently talked about AI depends on solid, well-organized data from the start, meaning you begin with the digitizing the information, and you organize and classify it so the machines can read your data accurately. As for SEC, as you may know, we do have an AI task force, and that task force has been working with different divisions and offices to find AI solutions enterprise-wide. We also, our division has an office called Office of Data Science that's been working on machine learning for a while. Our office has worked with them on several projects, for example, tonality of narratives and filings, meaning using AI and data, what does a particular narrative say about the company? So for example, did the company have a profitable year or did it not? Now from investors' perspective, there are various benefits they can enjoy with structured data and AI. One example would be using a chatbot to get an instant answer to a financial report or a company. So you can ask the chatbot, what was company A's current assets at December 31st, 2025, and you'll get the answer. Word of caution, you have to make sure that data, that AI model is pinging to the as-reported data by the filer, and that data is machine-readable. We are aware of a financial AI tool. If you ask the same question, it's not going to give you an answer, or it's going to give you a wrong answer, because it's actually dipping into a source that is not machine-readable. In addition to these efforts, our staff review Forms 10K, 10Q, and other filings to ensure the data is of high quality. One of the efforts we work on is called Data Quality Reminder. These are short posts about a particular data quality topic. It starts with, here's an issue we noted, here's how you can fix it, and here's the guidance for it. Some of the issues we keep seeing is scaling errors, either 3 extra zeros or missing zeros. So for example, we've recently seen a smaller reporting company with trillion in public float. I think we can all agree that is not possible. We've also seen filers using old tags. So they would adopt a new accounting standard, but they're still using the old tag. Those things really inhibit the use of the data. Or filers are creating custom tags for standard disclosures, such as property, plant, equipment. These are computers, phones. There's tags for those, and there's no reason to create custom tags. And as you may know, our interactive rules back in 2009 do allow custom tags, but the rules specify exactly when you can use them and you cannot. If it's a unique disclosure and you're unable to find tags in standard taxonomies, maybe. Otherwise, you should really review the standard taxonomies so that the public can use the data. And just to give you some context, in the GAAP taxonomy, we have over 15,000 tags. In the IFRS taxonomy, we have over 4,000 tags. And speaking of custom tags, at the bottom of this screen, you're going to see custom tag trend analysis. We do look at the average custom tag rates year over year. This one is for GAAP filers. We do one for IFRS as well. In the past couple of years, it's about a little less than 20%, depending on the filer size. You will see that for large filers, usually their rates are a little lower. And we also want to encourage everyone to make sure that checking the quality of your XBRL data is part of your financial reporting process. Doing a little deeper dive into Data Quality Reminder, here are the 3 that we did issue Data Quality Reminder. This is not including all the other data quality checks we did. We tried to focus on systematic issues. And the one that I'd like to highlight today is the Form 1A disclosure inconsistencies. As Vlad talked about earlier, Form 1A is the offering statement for under Reg A. There are informations in XML, in extensible markup language, in Part 1, such as offering price, total assets, total liabilities. then in part 2, the same information should show up in HTML. We've seen inconsistencies for the same disclosure in those 2 parts. There's no reason why they shouldn't agree. So if you could pay attention to quality of the data, that we would really appreciate that. And although our division does not have the delegated authority to contact the filers directly, because we're not a policy division, we know the repeat offenders. So although we're not calling you out on the website, we know who you are, and those with lower data quality errors, we do greatly appreciate it. And in addition to our efforts, XBRL US is a third party that works on data quality validation rules. It consists of public companies, data tagging vendors, accounting standard bodies, and they have validation rules that filers can run voluntarily before submitting them to us. And they also publish a list of filers with errors against their validation rules. So things like, hey, you used an old tag, or you have a negative value when you should have a positive value. And when you see those easy-to-fix errors, one may wonder, what does their financial reporting process look like? And are they paying attention to data quality? We have 15 data sets on our website. These are all free for the public to use. We often get questions and feedback on these data sets from different users. They are either updated monthly or quarterly. And one data set that I'd like to point out is financial statement and notes data. This is one of the most heavily downloaded items on our site. So in the past year, the downloads have doubled. We update this monthly. It goes way back to January 2009, so if you have time, please take a look. If you have technical questions for us on tagging or taxonomies, you can contact us at structureddata@sec.gov. Thank you for your time.
You've answered all the questions I could possibly think of.
Right. Thank you, Julie. I recognize I'm the sole barrier to lunchtime, so I'm going to do my best to stay on time. Hi, everyone. My name is Bill Young. I'm an assistant director in the Office of Litigation Economics, and I will be discussing kind of the economics of insider trading. First, a real quick intro on our office. Our office's role is to provide empirical analyses to the Division of Enforcement so that it can help inform their decisions in the course of their investigations and litigation. Work on a very wide range of cases, which obviously includes insider trading. I'm not going to list them here today, though, so we're just going to move on. So before you is kind of a basic insider trading base case. This here is just like a generalization for the purpose of showing how our office might be involved in an insider trading investigation. First, an insider learns of some material non-public information, or MNPI. It sounds like a loaded term. Here, all we kind of mean is this information that a reasonable investor would want to know, before they would trade a stock. The second step then is the trader then buys or sells on this information. If they know something good's going to happen, they might buy long. And then the third, right, they ultimately have to capitalize on this this information, and then they buy or sell when the news becomes public, right? So if they bought low, they sell high, and they make some money. We've often heard these cases described as difficult, right? Outside of a smoking gun or some kind of cooperator, you need solid circumstantial evidence, which is where our office can kind of come in. So insider trading really runs the gambit of what we do. This is kind of a broad overview of the kind of the value we can add at each step in an investigation. And I'll run into a couple case examples. So under materiality, we attempt to answer a couple kinds of questions, right? Or could or should this information that they got cause a stock price change, right? We might review academic literature or look at a cross-sectional event study, to see and to assess if this information typically would have an impact on prices. Did it historically? We'll evaluate, did it actually have an impact? Like, there's some things that are kind of given, right? You have big earnings announcements or mergers. Those are, generally just material. But some not so much, right? We might have some kind of interim letter from the FDA on drug trials. And in those cases, we might run a single firm event study to make an assessment. We'll look for significant price impacts. We'll consult analyst reports and news articles to make our assessment. The next part is trading patterns. And for the data nerds, this is kind of the fun part for us. We basically want to ask, what can we show that's anomalous in their trading if it weren't for this information that they weren't supposed to use? Especially useful during early stages of investigations. We can, highlight certain trading patterns, visualize data, look for outliers, possibly anticipate defense arguments. Review trading records. We're basically trying to look for changes in trading behavior. And, we'll look at different dimensions, such as the amount invested, for example, aggregate long-short positions over time. What type of investments, like equities versus options? Did they ever trade options before they got this information? And then in terms of profit estimates, we'll calculate realized and unrealized profits related just to the this MNPI as of a specific time. And so how does this, work in actuality? Got a couple examples, but for time, I'm going to skip this one. All right. So this is an older case, but it was in the news recently because of a corresponding criminal trial. This case, a former Capital One data analyst mined the company's own credit card sales databases and then used that information to trade ahead of companies' quarterly sales revenues for a bunch of big companies. Our expert, Steve Graham, had to analyze all this electronic media and assess the importance of that information to investors. The big question, right, is would an investor really care about these credit card transactions? So the defendant queried the database like thousands of times, and our expert went through all this data and actually found data that was aggregated by month in a conveniently named folder, done, as in complete, that contains summarized data and predictions of future revenue. So our expert ran various regression analyses and determined, yes, this credit card sales data, had a statistically significant relationship to the company's total revenues and could predict total revenues for companies, in a given time period. Here is an example. So this is an example of one of those files for Starbucks. But this is a chart, though, that our expert created using that data that was found. So the credit card transactions are the bottom line in red. That was what was pulled from the system. The black line at the top is the actual reported sales. And then that little green piece in the upper right is actually kind of the predicted sales for the next quarter, right? And according to our expert, having this information, or quote, having information on the revenue from Capital One systems is going to help a reasonable investor make better decisions on whether to buy or sell securities, right? And you can just see, you don't need a quant background, you don't need math, right? You can to see that the two lines move together. If you know one, you kind of know the other. Ultimately, jury trial was unanimously found guilty, and he was ordered to disgorge almost $4.5 million in ill-gotten gains. My next example is focuses again kind of digging into trading patterns, and this case was the U.S. versus Clution with our friends at the U.S. Attorney's Office. For several years, Clution and some co-conspirators hacked two of the companies that handled the quarterly SEC filings, which gave them kind of advance notice of earnings figures. They then traded ahead of earnings announcements on several big companies and under different account names across multiple countries. It's a little complex. Our expert, Matt Clark, testified on several points to kind of make sense of this trading, which was a lot. First, he asked, how good are they? Well, Clution traded in a profitable direction nearly 9 times out of 10 trades. Second, how good was he at predicting earnings surprises. Well, he was able to track positive earnings surprises correctly by going long 86% of the time and shorted correctly 85% of the time. And then, but maybe, at that point, maybe he's just a really good trader. But the third point, and I really love this statistic because it's something that shouldn't exist if it weren't for this information that they had access to. So about 96% of the companies they traded in used the two hacked companies to file their earnings. But during the same time, those two companies only accounted for 44% of all of the total earnings reports at the time, and there were like 38,000 of them. So to wrap our head around this, our economists equated Clearshin's trading pattern to a giant jar of like 38,000 marbles, right? That's the universal earnings reports at the time. 44% of them are red to kind of indicate the earnings reports that came from these two companies. And so our expert tried to answer the question of what the odds would be of grabbing a red marble 343 times out of 356 attempts, representing the companies that they traded in. And the answer to that question is 1 in a trillion, which is what he told the jury. Right? Economically, the company that that standardizes and formats earnings reports for SEC filings should have no bearing on someone's trading strategy, right? The outcome was that after a jury trial with like 10 hours of deliberation, they found them guilty of netting nearly 90 million in profits. So that's my last example. Thank you for your time.
So all I have to say to you, Bill, and the rest of the panel is keep up the good work.
Thank you.
Thank you. Note for anybody who's watching on the live stream, clearly not the folks in the room, we have added the slides from this presentation as a downloadable feature, so please just refresh your screen if you aren't seeing them right away. And for everybody, please enjoy your lunch break, and we'll see you back for the next panel.
Good afternoon. At this time, we would kindly ask that you please take your seats and silence all devices as our program is about to begin. Thank you.
So good afternoon, everybody. It's 1:42. You're 2 minutes late, but we're starting. No? Okay, I'm getting mixed messages here. I think we are starting, though, and I will begin by introducing the Investment Management Division Director, Brian Daly. He joined IM as the director in July of 2025. Before that, he was a partner at Aiken Gump in the IM practice, and before that, Schulte Roth, where he was an investment management lawyer for about a decade. He's a founding equity partner of Kipos Capital, which I assume you've divested, which was a quant IM company, and also a board member of MFA. Dan Gallagher almost needs no introduction, but I'll go ahead anyway. He has been all over the SEC. Most recently, he is the Chief Legal Compliance and Corporate Affairs of Legal Compliance and Corporate Affairs, there's commas in there, of Robinhood Markets. Before that, he was at Wilmer Hale as a partner and deputy chair of the Securities Department. Before that, he was a commissioner. Before that, he was on the SEC staff. And he was the chief legal officer of Mylan. I almost forgot about that. And he serves as an advisor on several boards. So I would like to welcome the IM panel. Thank you very much.
Hey, well, thank you so much for that.
Oh, wait. I on the last one. The magic words. I think you turned my mic off. Okay. Please consider the comments of this session's panelists so that you can get CLE credit. Okay.
I like when the magic word is like hamburger. So why don't we finish our introduction? Christian, why don't you go first?
Okay, my name is Christian Sando. I'm an assistant director in the Disclosure Review and Accounting Office. I've been with the SEC for 30 years now, 26 in the Disclosure Review and Accounting Office, and 15 years as one of the managers overseeing the Disclosure Review.
I'm Robert Holoka. I'm the acting assistant director in the Rulemaking Office. I joined the SEC in 2022, and before that, I was at Kirkland & Ellis.
I am Rachel Loco, and I'm a senior special counsel in the Chief Counsel's Office. I've been in IM for 13 years. I have the distinct honor of having been in every office in IM, but here to represent the Chief Counsel's Office today. Before that, I was at Sherman & Sterling and Allen & Overy, which now are the same firms. Yes. And before that, one of the most fun things I did in my life was to be the chief legal manager for Africa at the Grameen Foundation.
Great. So thank you, guys. And so before we start, we will do the obligatory disclosure. I will do it for everyone here except Dan. Dan can either do one or not. We don't really care anymore. Since you left the commission, you're on your own. So these remarks are provided in our official capacities as our various positions at the commission, and they do not necessarily reflect the views of the chairman, the commission, the commissioners, the other members of our staff, His Holiness Pope Leo, my mom, or anybody else that you might think of. So it's all on us. And with that, why don't we jump on in? One of the things that we have focused on a lot during this administration has been access and making sure that we are talking to industry, we are hearing from the industry, and more importantly, that people know how to reach us, right? Like very much across all the divisions, you'll see the same theme, which is we're trying to get rid of the cheat codes. We say this at every conference we go to. If you want to come in, call us. If you want a meeting, you get a meeting. I don't think we've turned away a single meeting request since Chairman Atkins, really since even Acting Commissioner Ueida took over. You don't always get the person, I only have so many hours in a day, but if somebody wants to come into IM, you come in, we talk to you, and we don't require an ask. If people want to come in, and we encourage people, managers especially, because we are IM, but fund managers of all stripes, if people want to come in to just tell us what's going on, what they're seeing, what the updates are. We have intermediaries, we've had prime brokers come in, we have administrators come in. Those interactions, even though there's no actionable request, are really helpful for us because we write rules, we give exemptive relief, we do analysis, and the smarter we are about the business, the better our rulemaking and other decisions are. So we definitely want to do that. Part of that we have really come to understand, particularly once you get out of the small circle of 40 Act lawyers, is that we have very seasoned, experienced, smart counsel, market participants who've never come in, who don't really understand the structures. And so what we thought we'd talk about here a little bit is what each of the offices within a division, right, division office, what each of the offices does and how that relates so that the listeners here and the people in the audience can understand who to call when they want to come in. Christian, since you're next to me, why don't you start?
Sure. So the Disclosure Office, obviously, unlike some of the other offices within the division, I'm going to say is a volume shop. We have filings that we review for all registered investment companies and BDCs. We're responsible for reviewing the disclosures, on registration statements, including post-effective amendments, as well as proxies and financial statements for all of these entities. Obviously, that's no small feat. Looking at, our, what we did last year for 2025, we reviewed, almost 2,500 new funds, including 175 new insurance products, close to 1,900 amendments for existing funds, and that included 165 for existing insurance products, more than 300 filings for business transactions or business combinations on Form N14, which includes about 562 target funds and 50 mutual funds that converted into ETFs. We reviewed more than 200 proxies and more than 4,600 financial statements, which I'll give a shout out to our accountants, which aren't on this panel today, but they're responsible since the Sarbanes-Oxley Act in 2002 for reviewing all the financial statements for RICs and BDCs every 3 years. With about 14,000 in total, that's between 4,000 and 5,000 a year. So that's just generally what we do.
Robert?
So in the rulemaking office, we do rulemaking. And this is a really exciting time for us because I think folks are starting to see some of our proposals come out. We've got a couple out there already, and I think people are going to expect there's going to be more. So, the rulemaking process, it's really a three-step process in most cases. First, you're going to put out a proposal, and staff may be working on that for quite a while before you see it. But the proposal will come out. The public will get a chance to look at the proposal. They'll get a chance to submit comment letters. We spend a long time reading those comment letters, thinking about them, discussing them, really considering them. And then we put together the adoption that reflects those comment letters, that reflects the direction from the chair and the other commissioners, as well as our director. So it can be a long process, but it's an important job.
And for the Chief Counsel's Office, I like to describe us a little bit as the law firm for the division. We're the jacks of all trade. We provide guidance on all aspects of the Investment Advisors Act and the 40 Act to various parts of the SEC. We support other offices and other divisions. We've been at the forefront of all these discussions with industry about, innovative products, but we also process a fairly large volume of routine work, which includes processing and reviewing routine exemptive applications, reviewing requests for clarifications on our rule. The request can be informal or formal in the form of no action letter requests. We craft the novel applications for the commission considerations, and we also answer general inquiries from the public. We provide support and technical assistance as well to Congress and other agencies. But in terms of the novel work, which has been more of interest to a lot of people, I will quote out the chair who said that the commission's job is to support innovation as much as it is to guard markets, and we have to meet innovation with thoughtfulness. So we're doing just that in the Chief Counsel's Office. And as we engage in novel issues, we engage similarly to sandboxes. And we do that in very specific situations for specific business arrangements. It allows us to experiment alongside the industry, and as Brian mentioned, it allows us to also receive information from how these arrangements are functioning in the market, which makes our rules better. And speaking of working with us, I wanted to go a little bit over the process of contacting the Chief Counsel's Office. You don't have to have a friend on the staff, or you don't have to know someone. If you do, that's great, reach out to them. But if you don't, we have a public mailbox, which is imocc@sec.gov. You can email that mailbox for very simple clarification questions. We will call you back. If it's a more complex question, you can also email there. It's just that if your request is more complicated, we would encourage you to draft an outline describing your business or the arrangement you're thinking about, as well as identifying the rules that are an impediment to your business, so we can engage quicker and more efficiently. We also encourage you to engage early in the process. in your process, and also to make sure that you engage before you file a formal request, whether it's a request for no action letter or a formal application, or even when you engage with my colleagues in disclosure, before you file something, if it's novel, call us first. So.
Actually, if I can bounce off of that, because that was actually on one of my note cards as well. Engage with us, and I think I wrote that in all caps, which means I should have been screaming it. But but similarly, when we have novel, complex issues, complex strategies, complex structures, or just different asset classes that we haven't, seen in a RIC format or in an ETF format, reach out to us early, work with us. Do it before you make a filing. I think that's got, plenty of benefits, I think, for us and for you. In fact, there was a letter that we had issued back in, I think, 2018, specifically, and this was in the context of crypto at the time, but, talk to us before you make your filing. We can do more to work with you. If you've got a novel issue, you don't want to share your secret sauce with everybody, engage with us, before you make your filing. Do it early, do it often. I think, in the context of doing most new funds, mutual funds and ETFs are offered through the post-effective amendment process, which has a 75-day clock on it before folks go effective. If you are, if you make that filing, it starts the clock. It starts all of your competitors, making their copycat filings. Makes it hard for you and makes it hard for us. You all end up in the prisoner's dilemma, where you want to be the first to market, and somebody else has tried to come in right behind you. This is hard for you and it's hard for us. Understand when we do have a novel or complex matter, that if you have filed it and the clock is running, the staff will oftentimes ask you to extend effectiveness, on those types of filings, because when there are novel issues, there are things that we need to be socializing within the building to our principals, and they with their principals. So you all have seen it before, in some previous iterations, whether it be in the cryptos times or the single stock ETF times or the leveraged fund times. There are various times that we've seen this before. So, work with us. Understand that when there are novel strategy structures, et cetera, that it's going to take a little extra time. So work with us.
I want to put a third emphasis on engagement. Engagement is really the core of the rulemaking process, and it happens at all three stages and sometimes before that. So when we're working on a proposal, we'll often meet with folks, talk with them, understand what the issue is, really try to drill down into what a potential solution might be. Obviously, then we get comment letters, and we read every single comment letter, believe it or not. And we engage with folks after reading those comment letters too, to try to refine some of our understanding. And even during the adoption phase, we're still meeting with folks, still trying to understand. So it really is kind of the lifeblood of rulemaking, is meeting with folks, understanding how things actually work in industry, and trying to provide solutions to that.
Can I ask a question? I don't need a disclaimer. Robinhood's good with this, because
Robinhood's good with this.
That decision would come to me anyway, so I'm good with it. When I was on the commission, it was, I lost so many votes, it was pretty obvious that I didn't speak for the commission. Little joke, sorry.
That was funny.
On this engagement thing, sorry, this just kind of occurred to me, and it's probably more of a trading and markets question, and I will ask them on the next panel, but I'm sensing just recently on this innovation stuff, maybe it's sandbox stuff, there's a lot of folks that come in and meet, which is great. I love that, the ability to come in or email, all these, making it easier to come in, and I love the point that you don't need a friend, right? You don't need a lobbyist, you can come meet with us, right? I remember saying that to folks when I was on the commission. But recently, it's like I hear a lot, and maybe it's just because of these new and innovative industries, crypto or whatever it is. I've met with the SEC staff, and I think we're all good. And it's a lot less, I think, directional, these meetings. And maybe you guys are just taking in so much information. But I think sometimes folks who are less familiar with the building, they'll have a meeting with you, they blather out whatever they're saying, and if you don't say, no, that's the stupidest thing I've ever heard, they kind of feel like they got the stamp of approval, even if they didn't get a no action letter, even if they're not getting an exemptive, relief or anything. And I'm just wondering, are you sensing that yourself, or is that just part of sort of this new engagement process? Again, I applaud it. I just think it's kind of interesting.
I will say we had a discussion very similar to that just this morning in one of our meetings, and it was slightly different. The way we were coming at it was we're getting a lot more people coming in. It is great, and people are, repeal all this stuff. And it's like, okay, that's great. And
that's the one I heard. Too. Yeah.
We had a lot of those. Which one? So this is a great venue. So thank you for that setup. But it's a great venue to put this out, which is if people do have something, if they do have an ask, if there is, I would like to be able to market this kind of product to these kinds of people. Here is the problem I have. It's like, okay, that's really helpful. It's helpful to have somebody come in and say, here's the problem I have. And that's great. And if you leave after that, we'll think about it and we'll try and put it into our various priorities. And we have only a certain amount of time and resources, and we'll decide where it goes more or less on our own, unless somebody else comes in with the same thing, or you come back in a month and you check in. And that can be fine. But people who come in and say, hey, I have this problem, I want to market this product and this to these people, and I have this issue, and they come in with, and here's the things I think you are going to worry about. The protections in the act or the rules are to protect against these three things. We recognize those are true dangers. We have a proposal for you to consider how to get through it. And here's how we're addressing danger number 1, danger number 2, and danger number 3. So we think we've got all of these. We think when somebody does the extra amount of legwork, then all of a sudden it goes from good idea to something that quite often, most of the time, wind up on Rachel's desk in Chief Counsel's office, like, hey, here's an actual proposal, and facially, at least, it looks workable, so let's start thinking about it. And if you do want to move from, hey, we had a nice meeting with the staff, they didn't say get lost, to, hey, I think they're actually working on this, that's one way to get to the front of the line. And I guess other ways, I mean, you meet all the time. Like, what else would you throw on that?
I mean, I guess I would add to that, to the extent that, folks do come in with, with an idea and we don't, immediately say yes or immediately say no. I think it's because it's sometimes really complicated and, there's a lot to think about. And, in the moment, it's something that we're very happy to hear. But we can't answer in the moment. And, perhaps, when folks don't hear us say automatically no, they're hearing what they want to hear. And, they're taking the lack of an answer, not as we're taking it back and truly considering it. Because it's, like I was just saying a minute ago, sometimes these are things that we have to, socialize, not just, among the couple of us, sitting here, but, throughout the division, throughout the agency, and, with our principals as well. So, I mean, it's not always easy to give the immediate yes or no. And I think in the times when it is easy, those are the answers that you do get the immediate questions. Yeah, of course, that's fine. Whatever. I'm not worried about that.
Got it.
But are there good, I mean, I think with you guys in particular,
yes,
what's the follow-up,
That's
right?
what I wanted to add. This is what I meant when I said prepare an outline, explaining your business arrangement and really identifying the rules that are coming in the way of your arrangement. And because we're always balancing innovation with investor protection. Investor protection means guardrails. And we can't really, as much as we would love to be able to do that, we can't just think of the guardrails as is. We also have to be creative in how we come up with that. And as Christian mentioned, there is the thought process of coming up with a workable framework for us, but then there are many stakeholders within the building who also needs to buy into what we are proposing. Like I said, in the case of a novel application, for instance, the Chief Counsel Office will design an application alongside the registrant, but then it needs to be approved by the commission, first our director, and then the commission.
But I do think, Dan, to your question, I think there's also a project management 101 aspect to it, which is it's perfectly appropriate to say, this was a wonderful meeting. We really appreciated it. You guys were so thoughtful, really smart, well-dressed. But would it be okay if I followed up? And if so, who should I follow up with? What is the way for me to follow up on this meeting that is most impactful and least burdensome for you at the commission? And somebody will say, oh, I guess it'll be me. Why don't you call me or whoever and give us like 3 or 4 weeks, and then you've got an actual path. And as the discussions go, sometimes it really is, this is a really interesting, innovative idea, but we don't have bandwidth for it, or we just don't think it's important to you, and we understand that we'd like to work that in. Do you think there are others in the market? Could you come back and tell us that this is a capital formation issue and there would be some impact? Because those kind of metrics allow us to rejigger our priorities. And not that any one applicant is more important than others, but 100 applicants kind of outweigh one sometimes.
And I'll say in the rulemaking process, the impact of these meetings, this engagement we're having, it might not show up immediately, like next week, but there could be a proposal that comes a month later, and you might say, hey, this is the thing I just went to talk to them about, and here it is in this proposal. So, rulemaking, obviously, in a lot of cases, we're meeting with people, we're working on things, then all of a sudden the proposal comes out, and then that's when we're really able to go public with what our ideas are. So I would say if you come and meet with us on rulemaking, just be patient, wait for the proposal, wait to see what comes out, and then continue to engage with us.
I think that's a huge point. And I remember from my trading and markets days, even though they're a long time ago now, on the rulemaking side, those were the best meetings, right? Even if it was after the comment period or whatever, because so often firms would go into a trade group or whatever, and the trade group generates a letter that has to appeal to Lord knows how many constituents, which basically homogenizes it, right? You're not going to get those idiosyncratic issues that when you meet with a firm and you say the rule's going to do this, how does it impact your business? And they go, oh my God, it would kill this line of business, right? Yeah. I remember these discussions in the money fund debates in 2012. It was like, oh my God, based on the corporate structure of some of these registrants, the rule would impact them, very differently. And you wouldn't know that unless, it was either in their letter, which sometimes they didn't put in, or they came in to meet with you. So I think that's a huge call out to engage through the rulemaking process in person.
Rob, maybe talk a little about how sometimes you're constrained because we can't publicly announce rulemakings until they're published in the Reg Flex agenda or the chair personally approves it. So sometimes you're sitting in the meeting just being like, right?
Well,
If you only knew.
obviously, I'm sitting here right now knowing that we're working on things that
I was going to say,
aren't
let's see what we
public
can
yet.
do here. Let's make it awkward.
Put pressure on me. But no, it can be frustrating at times because we're meeting with these people and we're kind of bouncing ideas off of them, trying to understand what their issues are and try to refine the potential rulemaking, but we can't necessarily tell people, okay, well, this is what we're going to do until the proposal comes out. But I think people will be surprised, one, how many meetings we do and how many repeat meetings. We'll meet with someone, we'll talk about a few issues, and then we'll go back discussing, like, well, we still don't fully understand this one issue, so we're going to do another one just to drill down on this. That's pretty common. And then I think people will be surprised how much influence those meetings have over time in ways that might be hard to detect if you just had that meeting and then saw the proposal come out 6 months later. But there might be discussion that came directly out of our conversation with you. So, it is frustrating that we can't just tell people what we're doing all the time, and we do have to ask people to be a little bit patient for proposals to come out. But once those proposals come out, we're ready to engage again.
And there is also, we collaborate across offices. So if you speak to one office, don't think that you have to speak to every office. We are aware in Chief Counsel's office, for instance, of the proposals that our colleagues are working on. So if you are bringing something to us that we know is relevant to some of the work they're doing, we will inform them. So it's never lost. Whatever you say to us, whatever impediments you present to us, and that's probably why we have the reaction of kind of not really saying yes or no, because no information that comes in is truly lost. Even if we know that there is not one way that we can move, it's always helpful to be able to have this collaboration where we can say, okay, I can't solve this right now, but maybe you'll consider that in your rulemaking, or I can solve this in this rulemaking, but maybe you and Chief Counsel can think about a way to address that, or even in disclosure. So it's never lost.
I'll add on to that. And like I had mentioned, I've been on the staff for a very long time. You know, and I've been through periods where it's been like this and periods where it's not been like this. And, you know, at least in IM, for a number of years now, you know, each of the different offices have been involved with each other. You know, the disclosure team or the disclosure office has had folks joining on to rulemakings, as has Chief Counsel's office, you know, to make sure that we're not siloed. You know, and, you know, in that regard, you know, as rulemakings are, you know, running their course, you know, with folks on our team, you know, for example, you know, in years past, you know, on names test rule, for example, you know, our team was on there. On the ETF rule, our team was in there, you know, so that could understand how it's going to impact, you know, the actual filers when they make filings, you know, funds with new names, how is that going to play out? So we are very much of a not siloed division. Perhaps it's in part our size, and in part, you know, just our culture and the way we do things.
We can't always say what we're doing. That's the
Well, why don't we, so Dan, would it help if we talked a little bit about some of the recent initiatives we've undertaken, how that really does reflect where the chairman's priorities are?
Yeah, let's do it.
Rachel, why don't you start?
I will, I guess, touch on some of the work that advances, that helps technological advancement in our markets, and I will also give examples that illustrate how we support transformation in our markets, for instance, on distribution, on the distribution aspect. I will start with our work that's supported technological advancement. So at the end of January, for instance, the Commission approved an application from the Wisdom Tree Money Market Digital Fund to permit investors to trade tokens of money market funds on an intraday basis at a $1 price. Concretely, before that relief, investors could only settle at the end of the day. And now investors can trade tokens on a blockchain with a dealer at that $1 price. The investors can benefit from instant settlement, possibly within minutes, we have been told, instead of settlement at the end of the day. And the relief also allows for trading around the clock. So it illustrates how the Commission is enabling tokenization on our capital markets while preserving investor protection through, because the money market fund rules are still applying. Another example is a letter published in the fall, a no-action letter published by the division in the fall, clarifying that investment advisors and investment companies can custody digital assets with state-chartered trusts, subject to certain conditions. So now I'd like to move on to the work from Chief Counsel's office that's been supporting transformation in areas like distribution and investment strategies. One example is the line of applications that allow ETF share class between ETFs and mutual funds. So under this relief, it permits an ETF to offer one class of mutual funds, and mutual funds can offer one class of ETFs. It allows investors to first select their investment strategy and then determine whether the ETF wrapper or a mutual fund is the most appropriate investment for them. It opens new distribution channels for funds, and some of the benefits identified by the industry are obviously a better investor experience, economics of scale with regard to service providers, and lower portfolio transaction costs, efficiencies in portfolio management as well. The key regulatory concern the staff had to address was the fact that one class could subsidize another, but the exemptive application includes conditions such as board oversight to mitigate the risks. So this has been a major line of no action letter in terms of the interest showed by the industry. We've received over 100 applications that we've been processing. We've processed so far over half, and we're working to continue processing these as quickly as possible. As we mentioned, issuing the relief is not the end of the conversation. We continue having conversations with the industry to implement it, including with, bringing in other divisions. TM just issued a follow-up letter allowing brokers this week to help with the trading in ETFs. So we are looking forward to continuing engagement again. I mean, it's not just issuing the application and letting it live in the ether. We are observing how it's behaving and responding as necessary.
So Dan, is that coming through to the industry, do you think? I mean, Rachel mentioned 3 initiatives. One is a tokenization / money market initiative, crypto custody, so technology or new technology, and the ETF share class is really old technology, but a new application, letting the ETF and the mutual fund coexist together. I'm very proud of that, what everybody's done. And I think that's pretty innovative across the board. Is that coming through, do you think? Do we need a better PR agent?
I think IM always needs a better PR agent, but I'm a TM guy, so. I do think it's just coming through generally across the board, right? I mean, the first and biggest thing is, not having enforcement breathing down your neck for trying to innovate with respect to digital assets is huge. The work you guys are doing, I mean, for my business, it's a little more around the edges, whereas the trading and market stuff is, right down the middle for us, but it's certainly recognized because it's kind of feels like it's part of an overall package, which is consistent with the chairman's remarks from this morning, right? It does feel holistic, and it feels like you're all rowing together, which is great. And so, yeah, I mean, these innovations, 4 years ago, it just wouldn't have been even entertained. So they're revolutionary in that way, and certainly for those market participants that are, in the space. But yeah, I think just the general sense is this is a time to get things done. And that's why I was asking you that first question, because I think you have folks coming to you with both, kind of down the middle innovation, recognizing that you can interact with digital assets. And then you have fringe players with, quite frankly, nutty ideas that meet with you and think, oh my God, I've got my seal of approval, and they're going to go launch something. So you might get into some whack-a-mole. But yeah, overall, kudos. And those are really important innovations, and it's just kind of a breath of fresh air.
What are we seeing on the rulemaking side that you can talk about?
Yeah. So we do have 2 proposals out of IM, one on small entity and one on amendments to NPORT. But I actually want to talk about something else which got a shout out in the chairman's statement today about e-delivery, which is something we don't have anything out yet, so I can't say too much, but I can note that this is an area we've gotten a lot of advocacy, and the chairman has obviously directed us to look at it. So for those who don't know, e-delivery is something that is been around for a while, but is in large part, at least in the IM space, mostly based on guidance, and some of that guidance is 30 years old. So we talk a lot about innovation, but there are also some 20-year problems is something I've heard before that we're trying to solve, and e-delivery is certainly one of them. And we've heard from a lot of folks that now is the time to really try to do something to modernize e-delivery, to advance it, to use one of the words from the chairman's statement earlier. And so we're really focused in an interdivisional task force across the commission, trying to find solutions and think about how can we modernize the current requirements for e-delivery. And we're excited to have something we can share about that soon.
This is where I can make it awkward for you.
Go for it.
Now, look, kudos. When I left the commission, we were doing Norm Champ's suite of rules back in 20, Lord knows what, 14, 15, right? 14. And I think we teed up 33 there. And but we were talking about like paper versus a PDF email, and that was controversial, right? And I think today, you hear the chairman talk about a financial super app, which is music to my ears, as you might imagine. You don't even, today's younger investing generation, which we have a lot of at Robinhood, they don't want a PDF in an email, right? They want to go to one place and get everything. So I just encourage you, and I know it's kind of like a hostage video. You can't show emotion to me right now, but I want to encourage you to think about not just e-delivery, but the form of e, right? To be really innovative, to really give rise to this notion of a financial super app.
And I think that's one thing that people have stressed to us when we've met with them, is this theme that, innovation is happening so rapidly. Yeah. Every year it goes faster and faster. Technology is evolving so rapidly. So we've got a lot of advocacy on tech neutrality and like how can you design these rules principally based so that it can evolve with the technology as opposed to fixing you in a place and then 10 years it's like, well, we don't use that anymore.
Absolutely
So that is certainly something we've heard a lot and we've taken into consideration.
You know what's funny, Dan, is because I've ranted a little bit about that, and I usually hold up the phone and I go, look, the 4-inch screen, this is your interface to your investor. It's not a big 8.5 by 11 PDF. And you should be thinking about, this is to people who are sending these, the issuers at the fund side and the public company side. You should be thinking about how to get that out. Maybe AI agents are the answer. I think I'm very big on AI agents and being an interface between the ultimate investor and shareholder for our Corpin friends, but the investor and the investment company or the sponsor or whatever. And I think there's so much we can do with that. It could solve the problem of having older Americans, older investors who don't want to have it, because I know I use my mom all the time, and my mom throws away everything that comes in a blue envelope. Like, it just goes out. But if she gets an email, she'll flip it to me. And my mother, like I think every grandmother in America, probably around the world, is on Facebook because that's where the kids' pictures are. And she figured that out in about 10 seconds. And if you lean way into the new technology, you jump over the adoption issues, right? So I talk about that. The first time I did that, I actually got some very concerned calls, though. And people said, oh my God, I see what's happening. You're going to make the same mistake every other division director did, which is you're going to ignore this to get to the next step, and you're going to get nothing done because you're never going to be perfect. So what Robert said, this technology neutral platform, is something we're very much interested in. We don't want to be making the mistakes of legislating, we don't really legislate, but regulating for today's technology. Like, this 4-inch interface is not going to be what we use in 5 years. I mean, it'll be something else. I don't know, those glasses or some Neuralink in 10 years or whatever. And I'm really hoping some division director 10 years from now or 20 years from now is not looking back and cursing me the way we're cursing the people who put, write once, read many technology requirements into record keeping. It's like, oh gosh.
That's Macchiaroli. He's on the next panel. We're gonna get him on that.
Well, I'm going to highlight that one of our former IM colleagues one time referred to IM senior leaders as a wax museum, which now that I'm reaching wax status, I guess. But everything that we're discussing here is going to would have to transform literally everything that we do in our office, but hopefully for the better.
And one thing I just call out to you that, it's how we run our business, is listen to the investors too, more than the players, right? Than the market participants. Like, how do they take in information? And we study this very carefully, right? And that's why you get accused of things like gamification when you're actually speaking to folks in the language they prefer. You're teaching them in a way that they actually learn. And in some ways, is it a more common way of speaking than the legalese usually? Yes, of course. But are they able to take it in that way? Yeah, and that's the way they want it too. So maybe that helps you when you try to make something that's technology agnostic, or at a minimum, it'll give you guidelines as to what the people want, not necessarily what the firms want to give them.
Sounds like a good comment letter.
I have one of my agentic AIs write one for you.
There you
go. So looking ahead a little bit, I know we've done a lot of looking ahead on this panel, but for each of your offices, and this will go into your performance review, let's talk a little bit about what we should be expecting in the future. Like, where do you think we're going? And then Dan can punch holes in it and tell us how to do a better job.
We have done a lot of clarification work on rules such as the fund-of-fund investments, the CLOs, the names rule, the marketing rules, those newer rules, and we're hearing that there are still questions out there in the market for those. And again, like I mentioned earlier, it's not that we issue applications and we're done. There are a lot of operational questions we're hearing from the industry about both share class and, for instance, the new streamlined co-investment relief. We're engaging on those and trying to see where we can provide clarity in what form that clarity should take. So that's kind of where we are next.
I guess I'll jump in, with disclosure. I think that our office, I think, is necessarily reactive to what the industry is going to bring in and file with us. But one of the things that I was thinking about in this regard, that we made a bit of press last year at SEC Speaks with an announcement regarding funds investing in private funds or in private assets generally, just sort of reporting out on what's kind of happened since then. If you recall, in last year's SEC Speaks, announced that we would not be giving the comments for funds of private funds that either that they must have an accredited investor standard or limit their investments to 15%. Since then, we've seen a number of funds come in and you make those changes. So the staff has had to consider the issues that revolve around those. And if you recall, following that that announcement, the staff, in order to help folks as they were making filings and making disclosures, we issued an ADI, which stands for Accounting and Disclosure Information, and it was highlighting the filing processes and the disclosures that we would expect to see, for funds that were making these changes following that announcement. I guess I'm happy to say that it sort of went exactly the way we would have expected it would have gone. In terms of the disclosures that we've seen, I don't think that was ever going to be a hard issue. As we've had funds, 33 Act-registered funds investing in private funds, for more than 20 years. I think that if those hadn't been getting it right, I wouldn't have been doing my job for the last 20 years. In terms of the types of filings that we would have expected, it was pretty much exactly as we expected it would be. And for funds that were taking away the accredited investor standard, it was simple supplements, 424s and 486B amendments to just remove the accredited investor standard. For funds that wanted to remove the 15% limits, it was more likely, and I think anecdotally, it was primarily 46A filings that folks would make to make the changes. Or I should say that those also weren't monolithic. As in the disclosures that we would have expected for a fund that was making a nominal increase in their holdings in private funds would have been way different from a fund that was changing to become a fund of funds. So I'll stop there.
So in addition to e-delivery, I'll talk about two other kind of areas that, there's public knowledge we've gotten direction from the chair on, or there's focus there. So the first one I talk about is retail access to alternative investments. So I think as most people are aware, there's an executive order directing the DOL to work on 401ks and providing access to alternative investments, and it also directs us, the commission, to collaborate with them, and we've been doing that. We're also responsible for post-tax pre-retirement dollars. Now, there's a lot of pressure, a lot of energy around retail access, and so we're also talking a lot about that internally and engaging with folks and trying to find ways to provide greater access. So can't share anything specific today, but I'm hoping to have some announcements soon on that. The other thing I wanted to talk about was crypto. And as a lot of people probably saw, there's been some recent announcements by the SEC on crypto. In the IM world, where a lot of attention has been focused. There was a bunch of crypto roundtables that were put on last year that have been really helpful, but a lot of attention and energy that we received in those roundtables was on custody in the IM space for investment advisors and investment companies. So we've been meeting with a lot of folks, particularly on questions, issues related to custody of crypto assets by those entities. And they've flagged a number of things, but I would say the biggest themes, if you read the roundtable letters, are what to do with crypto assets where there might not be a qualified custodian available, how to think about state trusts who are providing custodial services, and then how to think about trading and DeFi activities. So I think that's all areas where there's been a lot of attention, a lot of public letters that, we're really looking forward to hopefully having some things to share more on soon.
I didn't write a letter, so we can put this in the file, but on that point for crypto custody, and I think it's relevant to the trading markets panel too, the notion that you can't use state banks or state trusts is really a tough one to swallow for the industry. And for legit players like us, for everybody, right, being driven into national banks isn't exactly ideal given that history with banking over the last several years and how the political winds change and impact bank regulatory issues too. So it's a huge issue. You already called it out. I know it's going to be a tough one to consider, but I'll just say that is just a massive issue for folks. And it kind of it portends to crimp innovation too if you don't have the ability to, select state-regulated entities.
Yeah, I don't want one piece to go unnoticed because Robert put it out there, but this responsible retailization effort that we're engaged in, it really affects all of your offices. And I know you guys, I suspect, have a vested interest in us getting that right.
Yeah, I think, we're super interested in it. You guys saw we launched a closed-end fund, trying to bring access. I think that's about as responsible as you could get by way of vehicles. But there are other ways to do that also. In this day and age of AI, I think this is the most vexing thing, and I think about this a lot. The whole notion of accreditation, what standards should you have to have access to privates. It should be about savvy. It should be about understanding of the product. It should be, risk tolerance. It shouldn't be nanny state. You're rich and you're not, which it has been forever. It's the millionaire's rule. Just think broadly as you think through these things, right? I mean, I personally, I've raised this, through the building and the SROs and other agencies. In a world where you can queue up AI and get really sophisticated analyses that you used to require a financial professional for, think about other ways to get to the access, without divorcing it from any sort of control. I'm not suggesting, it should be like the over-the-counter markets or anything.
Without addressing anybody's specific filing or because there are a few that have come out relating to the retailization of the private assets, whether it be private credit or, private, the equity of private companies, including the one you mentioned. I think that the things that we in disclosure, because there have been a few, and, I think that, the things that we're thinking about in that regard is obviously lining up the liquidity with the type of vehicle that you're investing in. Obviously, for most of these assets, it makes a whole lot more sense to put them into BDCs or into closed-end funds. BDCs for the last 25 years that I've been doing this have been the primary vehicle for private credit. But again, there are also some vehicles that are looking to put private equity into their closed-end funds, which has been interesting. The things that we're thinking about there, obviously valuation is always an important thing that we're always, worried about, thinking about. And I think that the other thing is how you're structuring, how you're getting access to the private assets, whether you're holding something directly, whether you're holding it through, an SPV, or whether you're holding it through an SPV where you get indirect interest or a contract to get some interest. It's very important to us that information be laid out, transparent for, investors to understand. So an investor would understand, do you hold company X? Or do you hold an SPV that holds another SPV that holds a contract to possibly in the future get company X? You know, and the differences matter, you know, and so in financial statement disclosure, we ask folks to make it clear what the unit of account, you know, for the asset that they are in fact holding, you know, with an allowance to allow them to say, this is a vehicle that holds X.
Right.
Not the company X, sorry.
And we actually...
Not specifically the company
Oh, gosh, I didn't even think of that. That's great.
Acme Pretend
All right, let's
Company.
move past that really quick. We'll save you from that. But we did have, just 2 or 3 weeks ago, we had a roundtable on this, which wound up being somewhat prescient about the challenges of fair value and liquidity and retailization. And that's actually now up. It's fairly short, 2 panels, 45 minutes each, all-star cast of outside experts. And if you ever want to spin through that, that's worthwhile. But we're definitely, you know, we're attuned to this risk, not the risk, this tension out there between retail access, liquidity, and valuation. Like it's all one continuum or one interlocked, you know, web or whatever metaphor you want to use.
And not to just throw out another catchy term, and it's not your CLE term, I think tokenization as it rolls out will actually impact the private space, or it could impact the private space in a much more dramatic way. I think on the listed equity side, it's just going to make the plumbing better. But on the private side, and I've now gotten into the depths of, you know, the private side, the transparency, you know, the ability for smart contracts, all this other stuff should help, I would hope, as far as, you know, investor understanding of the things that they're owning, you know, liquidity issues, right? Being able to measure what's out there and interest, you know, the fungibility, everything else. So just a wait and see on that. I think you're going to see some leaps and bounds improvements.
Rachel, why don't we close with you, but what's ahead for us in the Chief Counsel world?
Like I mentioned earlier, we can't talk about everything we're working on. That's the problem. But we are like the engagement is there, and like I said, we're following up a lot on some of the questions we've been presented with on the retailization that you were talking about. We are looking at valuation questions and so forth for that would follow up from, for instance, the streamlined co-investment relief that we issued earlier last year, which is going to bring more opportunities for BDCs and closed-end funds to enter into different kinds of assets, because as they invest alongside their the private funds, their affiliated private funds, they have access to different assets, so more retailization of certain assets, which is good. But we also always have that tension with investor protection. So, but this is the next. The next is clarification of existing rules so that our registrants can continue function through FAQs, no action letters, and if there's something novel, probably exemptive apps.
So Dan, I know this is called SEC Speaks, but it's also SEC Listens. You want to close out? What should we listen to?
Wow, this is awesome. I've never had this. This is my 30th time doing this at Speaks, and I usually try to get a word in edgewise and don't get it. Thank you. Look, I mean, I think I've spoken my mind on the things you guys have brought up. I think the e-delivery thing is just massive, and I know it's a huge rulemaking, literally. So please, you know, any progress there, I think, is huge. I do think the retailization thing, obviously, you know, approach it. I know you're coordinating with the other divisions, but it is kind of fascinating how it all links together, right? Like this private valuation issue, right? You're gonna need trading and markets to think through some of the market structure issues there, which they're doing already, I think, and also for the listed markets. Valuation, I mean, at the end of the day, and Rachel, I think, hit it perfectly. The investor protection side of valuation is so massive, and the investor confidence. I was on the commission when Mary Jo gave a speech, Chair White gave a speech. I think it was at Stanford, and she, I don't know, maybe one of you wrote it. It was about just thrashed valuations for you know, private securities held through some investment companies. And I mean, the run on some of these asset managers, and I mean, the impact was just like a nuclear bomb went off, right? And it was because, you know, it's in a way, it's a third rail. It's so sensitive. It has to be right. And if folks question that valuation, they don't come and they leave, which we saw, my gosh, it must have been like 2015 or something when she gave that speech. So I think the valuation issue is massive. Any refinements to existing guidance be appreciated. You know, recognition of the new technology and how that impacts valuation, I think would be huge. And other than that, look, you know, again, I'm a trading markets person by nature, but have had the occasion over the last year to work with the staff, and I, you know, can't say enough. I mean, kudos to all of you. You've been through, it's been a bit of a tumultuous time, and I know you've lost some staff and government shutdowns and all this stuff, but the work continues, and I think that's something that you can say about the whole agency, right? At the end of the day, the agency's been through some rough times, but the work continues, and I think you guys are doing a great job. So, and I stole one of your staffers, and Aaron Elias, and he's amazing, and it's so nice to have an IM.
We're not bitter about that at all.
Yeah,
Go
sorry,
ahead.
sorry. I had to, and I stole one of your best ones. But it's so great to have a real, you know, I can like play IM sometimes, but I'm not a real IM practitioner. When you have one in-house, it's kind of an amazing thing. So, so kudos to the division and keep up the good work.
Well, so we have this way of thanking people now who give us a service in IM. And we have these challenge coins that we had minted. And they're using director dollars, not taxpayer dollars, just to be clear. So we'll just pass this down. Maybe you can just take a look at it. So thank you so much for coming today and working with us. And we have a snazzy little slogan on the back.
The best regs for your nest eggs. I love that. That is really cool.
So we had a contest for that,
I have
actually.
a Robin Hood one, but I know you wouldn't take it. So when you leave office, I'll keep it in reserve for you. But thanks, guys. This is terrific.
All right, well, thank you for coming with us, and thanks everybody in the audience for coming, and for those of you in virtual land for tuning in.
That's hilarious. It's so good.
It's really pretty, too. You see it? Yes, I know.
My goodness.
Well, I spent a lot of time actually designing.
So we are on a break until 3:05 when we'll resume with trading and markets. Thanks.
Good afternoon. At this time, we would kindly ask that you please take your seats and silence all devices as our program is about to begin. Thank you.
Okay, you heard that countdown, right? So we're back, and we're here for the final panel before the workshop sessions. I will say the last panel did a good job on a teaser, not only for their upcoming rulemakings, but for this panel as well. I will begin by introducing the director of Trading and Markets, Jamie Selway, who became the division director in June of 2025. Prior to that, he was a partner at Sofron Advisors, a board member of Protego Holdings, an advisor to several fintechs, including All of Us Financial and SKU, and the chief economist of Archipelago, and an equity derivatives research in the department at Goldman. A good equity derivatives research, right? Analyst. Then I want, even though I haven't been told to, I would like to introduce John Cropper, who, you knew that was coming, who's a new deputy director. He was my counsel, so obviously he receives many accolades from me for that time. And he just returned to the SEC after 16 years at FINRA 7 months ago, shortly before the government closed down, I believe. John was instrumental in keeping a pace of cyberspace report that was referenced earlier in the day. And just a personal anecdote, I have 2 daughters that are both in law school. One of them I'm going to go speak to, and my daughter asked her business enterprise professor if he would like me to come to class or talk or do something while I was there. And he looked and he said, "Your mother was a commissioner? Laura Unger? Keeping a pace of cyberspace?" So the infamy of that report lives on, and that was a decade, 2.5 decades ago. So it was good work. I do not need to introduce Dan and Elad, the 2 commentators, because I did that earlier today. So with that, this is a big panel, and I'm sure you have a lot to say. So I turn it over to you. First, all right, I'm going to just say it again. Please consider the comments of this session's panelists. CLE credit. Okay, thanks.
Great. Thanks so much, Laura. I'll start with a disclaimer, which you've probably heard a number of times. The comments you'll hear today are the personal views of the senior leadership of the division, not necessarily those of the chairman, the commissioner, or any of the staff. So we're going to organize ourselves today We're going to start with 3 popular themes. We're going to talk about CFTC harmonization. We're going to talk about tokenized securities and crypto. And we're going to talk a bit about 24/5 or 24/7 trading. And then we'll get into particulars in terms of the rulemaking. We're going to start with Deputy Director Corpin introducing the senior officers.
Great, thank you, Jamie. So to my immediate left here, I have Andrea Orr, head of our legal review office. Next to Andrea is Eric Huzenas, who is the head of our Office of Market Oversight. Next to him is Jeff Mooney, who's the head of Office of Clearance and Settlement, and Carol McGee, who's the head of the Office of Derivatives Policy and Trading Practices. Down the row is Mike Macchiaroli, head of our Office of Broker-Dealer Finances. Next is Emily Russell, who is the Chief Counsel of the Office of Chief Counsel. And finally, Alex Jodin, who is the Acting Associate Director of our Office of Analytics and Research. And Alad and Dan go without introduction now. So I'll hand it back to Jamie to get right into the topics. We have a limited amount of time, but we have a lot to share with you. So, Jamie?
So understand that our colleague, Director Maloney, might have organized a drinking game around ACT that might have been oriented towards caffeine. If you've got stronger stuff in mind for our panel, you're welcome to it. So our first one, CFTC, SEC harmonization, is absolutely a clarify project, as the chairman alluded to in his remarks, and we will start with discussion there with Carol.
Thanks, JP. So as you've heard, the SEC and the CFTC have launched a harmonization initiative. As should be aware, the CFTC and the SEC sometimes divide our jurisdiction. Sometimes we share jurisdiction over different but sometimes similar products and markets. They can be intertwined, and sometimes the lines are really unclear. This initiative is a collaboration that's really meant to strengthen the regulatory framework for U.S. financial markets and to provide clarity about what rules apply to what products, and also to reduce duplicative regulation when we can do that. We recently signed an MOU, the 2 agencies, to ensure that we're working together as efficiently, both in the policy divisions and then also in enforcement and examinations. From TM's perspective, this initiative really includes a number of different things. From my perspective, from the Office of Derivatives Policy, we're definitely looking at further defining or interpreting some of the definitions that determine the regulatory treatment of a financial instrument. Security futures, other types of securities, security-based swaps versus swaps. Again, this comes up in a number of different areas for us, but most recently, it's certainly coming up in the predictive markets. To the extent you're talking about event contracts on prediction markets, they might be swaps. They also might be security-based swaps. They could also be other types of financial instruments, including options or notes, which are excluded from that definition. We think it's really important to work with the CFTC to give markets clarity about those products and how they can trade. And we are definitely focused on getting out of the way of lawful innovation, but also staying true to our respective missions. Obviously, from our perspective, as you all know, for us, that is investor protection, ensuring fair, orderly, and efficient markets, and capital formation. So with that, I'm going to turn to Eric Huzenas, who's going to talk about another aspect of harmonization, the existing exemptive applications.
Thanks, Carol. So Carol's office, it tells us what a product is, and then as head of the Office of Market Supervision, we try and figure out how that product trades on the organized trading platforms. So as it relates to the CFTC SEC harmonization product, I would put it in sort of 2 categories. There's, and this has been the case for years, there's always novel products that come up between the agencies, and there's a question of where they fit. And that gives us one opportunity to think through harmonization. And then the second group is people come in with questions, and I think this is related to what our chairman calls the super app idea of, products being able to trade on a single platform. And so that's really the second track of thinking through how that might occur. And these are both things that we're working with on the CFTC. From the product side, the products that Our foremost in this area are filings we have from a couple of the securities exchanges for what would be an option, cash-settled option on basically spot crypto products. And so these are ones where the exchanges have been talking with the CFTC about a potential exemption that could allow them to trade on a securities exchange, and then from our side, we'll be working with the CFTC and the exchange based on whatever relief or whatever approach that the CFTC would take. And so that's an example of the product ones. We also have some interesting new products that are products which combine a future and an option in a type of interspread product. This is something that the CBOE has filed and that we're working on. And this is slightly different. This one relies on having a rule on the designated contract market side that potentially allows it to trade on the National Securities Exchange in a type of package. And right now we have a live filing before the Commission from the CBOE that we are sorting through. And the last category that I will talk about is in our continuing effort to harmonize with the CFTC around the trading of security-based swaps. We have recently issued no action relief that's similar to what the CFTC has for an order book, the requirement for a security-based swap execution facility to have an order book, and also providing relief from having to structure the data that is in the Chief Compliance Officer reports required of SBSFs. So continuing to make progress, but we're at the beginning stages of conversations, and it should be interesting.
Michael?
Oh, I'm sorry. We've started discussions with our colleagues at the CFTC on the various financial responsibility rules, which will be applicable to both broker-dealers and FCMs. A key issue will be portfolio margining, which will become more important when the Clarity Act becomes law. So we hope to continue those discussions with the CFTC in the near future and wind this up as quickly as possible. Thank you.
The MOU that Carol mentioned includes provisions that provide for data sharing between the SEC and the CFTC. These explicitly include swaps and security-based swaps and provide for the respective commissions to access one another's data directly as far as practicable, but also to develop shared analytic tools and environments, which will be a novel development for us to have the opportunity to work more closely with one another. But the MOU also will cover other areas of interest for us that we've long had a shared interest in monitoring, so futures markets that overlap, but also, importantly now, digital asset markets and emerging prediction markets.
Maybe take a moment to see if our moderators have got anything on their mind with respect to harmonization.
I was consulting Grok. So trying to size, what's the size of the securities-based swap market? Do you guys have a sense? Like what notional? Or
what's the?
Like just how big is it? Because my recollection is so tiny compared to the CFTC credit side.
I'm going to ask my co-counsel down there at the end of the table, because I think there's a mix of on-exchange, off-exchange, but I can hazard a guess, but I don't know. Alex, do you know?
I could have found a better time to ask you guys this than on this panel, but just like curiosity. And I get it's related to a substantive question, which is, all this you can do all the harmonization you want, but if like you face self-certification versus 19B, right, from a product selection standpoint, what the market's going to come up with, we all know the answer to that, right? And is there, as part of this harmonization project, is there any thought being given, and I know a lot of it's in legislation, believe me, I know 19B really well, on ways to kind of compete a little better, at least, or make it less of a sort of disincentive to go through the SEC process?
No, thanks, Dan. It's a great question. And though I don't know the notional size of the security-based swap, I know from going through the execution platform, you're absolutely correct. The volume of security-based swaps on swap execution facilities is many times smaller than interest rate swaps. The interesting thing about the Dodd-Frank Act is it does clearly say that security-based swaps can trade on a securities exchange. But in order to do that, a securities exchange, for instance, would need to make the rule filing. And I would expect that, in any rule filing, an exchange is going to consider kind of the competitive difference between, or just the rule filing difference between the 19B approach and the approach which exists for security-based swap execution facilities, which is patterned more on the CFTC's self-certification. So I think there will be an opportunity for the Commission to consider that, depending on what filings the entities seeking to do this put before us.
So we have done some things in the crypto space with generic ETPs. I think Carol may have some thoughts in terms of what we might do in the swaps world.
I do. One thing I wanted to mention was a couple of things. Like the swap market is obviously much bigger. That's because of the interest rate swaps. The interest rate swaps did not cause the financial crisis. So, we're still 50% of the CDS. And I think if you look at the semi-annual reports that we did put out, the equity size is much bigger than anyone thought. We're talking about trillions, so it's not a tiny market.
Okay.
It might not be the same size as the CFTC, but it's still quite, and it has impacts on the underlying securities market. So obviously that's
Carol,
just
you
to stand
always
up for
know
our
the
market.
answer. It's so good. You're better than Grok. You beat Grok. Thank you.
But I would also say that, yes, we are, obviously, as part of harmonization, we are looking to ways to make this as rational a marketplace as possible, to harmonize as much as we can with the CFTC. There are different statutes and things that we can and can't do, but we're certainly looking at ways to make ourselves, so it's not that if something is a security-based swap, it dies. That's obviously in nobody's interest.
Right, yeah. I mean, you just don't want, and I love the CFTC and I love the whole model, but, from an investor protection standpoint and everything else, you wouldn't want to drive them out, when there's an economically equivalent product, especially in a post-harmonization world. It's really easy to go to the CFTC side. It shouldn't be about a process, right? It should be about the substance of the market, so.
We agree with that.
Agree, yeah.
I'm going to save it. I want to actually follow up on this, but I know we're going to talk later about sort of what the exchanges are doing. But I do think one theme that Dan is pointing out, which I think is part of what the chairman has talked about through ACT, it is just, and what he said, and I think that there's a lot of dead rules in between the CFTC and the SEC, sort of no man's land space. It's this idea of making sure everyone has the requisite protections. We all know the mission of the SEC, but ensuring that you're not in a negative place because you are a registrant, and how to sort of enable innovation when there could be another framework that is addressing the concerns that the Commission always has.
So speaking of no man's land, we'll get to crypto and tokenization, and the division's done a pile of work of which we're very proud. Over the past year. This one is an A for advance because we're, extending our approach to new assets in a thoughtful way. And to discuss some policy here, we're going to start with Michael and some of the things that OBDF has done. Give him a nudge.
Oh, this is the, okay. Our office is currently considering how to import non-security digital assets in the financial responsibility rules, either by directly amending the present rules or fashioning separate rules, which we did for swaps. The key issues in this area will remain: what is custody for customer assets when you're talking about digital assets? That is, the rules mainly concern themselves with certificates. The whole rule is premised on certificates. Now, So we have to deal with crypto things where there are no certificates. The other issues will be what is a ready market for assets held by the broker-dealer, crypto assets, not securities, but crypto assets, which ones will be deemed to have a ready market of the thousands of different currencies. The third issue will be portfolio margining, which will become more serious, again, when the Clarity Act is passed, and we've been discussing that with the CFTC, although we're not really in any way ready to deal with that. So there are the key issues under this. We recently issued a no-action letter deeming stable coins under the Genius Act to have a ready market, and they will get a 2% haircut. So that's our contribution to the literature.
Thanks, Mike. So today I'm going to cover 3 items. First, I'm going to describe the staff's no-action letter to DTC to enable it to launch its pilot tokenized securities program. Second, I'm going to provide an update on the Paxos application to register as a clearing agency. And finally, I want to just briefly note some staff FAQ earlier today that earlier last year that clarified application of the transfer agent rules to blockchain technology. So in December of last year, the staff issued a no-action letter to DTC, allowing it to undertake a 3-year pilot program for tokenizing DTC custody securities. The pilot program that would not alter the existing DTC's indirect holding model. Securities would remain registered in the name of CD & Co., and DTC participants would continue to hold a security entitlement against DTC as its securities intermediary. The tokenization would occur after DTC debits the subject securities from the DTC's participants' book entry account and then credits them to a digital omnibus account that would reflect the sum of all the tokens held in the registered wallets. To participate, a DTC participant would register one or more wallet addresses for an approved blockchain wallet with DTC for the purpose of holding tokens associated with the securities entitlements. A DTC participant also may move securities back into book entry form by instructing DTC to detokenize the position, at which point the tokens are burned and the securities are recredited to the DTC participant securities account. Under the program, DTC would retain administrative control over the tokens, including an ability to mint, burn, and in some instances, transfer, in limited instances, transfer tokens that were sent to erroneous addresses. The staff's no-action position relies on a series of safeguards that are designed to limit systemic risk and also protect investors. These include, first, the separation of the tokenized systems from DTC's core clearance and settlement system, strict eligibility requirements for the securities, the participants, and the supported blockchains and tokenized protocols. There's also transparency commitments, including public disclosure for supported blockchains and prescribed technology standards and fees. Also, DTC is required to provide detailed quarterly reporting to the staff regarding participation levels, asset volume, systems performance, and also governance matters. Since the staff has issued the no-action letter, we continue to monitor DTC closely as they prepare to launch their pilot later this year. Next, I'll provide an update on the Paxos registration, register as a clearing agency. Actually, back in 2019, in October, the staff issued a no-action letter to Paxos Trust Company, an affiliate of the Paxos, current applicant, Paxos Securities, that allowed that entity to undertake essentially to operate a blockchain-based security settlement program without registering as a clearing agency. The initiative enabled Paxos to test its settlement platform for U.S. equities in a controlled, de minimis environment with strict participant and reporting requirements. The relief at that time was intended to evaluate the benefits of distributed ledger technology and simply expired based on its terms. So in July, Paxos Securities submitted its application. Under its application, it would operate provide clearance and settlement services as a CSD and a security settlement service. And again, their proposed service would be delivered through a private permission settlement service supported by DLT technology that facilitates bilateral DVP settlement. Earlier, in March of this year, the Commission published notice of an amendment to Paxos's application, and the comment period for that amendment closes on April 6th. Lastly, I'd just like to note that as part of the Commission's or the staff's broad FAQs covering a number of crypto issues, one of which FAQ focused on clarified the ability of transfer agents to use the blockchain as part of its master security holder file, and the key issue question there was whether or not the master security holder file could be kept in essentially separate sources. So I'll stop there and turn it back over.
Can I ask a question, James?
Sure.
Jeff Mooney, I love your stuff. Good stuff. I told you 20 years ago you got the best job in TM, and now it's actually true. Back then I was just selling you on it. Yeah, but now it's cool because of blockchain. So this is really interesting. So the DTC no action letter, and then the Paxos. If the Paxos, hypothetically, application was approved tomorrow, is it substantially similar activity happening through those two licenses with the no action letter relief as far as tokenized equities or the ability to trade tokenized equities?
The underlying clearance and settlement activity is consistent. So for essentially, because part of Paxos's application Paxos's proposal is that they would essentially have a link to DTC and be able to provide clearance and settlement services, again, for clearance and settlement services for securities that are already on deposited DTC. So if they were both operating now, there would essentially be a choice or a competition for tokenized clearance and settlement of DTC eligible instruments.
That's pretty exciting stuff. And to be clear, I love DTC. If anyone from DTC is in the audience, it's wonderful service, and please, I love DTC, but that's really neat.
Yeah, I mean, we have in the U.S. clearance and settlement system, we haven't had this type of, or potentially this type of paradigm since the late 70s, when with the regional exchanges and their separate clearance and settlement facilities. So we are taking a step forward and going back into, taking a step, I guess, forward and then going back into the past as well.
And I mean this sincerely. I actually give DTC a lot of credit because it's not lip service stuff with this no action relief. It's real, right? Jamie?
Is there margin call at risk? I say. Advancing the clearing agency frontier.
Especially NSCC. It's so good. Love it.
Eric, you want to pick us up?
Sure. So two things to add to what Jeff just talked about. The first I want to highlight is a NASDAQ filing that would amend NASDAQ's rules to essentially provide for the trading of tokenized securities to be the same as the traditional securities. So that's a filing that's before the Commission, and we're looking at that builds on some of the work that Jeff's group is doing on the clearing agency front. And then the other one that our chairman has spoken about quite a bit is an innovation exemption that would allow platforms using digital technologies, distributed ledger technologies, for example, to experiment and innovate while the Commission is considering what additional changes that might be needed in market structure to accommodate crypto.
Just approve the tokenization.
Oh, okay. And I'm happy to report the NASDAQ tokenization filing was just approved this afternoon. So thank you, Andrea. So that's exciting. It had not been approved when I came here, so I guess when I leave the office, good things happen.
Carol?
Yeah, so I'm going to talk a little bit about the tokenization statement. I'm sure other people have talked about it during this long day, so I'll be really quick. But at the end of January, staff from the 3 policy divisions published a tokenization statement. It addresses common questions about tokenized securities and what laws apply to these. From TM's perspective, the statement includes a definition, which is a financial instrument that means the definition of a security that is formatted as or represented by a crypto asset with ownership records maintained in whole or in part on one or more crypto networks. It's really viewed, or the staff really views the statement as addressing a technological process, creating a digital representation of a tangible or intangible asset using blockchain distributed ledger technology. The tokenization itself, a big message here, is that doesn't change how the securities laws apply. That being said, the way that you structure your token might. For example, a tokenized security might just be something another way to represent the same security, or it might be an entitlement to that underlying asset. But at other times, you might actually separate the rights from and obligations from the benefits of the token. And in that case, you might have created a different class of security of the issuer, or even a different issuer's security. Where that's most salient, and you can tell that I'm passionate about security-based swaps, so that's why I'm the one who gets to talk about the tokenization statement. Where it's most salient is when you're talking about a third-party issuer issuing a token and really creating something synthetic. So it's referencing the other asset, and maybe it's a structured note, maybe it's an exchangeable security, but it's not the same thing. And so you need to think about what does that mean for the securities laws. The other place where it pops up is security-based swaps. Here where third party has issued it, and it really is separate from the underlying rights and obligations of that reference asset. You might have created a security-based swap. Why does that matter? Because in security-based swaps, there's a bunch of different rules that came in with Title VII. Two of the really important ones when you're talking about retail are under the 33 Act. There are no exemptions from registration, so you have to register them, and they have to be on a national securities exchange. And so if you're tokenizing, it's important to keep those things in mind.
Thank you, Carol, for that. For those of you who are unfamiliar with my office, a key aspect of our work is handling issues related to broker-dealer registration, status, for example, and their regulation. So one of our primary focuses in this regard over the past year has been evaluating the application of broker-dealer registration requirements and associated regulatory obligations to activities involving crypto asset securities. You may have missed it, so I'll highlight that last month the chairman indicated that he expected the commission and the staff to issue or consider providing no action or exemptive relief to provide clarity around the registration requirements as applied to wallets and interfaces. We've had a lot of conversations with industry over the past year in this regard, and we look forward to continuing that as we move forward.
Thanks, Emily. One area that we've been following closely in our office is the issuance of tokenized versions of NMS stocks. To be clear, these are largely being done overseas. It's not in the United States yet, but we have been keeping a close eye on this to understand how they're being traded, where they're being traded, and how closely they're tracking trading here in the United States on our markets. And we now have, and you may be familiar with some of our data systems called Midas, and so in addition to getting equity exchange data, options data, we now get a fair amount of crypto data directly from trading venues, but we also are expanding our ability to look at activity directly on blockchains, and so we're using that to understand how tokenized securities are trading ahead of when this might become more prevalent in our markets.
Why are you looking at me? So I have a question for you, and I asked this in the IM panel too. We'll see. I'll grade you later. But so in this topic in particular, it seems like there's lots of folks who aren't sort of regular practitioners in front of the commission. They're innovators. They're coming from divergent places, and I hear a lot all the time of, "Gosh, I just met with the SEC staff, and I think they're good with this idea," and I'm sitting there like, that's impossible. Like, there's just no way. And so I'd ask the IM staff, like, is part of this new sort of sandbox type or innovation type approach to things and encouraging people to come in so you can hear and understand what's happening, is it also like, and my friend Amy Starr is somewhere in the crowd, I wanted to use this joke in the earlier panel, like, is there no Amy Starr anymore to sit there and say, that's the craziest thing I've ever heard? No? Because you just hear from folks, I think they feel, even without a no action letter in hand or an exemptive order, they've met with you, they ran some idea by you that clearly violates all the securities laws upside down and sideways, and they're like, they didn't show any emotion, it's awesome, we're gonna roll this thing out.
So maybe I'll start and others can jump in. I think, and we've actually shook the finger a little bit at maybe one such non-registrant. I mean, when we are good and when we were done, it's a matter of public record, and that good done is available to similarly situated people, and that's just the way the building works. And it has been an exercise to help sort of the newbies get a sense of how the buildings work. I think they're getting better. There's still probably room for improvement.
Yeah.
Yeah, I mean, I would echo that. I think particularly with trading in markets, because there's clearing rules, there's trading rules, there's different exemptions. I mean, it covers a really broad area. So I think sometimes people coming in, particularly if they don't have TM-focused counsel, you know, which if you're an innovator, maybe you're coming in, you don't even realize that. I think sometimes they have trouble interpreting what staff are saying, and maybe like you said, and I think as Jamie said, I think people are learning, but I think sometimes you get people that may be coming in that are experienced with the IM process or the Corpin process, but don't really appreciate the different facets of the TM process. And we definitely are here to talk through with people and try and share thoughts with them and perspectives, but you know, sometimes that is a challenge.
What I see a lot, and I'm sure you guys see it too, it's just sort of, I don't like this registration category because I don't want to be registered and carry that burden, or I don't think it applies for whatever reasons. Rachel Loco on the IM panel raised the great point. If you come in and you say, I'm doing this thing, and I don't think it should trigger registration, or it does, but you shouldn't require it because of X, Y, and Z, right? Like, what's the purpose of the registration, right? What's the statutory?
I think Emily might have a fantastic perspective on that.
Am I teeing Emily up for the
Well, I
the
mean, you
dunk on
know,
this?
it's a conversation, you know, worth having, and I have been having with people, is trying to understand what are the activities, and looking at historical statements the commission has said, and where we've been, or the staff has been in the past, and evaluating that. And then, but I think it is a twofold conversation. Is it that my activity doesn't trigger the obligation, or is it, okay, I'm in, why are certain aspects of the regulation problematic?
Right.
And then that's a different conversation. Right. But they could happen at the same time.
Right. It's just interesting, though. I think there are a lot of folks out there that just think it's so innovative, or it's so much more transparent because it's on a blockchain or something. That's such a good for everybody. It shouldn't come with any burdens whatsoever, right? And I get it. You guys are administering the federal securities laws, 100 years worth of it. And you can say, which you hear a lot, right? This rule's 80 years old. This legislation's 80 years. Right, it is, but it does something, right? If it's broker-dealer registration, what does it do? It makes sure that you're treated fairly. It protects your assets. It does these things. So if you're not going to register as a broker, who's going to do those things? Tell me why, right? And you just don't hear a lot of that. So it's just interesting. I don't envy you guys, you know, having some of these conversations, but it is interesting when it gets translated to the outside world as, oh, I met with trading markets. It's all's good. I'm going to go blow up the free world.
Can I just say, so I spent the beginning of my career in Corpin, and this didn't happen to us there. Here in trading and markets, since I've been here, we often get people from the outside coming in and giving us a presentation, and there's no question. And we listen. I mean, obviously, if we saw something really awful, we would say something. But if you don't ask us a question and give us your analysis of why you need an exemption or something should be, we haven't given you relief. We've just listened. And I think that's an important thing for people to understand because, again, we all do very different things. And so if there is relief needed, it's probably a complex process that we'd have to go through. And to Jamie's point, if it's not on the public record, we haven't given relief. We've just listened. As Josephine Tao would always say, we don't give oral no action relief.
There you go.
And to be fair, I don't know that that's always unique to the crypto industry.
I wasn't even specifying
Either.
crypto. I think it's broader than, I think it's just sort of new entrance to the markets generally, right?
Alad, did you have something?
I don't know if I can really blow up the free world, as Dan was saying. But I do think one of the things that, again, I commend you and your colleagues across the divisions, there has been a lot of effort extended to listen, to hear, and to understand this better. And I will say, Jeff, I think the DTC no action letter is amazing, also for going through the process of actually a trade and clearing, which is, you can read the rules, which are actually really well written, but it's a very concise, description of the mechanism, which most people don't think about. They push a button and they never think about clearing, right? And that's also part of I think the broader thinking going forward, which is, I think the chairman's talked about the super app. Like, people don't know if they're with a broker, with an IA, or with that, something else. But it's how do you facilitate their involvement in this ecosystem while maintaining the requisite, protections. And so one of the things that, we've heard about, and I think is really top of mind for a lot of folks, is this innovation exemption that has been spoken about, that, I know you probably can't talk about, but what would be helpful, I think, is, following up what you've been talking about, Emily, and others, what are just general guideposts you're thinking about when we're talking about sort of enabling this new technology to fit into the existing rule sets? And I've heard, Jamie, I've heard you say this, which is, enabling innovation without arbitration, right? And you want to
arbitrage. Well, arbitration is something else, but arbitrage.
But I think that's helpful for people to think about if they're coming in, right? This is to the point where, and you, Carol, said, like, you're going to just listen. You're not going to necessarily say something. And as the DTC no action letter proves, that you need a no action letter in many of these places. But what are some of the things that would be helpful for people to come in and talk to you about, or parameters to at least think about when we're making arguments?
Well, it was touched on, but I think the most helpful kind of feedback you get is when people come in and they do understand the purpose of the rules, or they listen to you when you explain the purpose to the rules, or they don't, and then they try and answer, and I'll just, one of the ones that we request people to come in and talk to us about is national market system rules. So if you want to tokenize a security that trades on an exchange, you have to comply with national market system rules. And a lot of times we'll just get the feedback like, oh, there's no way we could ever, comply with national market system rules. And, we'll say, look, we understand things might not fit here, but what specifically is the challenge? What's your business objective, and what are the hurdles to get there? And surprisingly, now I think we're starting to get people coming in and talking through that, but I think a lot of times it's just that people, and maybe it's what you said, people don't like the registration category, so that's what they're focused on, rather than helping us at the staff level really understand where are the actual operational challenges, where's the legal challenges, and then we can advise, leadership in the commission on whether we think changes make sense, or we can advise the parties on, well, did you think about this in terms of compliance?
So quickly, the chairman and Commissioner Peirce have spoken about, the innovation exemption, I think as recently as a month ago. I've talked about it as a time-limited, volume-limited, platform exemption. So when we say, innovation without arbitrage, what we mean is providing the opportunity for, a non-registrant to sort of look and feel and act a bit like an exchange to compete with exchanges, but we can't grant through exemptions capabilities that an exchange itself couldn't have. So it really, and Dan, you touched on it, it's the difficult exercise of enabling, sort of new entrants to come in to compete, to do things on a, volume, activity limited, time limited basis, but not strain the exchange, not allow the exchanges to sort of counterpunch. And, I think is illustrated by, the approval of NASDAQ's tokenization statement, where I think we're making some progress there. It's a difficult task, and we love to hear feedback, I think, on where, we've got our thumb on a scale, or we've created something that's unfair, because we want to do the best we possibly can to operate or to facilitate a level playing field.
So, just call out on that point. I don't worry about exchanges. I actually think the broker competition is actually a little more interesting when you peel it all back. Because it's not easy being a broker, you know, and you don't want to make it worse, right? You don't want to provide an alternate that has, it's a much easier regime to work in. So.
We would agree, and I think we would say it's across the stack. It's exchanges, it's brokers, it's clearing agencies, it's transfer agencies. I mean, where we've got, requirement, right? We've got requirements for folks. We can't erode those.
Yeah. Yep.
So let's get to another advanced project. And we got I think we're about 18 minutes behind, so we're going to do our best to make up. But this is a 24 by 5. We don't have 24 hours to get this panel in. I think we're going to kick off there with Eric, who's got the most activity.
Yep. So currently exchanges trade during the business hours from 4 a.m. for NMS stocks for 4 a.m. to 8 p.m. And then there is overnight trading on some alternative trading systems, such as Blue Ocean, Moon, and Bruce. So the Commission has approved rule filings for extended hour tradings for the 24X exchange, for example, but those exchanges cannot go live until the securities information processors, or basically the consolidated tapes for reporting securities transactions, are ready. And so that has been one of the stumbling blocks. We have rule filings that the Commission is working on for the consolidated tapes to extend their hours and provide the services. In the meantime, we've gotten exemptive requests from 24X to do trading in the interim, and that is something that the Commission is considering, with the idea that, or at least considering what would be the vehicles. And again, I think this is ensuring fair competition in these areas and also facilitating innovation. So those things are ongoing, and look forward to continuing to sort through them.
Now, this time from the clearing front, I mean, we've been actively monitoring the sort of DTCC's preparations for 24/7 trading. Just want to flag some of our, from the staff's perspective, some of our areas of focus. First, operational resilience, in particular things like cybersecurity, reducing single points of failure, especially during new and extended trading hours, looking at risk management, in particular NSCC's margin frameworks, the adequacy of the default funds, and actually in particular the ability to monitor positions overnight is an area of focus for us. Systems upgrades, in particular systems that may need to run continuously to support overnight trade, things like trade capture and clearance and settlement. I'm also been monitoring testing and implementation that the DTCC has been doing with regard to its clients. So we will continue to do this as part of our ongoing monitoring and supervisory oversight responsibilities. Stop there, turn over to Mike.
Yep. For our office, the primary issue will be Rule 15C33, which requires things to be done on a daily basis, or soon will require things to be done on a daily basis. Possession and control and computation of the formula. Possession and control usually was cut off at 4 o'clock, although it could be later in the day, so we'll have to determine what a particular time is. As far as the computation of the formula, the question will be when the money came in during the day. If it came in at 9 o'clock p.m., do you count it for today or for tomorrow? A lot of firms are counting things that come in late for the next day, so they don't have to reserve for it the following day. We've not objected to what people are doing now, but our goal is to have a standardized time, either one time or firms would have to agree on what time they want it. So this is something we've been discussing with the industry, including the CIFRA folks. So more to come. Right now, we don't have an answer.
And I think from our perspective, most of the questions we've been hearing are around foreign branch or Office of Supervisory Jurisdiction requirements, which obviously involve FINRA. But that being said, we are here and ready to take questions and work with FINRA or others as needed.
we've been able to use the data in the consolidated audit trail to understand how this market has grown and changed over time, and which broker-dealers are participating, what types of market participants are participating, where they're from. And so we've been closely monitoring changes in this market to understand how it's evolving as we move towards this sort of being blessed more broadly. And I'll say we're also closely interested in some of the sort of timing issues that Mike outlined, that we have to align a lot of data reporting requirements so that everybody is sort of on the same page about when we say a trade or an event occurred. And so we're working closely with the SIPs and the Consolidated Audit Trail Operating Committee to sort of get some of these reporting standards aligned so that everybody is all on the same page with respect to what we're saying is happening.
So, Alot or Dan, anything on overnight?
It's awesome. It works, and it's where as the great Wayne Gretzky would say, it's where the puck is going.
And as a point of clarity, it is awesome, and it's happening today, and a lot of the efforts you're hearing about are efforts this year that will likely, hopefully successfully conclude at year end, really to put some infrastructure measures, like the SIP, like central clearing in place to make it awesomer.
And I think the good thing is, I mean, we probably were the leader on this, but there's been innovation. It's happened around you. I know you're tracking it. A lot of the fears were not realized, right? The issues of customer harm and gapped out spreads and all this other stuff. Just it does happen, but the policing of it, even without a rule set, has been pretty vibrant, I would say. So the marketplace is much more vibrant than I think folks thought it would be.
So the next segment is Transform, and Andrea is going to take us through, aside from those three categories, there's a pile going on in the division, and she's going to lead us through a discussion of some other live items.
So the SEC's latest published Reg Flex agenda lists the agency's rulemakings. It has a number of initiatives led by the Division of Trading and Markets, including an evaluation of the Consolidated Audit Trail, known as the CAT, transfer agents, the trade-through rule, the definition of dealer, and 15C to 11, among others. As you heard the chairman's remarks earlier today, he has directed the staff to evaluate additional rulemakings, including regarding securities lending and short sales. And he identified business as such, as used in Exchange Act Rule 17A4, as an area where transformation may be needed. My colleagues on this panel will discuss some of these initiatives in more detail.
Carol? I'm really excited to say that one of those that you just mentioned has just happened. On Monday, we published amendments to Rule 15C to 11. For anybody who doesn't know, that's a rule that sets out requirements for brokers and dealers that publish quotations for or maintain a continuous quoted market in securities in the OTC markets. Since 1971, it's been really focused on preventing certain manipulative, fraudulent trading schemes in the OTC markets. What these proposed amendments will do will change the reference to securities so that it says equity securities under Rule 3A11-1. So the rules now, if adopted, it would only apply to equity securities under that definition, which is the definition used for Section 12G, so it should be one that's familiar. The comment period is 60 days, and we look forward to your comments on that. As far as other initiatives, Andrea just mentioned securities lending and large position reporting by investment managers. Those are two rules that we recently adopted, I think in 2023. We were promptly sued, and the court came back to say that we needed to revisit those rules to look. They didn't vacate the rules. They said we needed to look at the EA to make sure we considered both rules at the same time. And so the chair has told us to go back and do that, and to also consider if any other rules were necessary in order to address the court. That's me. Who's next?
Great, and from my office's perspective, as Andrea noted, we are considering in the dealer space, considering recommending rules to clarify the commission's position related to who is or who is not a dealer. We're considering the options now, and of course welcome any feedback or engagement with folks on that issue. Secondly, and I think my colleagues in IM probably touched on this on the earlier panel, but we're also, the chairman asked us to consider recommendations around the commission's approach for electronic delivery or e-delivery. We are part of that interdivisional working group, and so we are working on that. We've had a lot of engagement with people over that for at least the past 10 years, I think. So we look forward to, we thank you for that, and we look forward to continuing that engagement. One thing that I want to flag quickly that has kind of resurfaced recently is the issue of finders, or those who, for those who are less in the lingo, those who try to find or solicit potential investors for issuers. You know, that has become a new focus, again, of the Small Business Capital Formation Advisory Committee. In July, revisited it and considered recommendations, and also took it back up again in their latest meeting in February. I'd also note that the chairman indicated at last month, I think, or earlier this month at the Small Business Forum, that he wanted the staff to consider options to address barriers that small issuers face in accessing capital. So this has been an issue that we've been bandying about for, again, a long time. And so we welcome any thoughts that folks may have in that regard. And finally, one little last plug. As you might remember, Regulation SP was adopted by, amendments to that was adopted by the Commission in 2024. While I know larger covered institutions are already well in the way of compliance with that. Smaller covered institutions, the compliance date is June 3rd, 2026. To the extent you need help in compliance, TM and IM staff, along with exam staff, did a series of compliance outreach programs over the past year, and that material is available online, as are other guidance pieces. So, but keep that date in your calendar. Hopefully you have it. That's it.
And then in the market structure side, as Andrea mentioned, and the commission has had 2 roundtables on this, and the chairman spoke on it. Revisiting Rule 611 of the National Market System Rules, or the trade-through rules, is on our agenda and something that's that we are working on. But in the interest of time, I will not go too much into detail there. But the other 2 rulemaking initiatives on the agenda, is Andrea mentioned, our concept release for the consolidated audit trail, and that's the data system that tracks securities transactions, and it provides the ability to take a look at those in today's electronic markets. And so the concept release is will be a broad questions about how can CAT be improved. While the commission has taken steps in the plan, the CAT and the exchanges and FINRA have taken steps to reduce the costs of CAT. If there's additional improvements that can be made there, we're working on that, and hopefully that will be out soon. And then last on the Reg Flex agenda is revisiting Reg ATS again, and particularly for the trading of government securities on an alternative trading system.
This is all great. It's a lot of best hits that I think were not finished. And I also want to just commend you on the 15C211, which I know has been an overhang for a long period of time. So, and I think the right way to deal with it is through the rule process rather than continuing exempting fixed income. So I think all these things are very excited, and I think people know the direction thanks to things like this, but also the speeches have been very clear in the roundtables of where it is. So people have been able to comment accordingly. So I think I want to just say I appreciate that.
We'll briefly discuss business as such. So the present Rule 1784 requires a firm, broker-dealer, to keep records relating to its business as such, a rule that's been in place about 90 years or so. The SIFMA has proposed amending that rule to eliminate the term business as such and just require records, specific records, which would be defined specifically. That is, records relating between a customer and a registered rep, for example, would have to be kept. They also propose eliminating certain off-channel discussions, things that are done on FaceTime or some other instrument that is a non-firm instrument, which would likely be prohibited by the firm, but which the registered reps sometimes do. Firms claim, and I think with some justification, they can't keep up with. Obviously, they're in no position to determine whether or not a registered rep is doing business outside of the firm's instruments. So these are important issues for them. So we're looking closely at what to do. This is an issue that's about 20 years old, and I think we should get to it now. So I'm not entirely sure how to do it, though. So we have had active discussions with the industry. We've asked for some costs, which we haven't gotten yet. They keep telling me how expensive it is, but they've not provided any cost data at all. So it's something that we're waiting for.
When you think about the cost there, Mike, can you factor in, do the firms factor in the $100 million enforcement penalties?
Well, that was not, now they also suggested, which I found, that
or cost
the
avoidance,
commission not go so hard on people that if they violate it, if it wasn't too bad, we should just ignore it. And I said, well, I don't care.
That sounds like that sounds like a principles-based rulemaking, which
Parity.
I would recommend to you in this context.
I will have nothing to do with that in a rule. I cannot write a rule that says if it's not too bad, the rule doesn't apply. I'm not sure how to do that. I've thought about it.
You've got some young whippersnappers on your staff. They can write it.
I'm sure.
They'll come up with the language. They're
We have
smart
very
people.
clever people.
I know you do. I know you do. I think you should use them and come up with a...
No, we'll come up with a definition of it. It's not too bad. Now, what is too bad is beyond the scope of this rule.
People know when they're doing business, right? People don't know what business as such is, but they know when they're doing business, and they're trying to... If you're trying to avoid it, right? If the purpose of the communication is to avoid the record retention requirements, then they shouldn't be doing that. That's the principle.
Well, we can exclude certain departments, and this is something we tried in 2007, and we tried to define it. One of the problems is a lot of folks in our place want everything. So, we got into internal problems, internal discussions.
While they're on...
as to what had to be kept.
While they're on Signal themselves. Yeah. Oh, sorry.
No.
That was my outer voice. I was trying to keep that in.
No, it's
Of course
something
they
we're
want,
working on.
Enforcement wants everything because they wanted, it started with emails, now it's text and it's everything
Well,
else.
it's emails. It was never a problem until the email traffic became so heavy.
Yeah,
And we recognized that and said, how can we eliminate, I wanted to try to eliminate groups of emails.
Right.
But it's by cutting departments, for example.
Right.
But if you cut too much, they suggested cutting stock loan. Oh my God, no, stock loan is something that there's a lot of stuff goes on there.
If we're not careful, we're going to have to open a comment file here. But it should be readily apparent why this is an opportunity for transform. Jeff?
So, anyway, we're working on it.
God, I love you, Mike. You're the best.
As those who are in this space are well aware that the current transfer agent rules are designed primarily to address record-keeping, processing, safeguarding requirements related to paper certificates. One of our goals in amending the transfer agent rules is to modernize them so that they clearly and comprehensively contemplate and address requirements related to book entry securities, which is a broad category that includes securities products that use or rely on DLT technology, such as tokenized securities and certain crypto products. Our overall approach in updating these rules would be technology neutral and ideally to future-proof them with the goal of ensuring that the rules facilitate transfer agents' use of new and developing technologies such as DLT going forward.
What do you want to do?
Next, we're going to talk about some recent exemptive, interpretive, and no action relief, which I think we've touched on earlier. There are a number the Commission has issued a number of exemptions, including ones related to the implementation of recently adopted Commission rules in the trading and market space. And the division has issued a number of no action letters and FAQs like no action letters relating to personal services entities and security-based swap execution facility order book, as Eric mentioned earlier, as well as FAQs on daily computations pursuant to Rule 15C3-3. They've also issued several notices of applications for exemptions, such as related to treasury clearing, overnight trading, single stock futures, and we welcome public comment on all of those. We appreciate market participants' input on these matters, and please continue to reach out. We appreciate your engagement, whether it's providing your views on applications or seeking separate relief. My colleagues on this panel will discuss the actions in more detail. Mike?
17H. So the 17H was adopted in, I think, 1992. It requires that broker-dealers with a certain amount of capital, at the time the rule was written, was $20 million, would have to make records available to the Commission about the holding company and its affiliates. The Commission recently issued an order which would raise the $20 million, was originally raised to $50 million some years ago, to $100 million. Firms with less than $100 million in capital would no longer have to file 17H forms unless they were clearing firms or unless they had an excessive amount of assets, I think which were defined as over $1 billion. But in fact, those firms would continue to file 17H reports. That limits us to about 200 firms now that we will collect information on. Most of them are clearing firms. So there are some hedge funds and some other assorted trading firms.
So Treasury clearing. So when the Commission adopted the Treasury clearing rules back in December of 23, set implementation dates for cash clearing and repo clearing, which the Commission extended in January of last year. So the compliance dates for cash clearing will be December 31st of this year, and for repo, June 30th of 2027. This extension has enabled the staff to engage with market participants and working groups in order to provide greater clarity and guidance to help the industry implement the Treasury clearing mandate. The Commission is also focused on facilitating the development of infrastructure for the Treasury clearing rule. So over the past year, the Commission has registered CME and ICE Clear Credit as Treasury clearing CCPs. This gives market participants an expanded choice. Now with FIC, there are now 3 clearing agencies that are eligible to clear Treasury securities, and this gives the market participants an expanded choice in order to satisfy their obligations. The Commission has also approved several rule changes designed to broaden client access, and currently the Commission is seeking comment on customer cross-margining between FIC and CME. In addition, the Commission recently published a request for an exemptive relief with regard to the extraterritorial reach of the Treasury clearing rule. This has been an area of focus that the SEC staff has discussed extensively with market participants as well as foreign regulators. Another area of focus has been that market participants have asked for additional clarity is the application of the Treasury clearing's inter-affiliate rule. Since the adoption of the rule, market participants have raised a number of concerns, including with respect to the entities that are covered by the inter-affiliate rule, and also with regard to the outward-facing transaction requirements of the affiliate. We continue to work with market participants and industry groups on this issue, and hopefully we'll be in a position to better seek guidance or provide guidance with regard to the application of the rule. In addition, there are a number of other developments that the Commission staff has been working on. All of them are listed on the Treasury Clearing Implementation website, and I encourage folks to take a look at that.
So I'm going to be really quick and flag 2 things, otherwise you might be asking us for relief. from this conference. So with that, I just want to point out that in November, we issued no action relief to allow registered representative personal services entities to receive transaction-based compensation without having to register as a broker-dealer. For those of you who are in the know, that's a big deal and a long time coming, and we were very excited to get that out. The second thing I want to flag is that earlier this week, we issued exemptive and no action relief to the ICI on behalf of broker-dealers and certain other persons in connection with the recent approval of multi-class ETFs. These allow broker-dealers and other persons to engage in certain transactions with the ETFs without having to worry about compliance with certain Exchange Act rules. So look for that one.
I'm going to be equally quick. Just two things from my trading practices side. We issued earlier this year Reg M class relief for restructuring transactions in ordinary course. There were 50-some letters on the website. Everybody had to come in for each of them. And so that class relief is out there. If you're one of the people who wanted those kinds of letters, you know what I'm talking about, and I think it's a big deal. And then the Global Research Analyst Settlement. I didn't do it, but it has been sunset by the Corp. I will point out that part of the reason it was sunset was because FINRA has rules, we have Reg AC, and of course those things still apply. There's Sarbanes-Oxley. But if you're one of those firms, you're also happy because you're now on a level playing field with everyone else.
I will touch just real quick, given the interest of time. So the Chicago Mercantile Exchange filed an exemption with the SEC that the commission noticed for cash-settled, single security, well, cash-settled and PM-settled single security futures, so single stock futures. The commission put that out for comment because we really are interested in hearing people's feedback. This would be highly novel for the markets to have potentially cash settlement of single stock derivatives. So encourage everybody to take a look at it and let us know what you think.
The next item, we want to talk about our self-regulatory organization and national market structure filing. The division receives thousands of these filings and proposals each year from the SROs, including NMS plan filings. Some notable proposals, including related to consolidated market data, Treasury clearing implementation, FINRA rules relating to gift limits and outside activities, as well as various fees. My colleagues on this panel will discuss these actions in more detail.
And I think we've got a handful of minutes, so why don't we each pick our favorite one and then let our moderators grace us with some final thoughts.
So on the market data front, as Andrea mentioned, we have filings from an effort, multi-year effort for the commission to consolidate and improve the governance of the market data plans. And the next key step in this is for the new consolidated plan to submit fees. We have that filing and are working on processing it, but that would be the next step in achieving the commission's overall efforts dating back to 2020 for the market data infrastructure initiative.
So I guess my favorite is the one that we're going to be working on looking forward, which is we noticed in January a proposed rule change by FINRA to revisit their outside business activities and private security transaction rules, to modify them, to combine them into one, and to focus on areas that FINRA believes is of higher risk. I think the comment period just closed on that, and I know we have a voluminous amount of comments to consider there, but it'll be an exciting new area, so flagging that.
Okay. FICC and the Merc have filed a proposal for cross-margining of futures and treasuries for customers to post as margin for treasury clearing. Margin will be kept in a futures account. It's pending.
I'll just say that's my favorite too, so.
Dan is your favorite?
No, it's all good. I think I got everything out earlier. Kudos, you guys. I mean, I thought it was busy when I was there with you guys, but this is a really busy time. So, good luck with it all, and I think you're doing a really good job, as far as I can see, balancing the need to accommodate innovation, but also, look out and make sure things don't get a little too out of whack. So keep it up.
Yeah, I think, again, I commend you. The fact that we're over shows how much you're doing. I do think one of the things that is interesting, but we didn't really touch that long about, is what the exchanges are doing to try to innovate, which I think is important. And I do think we talked about the statutory requirements of 19B and how they are particularly onerous compared to market centers that are not exchanges. And I encourage you guys to consider to sort of engage with folks about that and see whether there is a way to or sort of think about that, because it is, as you mentioned, you have thousands of these, and I'm not sure there needs to be thousands of them.
Well, thank you, Dan, and thank you, Elad. Thank you, my colleagues here. Thank you, PLI. Thank you, audience. And to Elad's point, and Dan's point, a lot of complexity here, a lot of great issues. We absolutely need to hear informed opinions. So please visit us early and often, and we look forward to that. Thank you.
So just right quick, we're going to take a short break. We'll start up again at 4:30 with our workshops. And workshop A, Corpin, will be in here. Investment management will be in the Mint breakout room. And then international affairs will be in Congress. For those watching on the web, we will be broadcasting Corpin, and you will be able to see the other two on demand. Thanks.
Good afternoon. At this time, we would kindly ask that you please take your seats and silence all devices as our program is about to begin. Thank you.
Is my mic? It is. All right. Good afternoon, everyone. You made it to the end of the day, almost. We promised to make this interesting. This is the Corpin workshop. We thought Brad Skinner at the end of the table and I would do the easy part and moderate this session, and also because we are new to our roles as associate directors in Corpin. First, a disclaimer for everyone that will be talking on the panel today. Our remarks in this workshop do not necessarily reflect those of the commission, commissioners, or other members of the staff. At the Corpin session this morning with the director and others, there was lots of talk about regulatory priorities of the chairman, and that talk is generally about reducing compliance burdens, facilitating capital formation, all the while giving investors the relevant disclosure to make informed investment decisions. But not everything the agency does is at the commission level. Much of the interesting work takes place within the Division of Corporation Finance. So the panelists today are going to go into the more granular matters. We have 7 speakers in addition to Brad and me from around the division who will talk about the latest developments in their respective areas. Including those 7 is one of the disclosure groups, the Office of Finance Office Chief, who will provide some pointers in preparing your disclosure documents. Common themes that you're going to see in these updates sort of represent our efforts to give guidance to you in support of the chairman's goals of providing clarity around the capital formation process. Kicking it off this afternoon will be the newest Corpin senior officer, Michael Arnold, who just started serving as senior advisor to the director on Monday, March 9th, just 10 days ago, so go easy on him. He is new to us, but definitely not new to this area. Michael, welcome.
Thank you. Thanks for the warm welcome. And I've been warmly welcomed by everyone in the SEC. It's very exciting to be here for my first SEC Speaks, where I'm speaking and not listening. So very glad to be here. Obviously, I just joined. I'm digging out of a lot of, paperwork and onboarding and other exciting issues, and I definitely don't want to take time from my esteemed new colleagues, so I will be very, very brief. I will be, as you heard earlier today, working on some of the Reg SK work that is being undertaken here at the Commission. As Chairman Atkins announced on January 13th, we're doing a comprehensive review of Regulation SK, really soup to nuts. As Director Maloney noted at SRI, and as you heard earlier in some of the remarks today, disclosure has obviously become extremely complicated now. And so we're going to be really trying to kind of clarify and transform the rules within Reg SK with materiality as the lodestar. If it's any indication, my first stop at the SEC Supply Depot was to pick up some red pens. So that may be an indication of the direction of travel here. In terms of practical things you can do to help this effort, please submit comments. We have an open comment file open until April 13th, so about 3.5 weeks from now. Really try to be as specific as possible. If you want to mark up the reg text, that would be excellent. We already have some comments, but we expect more to come in. And if you are just getting started, you still have plenty of time. You can make it in 3.5 weeks. Really, no comment is too small or too big. We're really, fundamentally trying to kind of, get to the heart of Reg SK. So that's all I have. And now back to my esteemed colleagues.
Michael. As we're all aware, financial press continuously reports on industry developments and trends, some of which may have material impact on registrants. Staff in the Division of Corporation Finance in the Disclosure Review Program's 9 industry offices consider industry developments as part of their reviews. And here to talk with us about a couple of recent developments and the staff experience with them is Jim Lopez from the Office of Finance.
Thanks, Brad. I'm Jim Lopez, Office Chief for the Office
Hello? Hello? Can you hear me? Is this microphone on? Oh, there we go. All right, can you hear me now? Better? Now? Okay. So thanks, Brad. I'm Jim Lopez, Office Chief for the Office of Finance in the Disclosure Review Program. Let me start by clarifying, if anybody's drinking out there. My remarks reflect staff observations and do not reflect any initiatives or policy changes. Nothing transformative here. With that said, I plan to briefly cover three things: commercial real estate disclosure themes, private credit and other trends, and our ordinary course monitoring of market developments. Starting with the topic of commercial real estate, which is often shortened to CRE, this area has received a lot of attention over the last 2 to 3 years. Staff, particularly in the Office of Finance and the Office of Real Estate and Construction, have addressed some disclosure issues in comment letters, and SEC staff at various conferences have discussed areas of focus. One of the key subcategories of CRE that the financial press has frequently put in the spotlight is downtown office properties. It is important to note, of course, that there are many other subcategories of CRE, some of which appear in general to be performing very differently than office, for example, industrials and data centers. Excuse us. So, much better, I guess. Yeah, data centers and industrials performing very differently than downtown office. And even inside the subcategory of office properties, there is a wide range of performance depending on a wide range of factors. For example, geography and the extent of concentration. That fact about not all CRE being the same and needing to peel back the layers is something that I want to briefly discuss among a few other points about CRE and disclosure in general. Let me give you the punchline up front about CRE. For the most part, the Office of Finance and the Office of Real Estate and Construction have noticed improved CRE disclosures. This is what I would call a good story. CRE was an area of focus a couple of years ago. We were spending a decent amount of time reviewing disclosures. We sent tailored comments to a number of registrants. And since then, we have mentioned on panels that we have observed improved disclosures. But stories still appear about CRE problems, troubled office properties, delinquencies, large numbers of loan maturities in 2026. For example, recent industry reports have highlighted that delinquencies for commercial mortgage-backed securities, CMBS, have risen to levels not seen since before the Great Financial Crisis. And there are reports of distressed downtown office properties where the landlord, which may be a non-recourse borrower, has just left the keys and walked away. These properties, which the media sometimes calls zombie buildings, may have loans that were underwritten in a significantly lower interest rate environment. When reviewing banks and lending institutions with a significant exposure to CRE, staff evaluates whether investors are getting the information they need to understand the CRE loan portfolio. Over the last couple of years, the staff issued comments seeking expanded disclosures around the loan office portfolio concentrations and characteristics. As for the types of concentrations, they can exist in various forms, such as geographic, industry, nature of the business, and whether it is purchased for own use by the borrower or for investment returns. Some characteristics that are important for quantitative and narrative disclosure include the nature and quality of collateral, underwriting standards, and other applicable characteristics, such as ongoing credit risk assessment and mitigation practices at the lending institution. It can be important to address qualitatively risk management policies and procedures and actions undertaken by management to mitigate or manage risks. For example, staff comments sometimes ask about how the registrant seeks to manage risks due to changes in interest rates and other material factors impacting operations. As I said, with CRE, this has been a good story because the staff has observed many instances in our filing reviews where registrants that had not received comments have already taken steps to proactively expand the disclosure in their filings. For example, expanded disclosures we have observed include new information disaggregating CRE, which provides investors more detailed information important to understanding the nature and extent of their exposure to CRE. So my second topic is about private credit and other industry trends that we monitor. Markets have continued to see increased demand for private credit within recent years,
And just to level set, private credit is generally understood as non-bank lending to small private and middle market companies. Entities involved in private credit funding include asset managers, insurance companies, and non-bank financial institutions. Some of these registrants may have material concentration or exposure to private credit. Private credit in general has been in the news a lot recently. As with CRE, it is important to peel back the layers a bit because the term covers a wide range of types of investments whose credit quality can depend on many factors, including the nature of the underlying business, capital structure, leverage, and liquidity. Depending on the facts and circumstances, a given private credit portfolio may carry very little risk for a registrant. However, by its nature, private credit is typically less transparent than some other asset classes. If there is a material exposure to private credit, it may be a good idea to take a fresh look at disclosures given current trends and uncertainties in the market. Based on what we see in the media about private credit, it appears there is no lack of opinions with respect to the current status of credit quality, liquidity, loan valuations, as well as the limited amount of visibility into all of these things. Just to clarify, again, anybody? The staff's concern in this space is not with private credit itself, but with disclosure to the extent material to public investors. With CRE, we saw some registrants providing expanded disclosure, disaggregating their CRE portfolio and further explaining their risk management policies and procedures. These expanded disclosures help investors come to their own conclusions regarding the company's risk profile. Similarly, we encourage registrants that are materially engaged in private credit to take a fresh look at their MD&A and other disclosures to ensure that investors are getting sufficient visibility into their exposures and risk management to the extent material. Turning to another industry trend in the news, there have been a number of announcements of transactions between software or technology companies and AI companies where there's a level of interdependence or reciprocal structures. These so-called circular transactions are just one facet of the much broader topic of AI, which is of course getting a lot of attention for its evolving impact across multiple industries. As I said up front, this is not an announcement about some kind of task force on these issues. Instead, this is, and this is my third and last topic, I mentioned these observations as illustrative of our routine monitoring of market developments. In the ordinary course, the staff and the DRP typically go beyond the four corners of the 10K or the S1 or whatever filing is under review, and we take into account what we're seeing when we're conducting our reviews. So my final point is merely that our observations of industry trends inform our reviews, which can be incorporated into comments or questions we have for a registrant. Just as with CRE, I'm optimistic that registrants will continue to get in front and proactively address important disclosure concerns. Everybody likes a good story.
Thank you, Jim. As with other groups in the division, our Office of Small Business Policy has put out a lot of guidance recently relating to the exempt offering framework through which many transactions do take place. I'll turn it over to Jeb Byrne, that office chief, to talk through some of that guidance.
Thank you, Gabe. As Gabe said, I'm the office chief for the Office of Small Business Policy. Our office provides internal and external expertise on 33 Act exemptions, so Regulation D, Rule 701, and also the registration rules surrounding small businesses. Luna Bloom and Gabe just said, they flagged this earlier, but our office has put out a lot of guidance recently. I think we've amended or put out 60 new CFIs. I knew I was going to do that. 60 new CFIs in the last year or so, and a couple of no action letters. So before I get into a couple of those, I just want to thank the OSBP team, Tony Barone, Kenesha Nicholson, and Max Corey for their dedication and all the work they've done on that. As Luna mentioned earlier, we have new rulemaking projects that we're considering as well, so there's a lot of work going on in our office. The first piece of guidance I want to flag is New Securities Act Question 260.39. The question asks whether an issuer can use different methods of verification for the same Rule 506C offering for different purchasers. The answer to that is yes, just a flat yes. And the reason for that is when the Commission adopted Rule 506C, they wanted to provide issuers flexibility, both for their fact pattern, but also for their purchasers. So there's no specific requirement either to use the listed non-exclusive methods in Rule 506C, or to use one specific one for all issuers, or so for all purchasers. So an issuer can use some of those for some purchasers, they can use principles-based for other purchasers, they can mix and match depending on what their facts and circumstances necessitate. In addition to some Regulation D interpretations, we put out some integration interpretations earlier this year, and I wanted to walk through a couple of those quickly. As I'm sure many of you are aware, the integration framework pretty much entirely changed in 2020 when the Commission adopted the harmonization rules. And so what we did was we took out a number of interpretations that were under the old framework, referenced the five-factor test, which has since been repealed, and referenced other rules that have since been repealed. But we also put out some new guidance under the new Rule 152, which is sort of the governing rule for integration now. So I wanted to walk through a couple of those new interpretations, the first being New Securities Act Rule Question 148.01. So the question addresses if and how an issuer can sell to investors in a Rule 506B offering, which doesn't permit general solicitation, if they previously solicited those investors in a Rule 506C offering using general solicitation. The answer to the if question, can they do it, is yes. The answer to the how question is carefully. Rule 152.8.1 provides that if you're in that situation where you're selling to people after you've done a generally solicited exempt offering, you need to either not be comfortable that you haven't solicited those people through a general solicitation, or you've established a substantive relationship with those purchasers before you've done the offering that doesn't permit general solicitation. In the fact pattern asked in the question, they were solicited, so that first prong doesn't work. So the issuer would need to establish a pre-existing substantive relationship with the purchasers before they started their Rule 506B offering, again in the fact pattern. Whether an issuer's established that substantive relationship is a facts and circumstances inquiry that can be hard to establish, and so this CFI goes into some of the facts and circumstances that the Commission has pointed out in the past that issuers should consider. First, the quality of the relationship between an issuer and a prospective investor is the most important factor in determining whether such a relationship is substantive. The issuer must have sufficient information to evaluate and must, in fact, evaluate the investor's sophistication, financial circumstances, and ability to understand both the investment and the risks associated with the securities to be offered. The passage of time or a short-form accredited investor questionnaire are not sufficient on their own for establishing a substantive relationship. Second, the answer walks through some of the types of relationships and purchasers the Commission has identified as the types of people with whom issuers typically have these substantive relationships, and those include the issuer's existing or prior investors, investors in prior deals of the issuer's management, or friends and family of the issuer's control persons. The answer notes, as the Commission did in the harmonization release, that absent relationships like these, so prior business relationships or recognized legal duties to the offerees, it is likely more difficult for an issuer to establish a pre-existing substantive relationship. The other two integration questions or interpretations that we put out in January were less complicated, so I'll just quickly run through them. To some extent, they were just updates on prior guidance to reflect new Rule 152 and not the prior paradigm that we were in before. So the first, Securities Act Rules Question 148.02, asks whether the mere fact that a registration statement is effective in and of itself automatically raises integration concerns under Rule 152. Again, the answer to that is a flat no. So integration looks at offers and sales and offerings. It doesn't, so the fact that a registration statement is effective does not necessarily implicate integration concerns. The other interpretation, Securities Act Rule Question 148.03, is an update of a prior interpretation, again, to take into account Rule 152. So it's 148.03, I think I might have said that, but the question asks whether an issuer can complete an unsuccessful shelf takedown privately in reliance on 4A2 or 506B. The answer to this question is yes, but issuers should be very thoughtful and perform that same analysis I talked through before under Rule 152A1, which means they need to think through whether they solicited those purchasers through the general solicitation, or if they had established a pre-existing relationship with those purchasers before doing the 4A2 or 506B offering. In addition to the new Rule 506C and integration interpretations we put out in January, we also put out some new Rule 701 and smaller reporting company interpretations earlier this month. The two new Rule 701 interpretations deal with the same fact pattern, and that fact pattern is an issuer went over the Rule 701E $10 million disclosure trigger in 1 of 3 years it did its Rule 701 offerings. And the first question asks, in that situation, to what investors does the issuer owe the disclosures required under Rule 701E 1 through 6? As a reminder, 701E 1 through 6 goes through a number of disclosures that issuers have to provide if they sell over $10 million under Rule 701 in a 12-month period. And those disclosures are things like details relating to the plan, information about risks associated with the security sold pursuant to the plan, and financial statements. Because the fact pattern that was asked about was about options, the requirement to deliver disclosure under Rule 701E is triggered if the value of the options based on their exercise price exceeds $10 million when combined with other sales made under 701 in a consecutive 12-month period. Here, the issuer exceeded that $10 million amount in 1 of the 3 years it granted options under the plan, so it must provide disclosure to persons granted options in that year. All of those disclosures must be provided a reasonable period of time before exercise, but the issuer is not required to provide disclosures to person it granted options in the other 2 years. The trigger is only based on the year in which the disclosures, or the $10 million threshold was exceeded. The second question is based on the same fact pattern, and basically it asks what happens if the issuer doesn't provide those disclosures a reasonable period of time before the date of sale. And the answer is the exemption is lost for that entire year in which the issuer exceeded the $10 million threshold, but it is not lost for the other 2 years in the 3-year fact pattern. The final interpretation I want to flag deals with everyone's favorite topic, checkboxes. So new regulation SK question 102.06 asks whether the failure to check the smaller reporting company status box results in the loss of SRC status or the loss of the ability to use the SRC accommodations, assuming the issuer qualifies as an SRC. The answer to that is no. The issuer's status as an SRC and their ability to use those accommodations are not contingent on the box being checked. But that said, obviously the box being checked is a requirement of the form, so issuers that are SRCs that don't check the box will not be in compliance with that requirement.
Thank you for that, Jeb. Kayla Roberts, the Office Chief of Structured Finance, will talk a bit about her team's work on potential revisions to the registration, reporting, and disclosure framework for asset-backed securities. And as part of that, she'll talk about some common themes and questions that have emerged throughout that process. Kayla?
Thanks, Brad. Good afternoon, everyone. For those of you who may not be familiar with the Office of Structured Finance, I'll start with just a quick high-level intro. The short version is that OSF is the one-stop shop for all things asset-backed securities in Corpin. So that means our office is reviewing the filings of asset-backed securities issuers. We provide interpretive guidance. We develop and draft rulemaking recommendations for the Commission's consideration, and provide internal and external subject matter expertise on securitization matters. As many have noted throughout the day already, the capital markets are evolving as quickly as I think they can, especially with all constant changes in the news lately. My team has been fielding a lot of questions about whether certain offerings are ABS or have ABS-like qualities. So this is my plug to please give us a call with any questions, or if some guidance on this might be helpful, or we can be of assistance in any way. This question has been particularly salient in recent months due to the concept release that Brad alluded to a few moments ago. So I'll use that as my segue into some updates about the office's work over the last year, and some key observations, and offer up some hopefully helpful guidance that you can take away with you this afternoon. At the end of September, the Commission issued a concept release exploring whether our current regulatory framework for asset-backed securities continues to meet market needs amid changes in technology, market practices, and new and evolving securitization structures and asset classes. The Commission sought feedback on topics that can be grouped into 2 big categories. The first one was asking if the Commission should consider revising the definition of asset-backed security in Regulation AB to incorporate the broader Exchange Act definition in order to promote clarity and consistency of treatment across similar ABS products and expand access to the registered ABS market for both issuers and investors. Related to this question, the Commission also asked about whether there are changes that we should consider more broadly to the registration, reporting, and disclosure framework that we should consider in order to reduce barriers to entry, mitigate costs and other burdens, and facilitate enhanced liquidity in ABS markets. The other big category, and probably the bigger focus of the release, dealt with registered offerings of residential mortgage-backed securities, or RMBS, which have been exclusively issued in unregistered offerings since 2013. The Commission sought feedback about potential amendments to the rules that could facilitate the return of RMBS to registered market offerings. Specifically, we were asking about potential revisions to asset level data requirements that were adopted in 2014, and whether, in order to strike the appropriate balance between transparency and borrower privacy, the rules should permit disclosure of certain sensitive borrower information to be made subject to confidentiality agreements outside of the issuer's public EDGAR filings. Taken together, these questions reflect the Commission's broader interest in ensuring that its regulatory ABS framework is appropriately calibrated to today's markets and flexible enough to adapt as this space continues to experience rapid innovation and evolution. My staff and I have been actively reviewing the comment letters, and we've had numerous discussions with market participants ranging from issuers and investors to the other transaction parties such as trustees, servicers, data vendors, privacy experts. Really just trying to make sure that we are taking in all of the feedback and synthesizing everything appropriately. There have been some big themes that are emerging. I would say that generally the comments were supportive of those kind of bigger efforts that the Commission was seeking comment on. There is some differences in the opinions on how to accomplish that, but that is part of what we are sorting through. And do you think that we will have, a lot more information as we continue to go forward and have those conversations and engage with folks? Drilling down into some of the themes, I think that one of the most common thread that came out of this whole process has been there seems to be a limited understanding about how some of the securities laws and the rules work together, particularly with respect to these topics and in this space. The most prominent example of this is just how much uncertainty exists in the market regarding these asset level data requirements, especially with respect to how materiality should be evaluated and including whether individual errors in a data field are per se material. Our office is in the process of developing some guidance on this point, so be on the lookout for that. But for today's purposes, I'll just give you a preview. For purposes of the federal securities law's liability provisions, the asset level disclosures are subject to the same materiality standard as an issuer's other disclosure obligations. That is consistent with the Commission's statements in the Regulation AB2 adopting release when the asset level data requirements were adopted. The materiality of errors in a Form ABS-EE asset level data file turns on whether there is a substantial likelihood that a reasonable investor would consider the erroneous data when assessed in the context of the disclosures as a whole to have significantly altered the total mix of information made available. Not every error is going to rise to that level. For example, typos or other similar inadvertent errors are unlikely to be considered material under this standard. That's just an important thing to keep in mind. I know that a lot of our commenters have been very, very focused and concerned about that, hoping that we can kind of push everyone past that initial threshold question and start really drilling down into some of the, the real technical details on that data. While I'm on the topic of these frequently asked questions and staff guidance, I'm going to quickly highlight a few other areas that we're looking at some guidance for as well. These are questions that came up both through the concept release process, in comment letters, and then again in these ongoing discussions that we've been having with market participants. So this next group of guidance previews I'm going to give, I'm just going to call Form ABS 15G. And for the structured finance practitioners watching, I understand that this may not be your favorite form. I hear you. Hopefully this guidance and some of the notes I make today will help to answer some of the questions that we've been getting. First, a few quick points of housekeeping. ABS 15Gs filed for Rule 15GA1 and for repurchase request activity reports, and then ABS 15Gs filed For Rule 15GA2 are the reports filed with findings and conclusions of third-party due diligence providers. So with that context in mind, the guidance that we are going to reference here, it will address guidance with respect to the form filing for both of the rules. But I'm going to get into a little bit more detail with the filings for Rule 15GA1, just because those were a little bit easier to talk through, and the others to be on the lookout for. So there's a lot of confusion about whether securitizers should file their first Rule 15GA1 repurchase request report under Item 101, which on the form is called the initial filing, or on Item 102, which is referred to as the periodic filing. My guess is that if I took a poll, 9.5 out of 10 of you would say Item 1.01. That is wrong. The answer is Item 1.02, despite the fact that it says periodic filing. Item 1.01 actually applied only to the initial look-back transition period immediately after the rule was adopted. The transition period related only to repurchase request activity that occurred prior to the end of 2011. So if you're filing an ABS 15G today, you won't be needing Item 1.01. And don't worry, this is a common error. I have to read the rule and the form multiple times every time I get this question just to make sure I'm still reading it correctly. That same logic applies to the check boxes that are on the cover of the form, which also have similarly confusing language. So if you have no activity to report for the period covered by the form, even if it's your first ABS 15G, you would mark the second checkbox indicating that there's no activity to report for the quarterly period, not the checkbox referring to the initial period. As I mentioned, we're also working on some guidance that addresses some other questions with respect to the form, including questions that we've received about the timing of the Form ABS 15G with respect to filings pursuant to both Rule 15GA1 and Rule 15GA2. So keep an eye out for those CFIs, and I had to pause before I said that because otherwise I was also going to call them by their old name, and reach out if you've got any questions once you see those pop up. Thanks so much.
Thank you, Kayla. Now we'll turn to Michael Coco, Chief of the Division's Office of International Corporate Finance, a former office of mine, who will tell us about the Holding Foreign Insiders Accountable Act, or the HFIAA, and its related developments. Michael?
Thank you, Gabe, and good afternoon, everyone. It's nice to see a lot of familiar faces in the audience. If you're not familiar with the Office of International Corporate Finance, we are the office that administers the regime applicable to foreign private issuers and the related rules and regulations, including the MJDS system with Canada, Schedule B for sovereign issuers, ADR regulation, and Regulation S as well, among other topics. At this morning's session, I think Ted Yu spoke about the Holding Foreign Insiders Accountable Act. I will go into some more detail into the steps that the Commission and the staff have taken as a result of that. And as you may well know, Congress enacted the HFIAA on December 18th with a 90-day effective date, which was yesterday, March 18th, as the first day on which directors and officers of foreign private issuers are subject to Section 16A disclosure of their holdings and transactions in FPI equity securities, and those would be Forms 3, 4, and 5. Previous to that, foreign private issuers were exempt from all of Section 16. Under the Act, FPI directors and officers must report electronically and in English, and the goal is to increase the transparency of FPI insiders' holdings and transactions. So, as of yesterday, reports were first due unless there was exemptive relief granted by the Commission. And my understanding is that around 4,100 Forms 3 were filed on that one day. I would highlight that, unlike for domestic issuers, the Section 16A disclosure requirement is not applicable to 10% owners of FPIs, only to their directors and officers. I would also emphasize that other paragraphs of Section 16 still do not apply to FPIs. It's just Section 16A. And the statute did give the Commission the exemptive authority if the Commission found that foreign law is substantially equivalent to the requirements of 16A. And I will say quite a bit more about that in just a moment. In order to make the requisite filings, EDGAR access is of course necessary for directors and officers to have, which involves the filing of the Form ID, the process for staff sort of processing those forms. My understanding is about 7 days currently. Staff has issued an extension for anyone who has submitted EDGAR access applications before the March 18th deadline, but not received it yet. And in that situation, the filing is due no later than April 1st. So pursuant to the HFIA Act, the Commission issued final rules on February 27th. They are fairly straightforward and reflect the requirements of the Act, specifically revising Exchange Act Rule 3812-3B to retain the FPI exemption from Section 16B short swing profit rules and from Section 16C short selling prohibitions. The Commission also amended Rule 16A2, which identifies persons and transactions that are subject to Section 16 in order to exclude 10% holders of foreign private issuer equity securities from the 16A requirements. And in addition, made some technical changes to reflect the application of, application 2 rather, FPI directors and officers to the 16A forms, some technical amendments to add country code, trading symbol, and updated SEC contact information. So as I had alluded to, Congress did give the Commission authority to exempt from the new 16A requirements any class of persons, securities, or transactions if the Commission determined that the laws of a foreign jurisdiction are substantially similar. I would emphasize that substantially similar, not identical. Staff has received many submissions from participants in foreign countries. Those have been extremely helpful to our understanding and our evaluation of foreign insider reporting requirements. And after evaluation of many such requests, the Commission issued an order on March 5th exempting from the new 16A requirements directors and officers of any FPI that is incorporated or organized in one of the qualifying jurisdictions, and also subject to specific qualifying regulations in those jurisdictions. And those jurisdictions are Canada, Chile, the European Economic Area, which is the 27 members of the EU, plus Iceland, Liechtenstein, and Norway, South Korea, Switzerland, and the United Kingdom. And the order takes what I refer to as sort of a mix and match approach. So as long as both incorporation and the qualifying regulation are in a named exempted jurisdiction, even if not necessarily the same named jurisdiction, the exemption would apply. The exemptive relief does have some conditions. First, a director and officer seeking to rely on the exemption is required to report the transactions under a qualifying regulation, and the report filed under such regulation must be available to the general public in English within 2 business days of the public posting. In reaching its determination, and as laid out in the order, the Commission considered persons, securities, and transactions that were covered by the regulation, as well as the content, timing, and availability of the reports. I'd like to mention that other jurisdictions are still being evaluated, and the Commission may issue additional exemptive relief. Of course, the determination and timing is up to the Commission, but if there are any interested parties that are would like to inquire or pursue an exemption, then they should feel free to reach out to the staff of the Office of International Corporate Finance, and we would be happy to discuss. There are a few notable pieces of guidance that I'd like to bring to your attention. The The staff issued some FAQs, not CFIs, but FAQs, on March 3rd, and they were updated on March 12th. These largely related to transition guidance about the due dates, given different fact patterns for when a reporting person became a director or officer. Generally, the due date was March 18th, but the FAQs do clarify that the due date may be the later of March 18th or 10 days after the person's appointment as a director or officer. I'd mentioned an extension of the filing date regarding the Edgar access. Staff provided an extension until April 1st, recognizing the large number of Forms ID that were filed resulting from the HFIA Act. Staff will not recommend enforcement action if the filings are made by April 1st, if the Form ID was submitted prior to March 18th. The requesting person did not receive the Edgar access codes by that date, and the filing is made after access codes are granted, but no later than April 1st. Importantly, the FAQs also issued similar relief to directors and officers and 10% owners of domestic issuers, because the volume of applications for Edgar access as a result of the HFIA Act also affects, of course, the timing of applications of those persons as well. Last Friday, March 13th, staff also issued no action relief in light of the current conflict in the Middle East through a no action letter to Tower Semiconductor. And that letter allows a filing extension until April 20th for the director or officer of any issuer incorporated and headquartered in Israel or in any other country in the geographic region that is first directly affected by the conflict, and provided that the person can represent that their ability to comply with the March 18th deadline has been materially affected by the conflict. It's important to highlight that while the letter does indicate that the director and or officer must represent that they are materially affected by the conflict, they do not need to submit any representations to the staff, either written or oral. But they have to obviously make their own assessment of their circumstances and make their determination. So I will close there, but if anybody has questions about the implementation of the HFIA Act or any of the matters I've discussed today, please do contact us at the Office of International Corporate Finance. We have an open door, and I invite you to contact us if there are any matters on which we can assist or on which guidance may be helpful. Thank you very much.
Thank you for that, Michael. The Office of Mergers and Acquisitions has had a very busy year so far, including publishing new or revised CFIs with respect to lockup agreements in mergers and exchange offers, as well as in the proxy information statement, tender offer, and going private spaces. Perry Hinden is here to speak about aspects of these CFIs. Perry?
Thanks, Brad. First off, let's discuss our CFIs covering lockup agreements and mergers and exchange offers. They were updated on January 23rd. We updated those CFIs to provide additional flexibility for registrants and bidders in mergers and registered exchange offers on Forms S4 and F4. And I'm referring to Securities Act Section Q&A 139.29.30 and Securities Act Section 5 Q&A 239.13. You'll see in these CFIs a link to show a black line, which is very helpful to understand what we changed. As a reminder, 139.29 and .30 discuss lockups or agreements to tender in issuer and third-party exchange offers, and 239.13 discusses lockup agreements in the merger context. The basic premise being that the staff will not object to the subsequent registration of offers and sales of the subject securities where lockup agreements have been previously signed if specified circumstances are met, and I would refer you to the CDIs for the bullet point circumstances. You'll see that our updates expand the scope of CFI 139.29, which relates to issuer exchange offers, to include any subject securities, not just debt, as was previously the case, and modify the first condition in 139.29 to include qualified institutional investors in addition to accredited investors. However, the most notable change in those first two CFIs was to bring them in line with CFI 239.13. And that is, even if the enumerated circumstances in each of CFIs 139.29 and .30 are not satisfied when the lockup agreements are executed before the filing of registration statement, the staff will not object to the subsequent registration of offers and sales of the subject securities if the parties who executed the lockup agreements will be offered and sold securities only in an offering made pursuant to a valid Securities Act exemption, and the securities registered on Form S4 or F4 will be offered and sold only to those security holders who did not execute lockup agreements. We, in January, also issued a new proxy rule CFI 182.01 regarding Rule 14C2, and that rule requires a 14C information statement be sent or given at least 20 calendar days prior to the earliest date on which the relevant corporate action may be taken. That CFI answers the question that arose in the CBS versus National Amusement Sherry Redstone battle over control of CBS back in 2018, which was what happens if a registrant is unable to distribute an information statement in compliance with this 20 calendar day requirement because the written consents were solicited by a dissident security holder without the registrant's knowledge. Does Rule 14C2 prevent the corporate action from becoming effective until at least 20 calendar days after the information statement is distributed to security holders? As our CFI explains, no, applicable state law or the registrant's governing documents and not Rule 14C2 determines when a corporate action taken by written consent becomes effective. So the failure to comply with the 20 calendar day requirement in 14C2 does not invalidate the corporate action. Now, where the written consents were solicited by a dissident security holder without the registrant's knowledge, the staff will not object to the registrant's failure to comply with the 20 calendar day requirement as long as the registrant distributes the information statement as soon as practicable after it becomes aware of the written consents. In January, we also issued two new CFIs, 166.02 and .03. Those relate to Rule 14E5, which is the rule governing outside purchases, including outside purchases and cross-border tender offers. Those CFIs are fairly technical, and given time constraints, I'll just refer you to read those on your own time on the website. In February, we issued three new CFIs, 112.03.04 and 212.01. 112.03 provides some clarity with respect to Rule 13E3G2, which is an exception to the requirements of Rule 13E3 if the security holders are offered or receive only equity securities in the Rule 13E3 transaction and certain conditions are satisfied. One condition being that if the security, which is the subject of the 13E3 transaction, was either listed on a national securities exchange or authorized to be quoted in an interdealer quotation system of a registered national securities association, let's just call that listed or quoted for short. Such offered equity security is similarly either listed or quoted. The new CFI answers the question whether the G2 exception is available if the class of equity securities to be issued in the 13E3 transactions is not listed or quoted at the time the Rule 13E3 transaction is publicly announced, but both the registration of the class of equity securities under Section 12 of the Exchange Act and the approval of the class of equity securities for listing or quoting are express conditions to the closing of the transaction. There, the answer is yes, the G2 exception is available, provided that such conditions are disclosed and all other conditions of the G2 exception are satisfied. Again, out of time limits, will refer you to CFI 112.04 and 212.01 to read on your own time. Those also relate to 13E3G2. Lastly, we issued two new CFIs in the tender offer space, questions 101.22 and 163.02. 101.22 provides guidance as to whether Exchange Act Section 14D and Reg 14D or Rule 13E4 applies in the specific scenario where a parent company plans to commence a tender offer for Section 12 registered equity securities issued by its affiliate, and the parent company controls the affiliate through ownership of 60% of the affiliate's outstanding common stock. In such a case, Reg 14D applies to the parent company's tender offer. As the CFI explains, Section 14D applies to any tender offer for a class of equity securities registered under Section 12 that could result in the bidder beneficially owning more than 5% of the subject securities, except for tender offers by the, quote, issuer of such security. This exception is not available for any affiliates of the issuer other than a 100% owned sub of the issuer. Accordingly, the parent company's tender offer is subject to 14D and Reg 14D and exempt from 13E4. CFI 163.02, I will refer you to read it again on your own time. That relates to and basically highlights some pre-existing guidance in our mini tender offer release that was issued back in 2000. But I think now I'll just hand it back off so we can let my colleagues get some time to talk.
Thank you, Perry. We're getting pretty close to the end here, so just as with many other support offices, the Office of the Chief Counsel has been engaged in efforts to publish new CFIs and revise existing CFIs to provide helpful guidance to market participants. Here to talk about those efforts is Deputy Chief Counsel Jonathan Ingram.
Thank you, Gabe. It's nice to see everybody. After being down by 9 at half, Duke ended up beating Siena by 6, so a lot of brackets have been saved. And I'm in the unenviable position of being last because I'm the person that's standing between you and the happy hour. So there's a clock in front of me, and I'll make sure that I don't go over time. We recently have issued or revised several CFIs that relate to the use of Form S3. I'll start by reminding you that there are 2 times for testing your eligibility to use S3. 1, at the time of filing a new S3, and 2, for an already effective S3 at the time of your Section 10A3 update, which is almost always when you file your Form 10K. So with that in mind, today, by coincidence, we issued a CFI, Securities Act Form 126.26, that deals with at-the-market offerings. It addresses a question that we've received several times and for which there is a lot of commentary about because the answer has been unclear. It involves a situation where an issuer has an effective S3 for an at-the-market offering. At the time of filing, the issuer had a public float that exceeded 75 million, so the S3 was filed under General Instruction 1B1, and the company filed a prospectus supplement that was for an amount over 75 million. When the company filed its 10K, which I mentioned is a testing point for S3 eligibility, its public float was under 75 million, so it was no longer eligible to rely on General Instruction 1B1 and had to drop down to General Instruction 1B6, which has a 1/3 limitation. The question we received is whether the company can continue selling the entire amount of the ATM under its 424, or whether it is limited to the 1/3 amount in 1B6. The conclusion that we reached is that we will not object if the company continues to sell the entire amount, provided that, prior to the 10A3 update, the company entered into a sales agreement with a named selling agent for the ATM for an amount of securities that the company reasonably expected to offer and sell, and filed a prospectus supplement for the ATM. The next CFI I'd like to mention is revised CFI Securities Act Form 11405, which deals with S3 and Part 3 information. A bit of history here. Before we came out with securities offering reform in 2005, the staff's position was that a company could never go effective on an S3 if it had not filed its Part 3 information as part of its 10K. Then security offerings reform allowed for automatic effectiveness of S3s that were filed by certain types of issuers. As a result of some critical feedback that we received at the next SEC Speaks in 2006, we revised the CFI to state that an S3 ASR could be filed and go effective automatically even if the 10K did not have Part 3 information. Importantly, the caveat was that it was up to the issuer to determine whether the prospectus contained the information required by Section 10A and Schedule A. In March of last year, almost 20 years later, we further amended the CFI to provide that the non-automatically effective S3s would receive the same treatment. They similarly could go effective automatically without Part 3 information, subject to the same caveat I just mentioned. While I'm speaking of S3 eligibility, I'd like to mention a situation that we've been seeing with increasing frequency. Form 10K has an instruction that states that you don't have to file your Part 3 information as part of your 10K as long as you file your proxy statement within 120 days of your fiscal year end. The reason being is to prevent duplicity. You don't need to file the Part 3 information in both your 10K and your proxy statement. The instruction further provides that if you don't file your proxy statement in this time frame, then you need to file a 10K amendment that includes the Part 3 information on or before the 120th day. What we have been seeing is that companies are not filing that 10K amendment. And so what does that mean? It means that the original 10K was not timely filed because it did not have all the information required to be in the form. Again, as I mentioned at the beginning, you test S3 eligibility at the time of filing your S3 and at the time of your 10A3 update, which is when you file your 10K. So as a result, companies in this position will not be eligible to file new S3s, and if you have already effective S3s, they can't use them until their next 10A3 update. If you run into this situation, please call the Chief Counsel's office for guidance. The last S3 CFI I'll mention is revised CFI Securities Act Form 11705. The change was rather technical, but I think the substance goes well with what I've been discussing today. It deals with 33 Act registration statements that are filed shortly after the company's fiscal year end and before the company has had time to compile its Item 402 exec comp disclosure. So let's say you're a company that has a December 31, 2025 year end, and you want to file a 33 Act registration statement in January, February, or March of 2026. If you file an S1, the S1 needs to include the 402 disclosure for reasons that are in the instructions to the form. However, unlike S1, S3 does not have a specific line item requirement for 402 disclosure, and the information requirements of S3 are satisfied by forward and backwards incorporation by reference. Additionally, I just mentioned the CFI that allows for effectiveness of an S3 before the 10K is filed. So the bottom line is that an issuer can go effective on an S3 that doesn't include Item 402 disclosure, or for that matter, any Part 3 information, as long as the issuer is able to determine that the S3 contains the information required by Section 10A and Schedule A. I'm going to switch gears to Securities Act Rule 145, which deals with situations where 33 Act registration is required in connection with shareholders being asked to make an investment decision to accept a new security. The rule has several carve-outs, such as Rule 145A2, which says that registration is not required if the sole purpose of the transaction is to change the company's domicile. We were asked recently whether registration would be required if the purpose of the transaction was not just to change domicile, but also to form a new holding company. In revised CFI Securities Act Rules 13903, we took the view that registration would not be required. But importantly, we stated that the carve-out would not be available if, as a result of the transaction, the company's organizational structure, business operations, or regulatory regime would significantly change, other than changes resulting directly from differences in applicable state law. Examples of other situations where the carve-out would not be eligible include a change from a business trust or limited partnership to a corporation, a change from a C corporation to an S corporation or a public benefit corporation, and the formation of a bank holding company. So I see them running up on time. I'm going to have to pick between the last two that I have. Let's see. All right. We'll switch gears and talk about spinoffs. The last CFI I'll mention relates to exec comp disclosure and spinoffs. The CFI is Regulation SK 21704. It deals with the circumstances under which historical Item 402 disclosure is required for a spun-off registrant. In short, where a spun-off registrant consists of portions of different parts of the parent's business or has new management who will be named executive officers after the spin, 402 information for the named executive officers for the periods before the spin-off would not be required. On the other hand, if the parent spun off a subsidiary that conducted one of its line of businesses and before the spin before and after the spin, the executive officers of the subsidiary were the same, provided the same type of services to the subsidiary, and provided no services to the parent, historical 402 disclosure likely would be required. Time.
Breaking sports news. And I'd like to thank everybody for the time today. My fellow panelists, appreciate all your input, and thank you very much. Enjoy the rest of your evening.
We'll see you guys all back tomorrow at 9 a.m. There's cocktails and food. Be sure to grab your coats. And that's it. Have a great night. Thanks, guys.